take your respective seats. The judges who are unable to occupy their seats, we have also a small auditorium in the basement. They can have their seats in that small auditorium. Respected judges who have not taken their seats, they can take their seats in the auditorium and the ground floor, in the basement, sorry. Respected judges are requested to keep their mobile phones on silent mode, please. Respected judges, the dignitary is going to arrive shortly in 2 minutes. Kindly please take your seats. Respected judges, all the dignitaries have arrived in the VIP room. So I request all the judges to kindly take their seats, please. Respected judges, the dignitaries are arriving. I request everyone to kindly take their seats, please. Respected judges, our dignitaries are arriving shortly. I request everyone to kindly take their respective seats. Thank you. Respected judges are requested to keep their mobile phone on silent mode. Thank you. Respected judges, our dignitaries are arriving. I request honorable dignitaries to kindly adorn the dais, please. A very good morning to all. I, Swati Bajaj, Civil Judge, Senior Division Sonkach, District Devas, will be your host for the inaugural session. We are extremely overjoyed to have amidst us Honorable Chief Justice Sanjiv Khanna, Judge, Supreme Court of India, who has kindly consented to inaugurate the program. We also have the gracious presence of Honorable Chief Justice Aniruddha Bose, Judge, Supreme Court of India, and Honorable Shri Justice J.K. Maheshwari, Judge, Supreme Court of India, as our distinguished guests of honor. We also have amongst us our own Chief Justice, Honorable Shri Justice Ravi Malimath. Lighting of the lamp signifies ignition of thoughts of enlightenment, and it invites positivity, knowledge, and auspiciousness. As the lamp is lit, may its radiance touch each one of us, kindling the immortal flame of knowledge and understanding. To commence the program, I humbly request the esteemed dignitaries on the dais to kindly light the lamp. Thank you, Your Lordships. We need to seek blessings of the Almighty for the success of this 2 days conference. I now request Ms. Riya Dehria, Ms. Nandini Shukla, Ms. Arpita Shukla, Ms. Swapnil Verma, Ms. Shrishti Kushwaha, and Ms. Chitrangna Mandloi, all civil judges, Junior Division Bhopal, to kindly render the invocation song.
हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। तू स्वर की देवी है, संगीत तुझसे, हर शब्द तेरा है, हर गीत तुझसे। तू स्वर की देवी है, संगीत तुझसे, हर शब्द तेरा है, हर गीत तुझसे। हम हैं अकेले, हम हैं अधूरे, हम हैं अकेले, हम हैं अधूरे। तेरी शरण हम, हमें प्यार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। मुनियों ने समझी है, गुनियों ने जानी, वेदों की भाषा, पुराणों की वाणी। मुनियों ने समझी है, गुनियों ने जानी, वेदों की भाषा, पुराणों की वाणी। हम भी तो समझे, हम भी तो जाने, हम भी तो समझे, हम भी तो जाने। विद्या का हमको भी वरदान दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। तू श्वेत वर्णी कमल पे विराजे, हाथों में वीणा मुकुट सर पे साजे। तू श्वेत वर्णी कमल पे विराजे, हाथों में वीणा मुकुट सर पे साजे। मन से हमारे मिटा के अंधेरे, मन से हमारे मिटा के अंधेरे। हमको उजालों का संसार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। अज्ञानता से हमें तार दे माँ। अज्ञानता से हमें तार दे माँ। अज्ञानता से हमें तार दे माँ।
Thank you very much. I now request Shri Subodh Kumar Jain, President, Madhya Pradesh Nyayadhish Sangh, to kindly deliver the welcome speech.
माननीय न्यायाधिपति महोदय श्री संजीव खन्ना, न्यायाधीश सर्वोच्च न्यायालय, माननीय न्यायाधिपति महोदय श्री अनिरुद्ध बोस, न्यायाधीश सर्वोच्च न्यायालय, माननीय न्यायाधिपति महोदय श्री जे.के. माहेश्वरी, न्यायाधीश सर्वोच्च न्यायालय, माननीय न्यायाधिपति महोदय श्री रवि मलिमठ, मुख्य न्यायाधीश मध्य प्रदेश उच्च न्यायालय, कॉन्फ्रेंस में उपस्थित मध्य प्रदेश उच्च न्यायालय के माननीय न्यायमूर्तिगण और कॉन्फ्रेंस में भौतिक एवं आभासी रूप से शामिल जिला न्यायालयों के सभी न्यायिक अधिकारीगण, विशिष्ट अतिथिगण। मध्य प्रदेश न्यायपालिका का आज यह गौरवशाली दिवस है, जहां हम अपने बीच भारत के माननीय सर्वोच्च न्यायालय के माननीय न्यायाधिपतिगण को पाकर अत्यंत हर्षित, उल्लासित और गौरवान्वित महसूस कर रहे हैं। मध्य प्रदेश न्यायाधीश संघ दिनांक 27/8/1998 को अस्तित्व में आया। हमने पूर्व में 9 कॉन्फ्रेंस आयोजित की हैं। इस श्रृंखला की यह 10वीं कॉन्फ्रेंस है। इस कॉन्फ्रेंस को बहुत ही अलग तरीके से निरूपित किया गया है। यह पूर्व में आयोजित की गई कॉन्फ्रेंस से भिन्न है। इस कॉन्फ्रेंस में हम ऐसे प्रमुख मुद्दों पर चर्चा और विचार विमर्श करेंगे जो जिला न्यायपालिका को प्रभावित करते हैं। इस कॉन्फ्रेंस की थीम है आगे की ओर देखना है, लुकिंग अहेड। अपने कृत्यों के माध्यम से हम भविष्य की ओर देखने और उसकी इस तरह से योजना बनाने की आशा करते हैं कि वर्ष 2047 में हम स्वतंत्रता प्राप्त करने के 100 वर्ष पश्चात हमारे पास दिखाने के लिए सकारात्मक परिणाम हो। भारत के उच्चतम न्यायालय के माननीय न्यायाधिपति महोदय श्री संजीव खन्ना का स्वागत करना मेरे लिए गर्व की बात है, जिन्होंने कॉन्फ्रेंस का उद्घाटन करने के लिए सहर्ष सहमति व्यक्त की। माननीय न्यायाधिपति महोदय श्री संजीव खन्ना का जन्म 14 मई 1960 को हुआ था। माननीय न्यायाधिपति महोदय ने अपनी स्कूली शिक्षा वर्ष 1977 में दिल्ली के मॉडर्न स्कूल 12 खंबा रोड से पूरी की। वर्ष 1980 में सेंट स्टीफन्स कॉलेज दिल्ली विश्वविद्यालय से स्नातक की उपाधि प्राप्त करने के पश्चात उन्होंने दिल्ली विश्वविद्यालय के विधि संकाय के कैंपस लॉ सेंटर से विधि की उपाधि प्राप्त की। आप वर्ष 1983 में दिल्ली बार काउंसिल में एक अधिवक्ता के रूप में नामांकित हुए। प्रारंभ में आपने दिल्ली के 30 हजारी जिला न्यायालय और बाद में दिल्ली उच्च न्यायालय एवं न्यायाधिकरणों के समक्ष संवैधानिक विधि, प्रत्यक्ष कराधान, मध्यस्थता, वाणिज्यिक विधि, कंपनी विधि, भू विधि, पर्यावरण विधि एवं चिकित्सीय लापरवाही जैसे विविध क्षेत्रों में प्रैक्टिस की। आयकर विभाग के वरिष्ठ स्थायी अधिवक्ता के रूप में आपका कार्यकाल लंबा रहा है। वर्ष 2004 में आपको राष्ट्रीय राजधानी क्षेत्र दिल्ली के लिए स्थायी अधिवक्ता सिविल के रूप में नियुक्त किया गया। आपने अतिरिक्त लोक अभियोजक एवं न्याय मित्र के रूप में दिल्ली उच्च न्यायालय के समक्ष कई आपराधिक मामलों में उपस्थित होकर बहस की है। 24 जून 2005 को आपका उन्नयन दिल्ली उच्च न्यायालय के अतिरिक्त न्यायाधीश के रूप में किया गया और वर्ष 2006 में आपको स्थायी न्यायाधीश बनाया गया। दिल्ली उच्च न्यायालय के न्यायाधीश रहते हुए आपने दिल्ली न्यायिक अकादमी, अंतर्राष्ट्रीय मध्यस्थता केंद्र दिल्ली और जिला न्यायालय मध्यस्थता केंद्रों के अध्यक्ष और प्रभारी न्यायाधीश के पदों को सुशोभित किया है। 18 जनवरी 2019 को आपका उन्नयन भारत के उच्चतम न्यायालय के न्यायाधीश के रूप में किया गया। आपने 17 जून 2023 से 25 दिसंबर 2023 तक उच्चतम न्यायालय विधिक सेवा समिति के अध्यक्ष के पद को सुशोभित किया। वर्तमान में आप राष्ट्रीय विधिक सेवा प्राधिकरण के कार्यकारी अध्यक्ष एवं राष्ट्रीय न्यायिक अकादमी भोपाल की शासी परिषद के सदस्य हैं। हम आपके व्यस्त कार्यक्रम से अवगत हैं। इसके बावजूद आपने इस सम्मेलन के उद्घाटन के हमारे निमंत्रण को स्वीकार करने की कृपा की। हम वास्तव में आपके द्वारा हमारा निमंत्रण स्वीकार किए जाने के लिए अत्यंत आभारी हैं। मुझे यह कहने में कोई संकोच नहीं है कि राज्य के 1841 न्यायिक अधिकारीगण को आपके व्यापक अनुभव से लाभ प्राप्त होगा। हम आपके मार्गदर्शन और आशीर्वचन सुनने के लिए इच्छुक हैं। अब मैं हमारे विशिष्ट अतिथि भारत के उच्चतम न्यायालय के माननीय न्यायाधिपति महोदय श्री अनिरुद्ध बोस का स्वागत करना चाहूँगा। माननीय न्यायाधिपति महोदय श्री अनिरुद्ध बोस का जन्म 11 अप्रैल 1959 को हुआ। उन्होंने कलकत्ता के सेंट लॉरेंस हाई स्कूल से उच्चतर माध्यमिक परीक्षा उत्तीर्ण की। कोलकाता के सेंट जेवियर्स कॉलेज से वाणिज्य संकाय से स्नातक करने के पश्चात उन्होंने सुरेंद्र नाथ विधि महाविद्यालय से विधि स्नातक की उपाधि प्राप्त की। नामांकन के पश्चात आपने वर्ष 1985 में कलकत्ता उच्च न्यायालय में संवैधानिक, सिविल और बौद्धिक संपदा मामलों पर प्रैक्टिस शुरू की और आपने उच्च न्यायालय में प्रारंभिक एवं अपीलीय स्तर पर प्रैक्टिस की। जनवरी 2004 में आपका उन्नयन कलकत्ता उच्च न्यायालय के स्थायी न्यायाधीश के रूप में हुआ और दिनांक 11 अगस्त 2018 को आपका उन्नयन झारखंड उच्च न्यायालय के मुख्य न्यायाधीश के रूप में हुआ। 24 मई 2019 को आपका उन्नयन भारत के उच्चतम न्यायालय के न्यायाधीश के रूप में हुआ। आपने 29 मई से 1 जून 2023 तक सियोल, दक्षिण कोरिया में न्याय तक पहुंच संवैधानिक परिप्रेक्ष्य विषय पर एशियाई संवैधानिक न्यायालयों और समकक्ष संस्थानों के अनुसंधान और विकास सचिवालय AACC और SRD द्वारा आयोजित चौथी अंतर्राष्ट्रीय संगोष्ठी में भाग लिया और सत्र प्रथम की अध्यक्षता करते हुए संवैधानिक न्याय तथा व्यक्तिगत पहुंच पर अपना भाषण दिया और न्याय तक पहुंच सुनिश्चित करने वाले संवैधानिक अधिकार पर तृतीय सत्र की अध्यक्षता भी की। आपने विभिन्न सम्मेलनों में भाग लिया है और देश भर में विभिन्न समारोहों में भाषण दिए हैं। आपने दिनांक 23/9/2023 को नई दिल्ली में बार काउंसिल ऑफ इंडिया द्वारा आयोजित इंटरनेशनल लॉयर्स कॉन्फ्रेंस 2023 में मुख्य अतिथि के रूप में भाग लिया एवं अपने विचार व्यक्त किए। आपने विकासशील देशों में न्याय और कानूनी सहायता तक पहुंच पर दूसरे तकनीकी सत्र की सह अध्यक्षता की। आपने दिनांक 29/7/2023 को अगरतला में त्रिपुरा उच्च न्यायालय के तत्वाधान में त्रिपुरा न्यायिक अकादमी द्वारा क्रॉस बॉर्डर संगठित अपराध NDPS, मानव तस्करी, आतंकी फंडिंग आदि प्रभाव आकलन और कानूनी समाधान विषय पर आयोजित राज्य स्तरीय सेमिनार में मुख्य अतिथि के रूप में भाग लिया और सारगर्भित विषयों पर संबोधन दिया। आपके व्यस्त कार्यक्रम के बावजूद आपने इस अवसर पर विशिष्ट अतिथि के रूप में शामिल होने के लिए हमारे निमंत्रण को स्वीकार करने की कृपा की है। हम आपके अत्यंत आभारी हैं। अब मैं भारत के उच्चतम न्यायालय के माननीय न्यायमूर्ति महोदय श्री JK माहेश्वरी का स्वागत करना चाहूँगा। माननीय न्यायाधिपति महोदय श्री JK माहेश्वरी का जन्म 23 जून 1961 को मुरैना मध्य प्रदेश के एक छोटे से कस्बे जौरा में हुआ था। आपने 1982 में कला संकाय में स्नातक, 1985 में विधि स्नातक की उपाधि प्राप्त की एवं 1991 में विधि परा स्नातक किया। आप 22 नवंबर 1985 को मध्य प्रदेश राज्य अधिवक्ता परिषद में अधिवक्ता के रूप में नामांकित हुए। आपने सिविल, आपराधिक, संवैधानिक, सेवा और कर मामलों में प्रैक्टिस की। आप मध्य प्रदेश राज्य विधिज्ञ परिषद के सदस्य के रूप में निर्वाचित हुए। आप 25 नवंबर 2005 को मध्य प्रदेश उच्च न्यायालय के अतिरिक्त न्यायाधीश के रूप में नियुक्त हुए और 25 नवंबर 2008 को माननीय न्यायालय के स्थायी न्यायाधीश के रूप में नियुक्त हुए। आप मध्य प्रदेश के उच्च न्यायालय के प्रशासनिक सुधार से संबंधित विभिन्न समितियों में शामिल रहे और आपने 6 अक्टूबर 2019 तक इन पदों को सुशोभित किया। आपका स्थानांतरण आंध्र प्रदेश उच्च न्यायालय के मुख्य न्यायाधीश के रूप में किया गया और आपने 7 अक्टूबर 2019 को पदभार ग्रहण किया। आप नव स्थापित आंध्र प्रदेश उच्च न्यायालय के पहले मुख्य न्यायाधीश थे। आपका स्थानांतरण 6 जनवरी 2021 को सिक्किम उच्च न्यायालय के मुख्य न्यायाधीश के पद पर किया गया। आपने 31 अगस्त 2021 को भारत के उच्चतम न्यायालय के न्यायाधीश के रूप में शपथ ग्रहण की। आपके व्यस्त कार्यक्रम के बावजूद आपने इस अवसर पर विशिष्ट अतिथि के रूप में शामिल होने का हमारा निमंत्रण स्वीकार कर इस समारोह की शोभा बढ़ाई है, जिसके लिए हम आपके अत्यंत आभारी हैं। आप इस प्रतिष्ठित मध्य प्रदेश उच्च न्यायालय के न्यायाधीश रहे, तब आपका बहुत बड़ा योगदान रहा। आपने सदैव हमारा मार्गदर्शन किया, जो आज भी हमारे दिन प्रतिदिन के कार्यों में बहुत मददगार साबित हो रहा है, जिसके लिए हम आपका आभार व्यक्त करते हैं। मैं मध्य प्रदेश उच्च न्यायालय के मुख्य न्यायाधिपति महोदय माननीय न्यायमूर्ति श्री रवि मलिमठ का भी स्वागत करता हूं। दिनांक 14/10/2021 को माननीय महोदय द्वारा मध्य प्रदेश उच्च न्यायालय में मुख्य न्यायाधिपति के रूप में कार्यभार ग्रहण करने की तिथि से ही माननीय महोदय का प्रत्येक दिन मध्य प्रदेश न्यायपालिका की उन्नति में व्यतीत हुआ है। दिनांक 20/10/2021 को प्रथम दिवस के उपवेशन के पूर्व ही माननीय महोदय द्वारा एक ज्ञापन जारी कर प्रत्येक न्यायालयों में विचाराधीन 25 प्राचीनतम मामलों की सूची आहूत की गई थी। तत्पश्चात उक्त मामलों के निराकरण हेतु निर्देश जारी किए गए थे। न्याय वितरण प्रणाली की उत्कृष्टता के प्रयोजन से बृहद सुधार किए गए हैं। यद्यपि समय का अभाव है, तथापि मैं उपर्युक्त में से कतिपय अति उत्तम योजनाओं का उल्लेख करना चाहूँगा, जिन्होंने जिला न्यायपालिका का सकारात्मक रूपांतरण करने में महती भूमिका का निर्वाह किया है। प्रथम एवं सबसे महत्वपूर्ण माननीय महोदय द्वारा माह अक्टूबर 2021 में प्रारंभ की गई 25 डेट योजना नामक अद्वितीय योजना है। आप सभी योजना के विवरण से भली भांति परिचित हैं और मेरे द्वारा इसकी पुनरावृत्ति करने की आवश्यकता नहीं है। यह योजना अब 2 वर्षों से अधिक अवधि से प्रवर्तन में है और हमने विलक्षण सफलता अर्जित की है। मध्य प्रदेश उच्च न्यायालय एकमात्र उच्च न्यायालय है जिसने विचाराधीन प्राचीनतम मामलों से निपटने के लिए एक योजना विकसित की है। यह एक ऐसी नियमित योजना नहीं है जिससे सतत निर्देश और ज्ञापन जारी किए जाने पर भी कोई वांछित परिणाम सामने नहीं आ रहे थे। यह एक सुविचारित, योजनाबद्ध और वैज्ञानिक योजना है, यहाँ तक कि बार के सदस्य भी इस योजना को अंगीकृत कर न्यायाधीशों के साथ पूरा सहयोग कर रहे हैं। उक्त योजना का परिणाम उल्लेखनीय होकर दृष्टिपात योग्य है। यहाँ यह रेखांकित किया जाना अपरिहार्य है कि 56 न्यायिक अधिकारीगण ने अब तक के समस्त 8 चरणों की प्रत्येक तिमाही के उक्त 25 मामलों के निराकरण में 100% लक्ष्य अर्जित किया है। यह न केवल योजना की सफलता को दर्शाता है बल्कि समस्त न्यायिक अधिकारीगण की भागीदारी का भी द्योतक है। इस योजना ने मध्य प्रदेश की अदालतों में जनता के विश्वास को सुदृढ़ किया है। 25 डेट योजना के अंतर्गत मामलों के सम्यक निराकरण के अनुक्रम में न्यायिक अधिकारीगण की सम्मान और गरिमा परिवर्तित हुई है। प्रत्येक पक्षकार इतना प्रसन्नचित्त है कि उसके पुराने मामलों का सम्यक निराकरण किया जा रहा है। मैं अभिभूत हूँ कि मध्य प्रदेश की न्यायपालिका का गौरव पुनर्स्थापित हुआ है। वर्तमान में भी यह मुहिम जारी है और मैं अपने एक अनुभव के आधार पर इस अत्यंत महत्वपूर्ण योजना की सफलता को रेखांकित करना चाहता हूं। पूर्व में जब मैं प्रधान जिला एवं सत्र न्यायाधीश के पद पर इंदौर में पदस्थ था, तब एक दिन मेरे न्यायालय में एक बुजुर्ग व्यक्ति आए और उनके हाथ में एक आवेदन था और उन्होंने मुझसे अत्यंत विनम्र भाव से निवेदन किया कि उनके प्रकरण को भी 25 प्रकरणों की सूची में शामिल कर लिया जाए। हालांकि उन महोदय का प्रकरण बहुत अधिक प्राचीन नहीं था और ना ही 25 पुराने प्रकरणों की सूची में था। उन्हें शीघ्र निराकरण का आश्वासन तो दिया गया, लेकिन यह महसूस हुआ कि इस योजना ने सामान्य पक्षकारों के मन में यह भावना बिठा दी है कि यदि उनका प्रकरण 25 पुराने प्रकरणों की सूची में आएगा तो उसका शीघ्र निराकरण अनिवार्यतः होगा। वास्तव में इस प्रकृति के घटनाक्रमों से जिला न्यायपालिका के सदस्यों को यह सोचने पर विवश किया कि इस प्रकार की योजना के माध्यम से प्रकरणों के शीघ्र निराकरण से सामान्य जनमानस के न्यायपालिका के प्रति शीघ्र न्याय प्राप्त करने की भावना प्रबल हुई है। यहाँ यह उल्लेख करना भी जरूरी होगा कि तमाम समस्याओं, विषमताओं और अनेक प्रकार की परेशानियों के बावजूद भी मध्य प्रदेश जिला न्यायपालिका के न्यायाधीशगण इस लक्ष्य को लगभग पूरा करने में इसलिए भी सफल हुए हैं क्योंकि हमें महसूस होता है कि इस लक्ष्य प्राप्ति के लिए किए जा रहे प्रयासों में माननीय उच्च न्यायालय के द्वारा हमें विभिन्न प्रकार के संरक्षण भी प्रदान किए गए हैं। तभी न्यायाधीशगण उक्त लक्ष्य की प्राप्ति में अपने जी जान से जुटे हुए हैं। अतः माननीय मुख्य न्यायाधिपति महोदय की डेट स्कीम की इस योजना ने मध्य प्रदेश की न्यायालयों के पुराने प्रकरणों की संख्या को कम करने में एक महत्वपूर्ण सफलता प्रदान की है और मैं मध्य प्रदेश न्यायाधीश संघ का अध्यक्ष एवं जिला न्यायालय के सभी सदस्यों का प्रतिनिधि होने के नाते माननीय मुख्य न्यायाधिपति महोदय को विश्वास दिलाता हूं कि इस जन कल्याणकारी जनमानस के मन में शीघ्र न्याय की अवधारणा को पूरा करने में सभी न्यायाधीश अपनी ओर से संपूर्ण प्रयास करेंगे। न्यायाधीशों के सम्मान को भी दृष्टिगत रखते हुए माननीय मुख्य न्यायाधिपति महोदय श्री रवि मलिमठ साहब द्वारा सुधार के महत्वपूर्ण प्रयास किए गए हैं। माननीय मुख्य न्यायाधिपति महोदय का दृढ़ विश्वास है कि किसी भी न्यायालय में पदस्थ न्यायाधीश अंततः न्यायाधीश ही होता है और कोई भी न्यायाधीश किसी अन्य से निम्न या अधीनस्थ नहीं हो सकता है। अधीनस्थ शब्द का प्रयोग केवल न्यायालय के पदानुक्रम को दर्शाने के लिए किया जाता है। इसलिए जिला न्यायपालिका को संबोधित करने के लिए अधीनस्थ शब्द का प्रयोग करना ब्रिटिश सामंतवादी मानसिकता का घोतक होकर पूर्णतः असंवैधानिक है। माननीय मुख्य न्यायाधिपति महोदय के इन पवित्र प्रयासों को मध्य प्रदेश उच्च न्यायालय द्वारा सर्वसम्मति से स्वीकार कर दिनांक 16/12/2022 से मध्य प्रदेश राज्य में उच्च न्यायालय को छोड़कर सभी न्यायालयों को अधीनस्थ न्यायपालिका के स्थान पर जिला न्यायपालिका एवं उसकी सभी अदालतों को विचारण न्यायालय से संबोधित करना निर्धारित किया गया है। इस संबंध में माननीय मुख्य न्यायाधिपति महोदय द्वारा पहली बार हिमाचल प्रदेश उच्च न्यायालय के कार्यवाहक मुख्य न्यायाधिपति के पद पर आसीन होते हुए सर्वप्रथम प्रयास किया गया। दूसरी बार मध्य प्रदेश उच्च न्यायालय के मुख्य न्यायाधिपति के रूप में कार्यभार ग्रहण करते हुए उक्त प्रस्ताव पेश कर मध्य प्रदेश के न्यायालयों में भी प्रभावशील कर दिया गया। उक्त स्थापित उदाहरण के बाद इलाहाबाद उच्च न्यायालय ने भी इस प्रस्ताव को अपनाया है। इसी कड़ी में अन्य महत्वपूर्ण कार्य अनुकंपा नियुक्ति योजना का भी उल्लेख किया जाना आवश्यक है। पूर्व में मृतक कर्मचारी किसी भी पद पर कार्यरत रहा हो, उसके आश्रितों को अनुकंपा नियुक्ति चतुर्थ श्रेणी के पद पर ही दी जाती थी, भले ही उक्त आश्रित की योग्यता व प्रतिभा कितनी भी हो। माननीय मुख्य न्यायाधिपति महोदय द्वारा योग्यताधारी एवं प्रतिभाशाली आश्रितों के संबंध में मापदंड निर्धारित किए गए। उक्त मापदंड पूर्ति पर आश्रित की योग्यता व प्रतिभा अनुसार तृतीय श्रेणी के पद पर ही नियुक्ति के नियम प्रभावशील किए गए, जिसका लाभ 41 योग्य आश्रित को अनुकंपा नियुक्ति में तृतीय श्रेणी के पद पर प्राप्त हुआ है। यह भी महत्वपूर्ण है कि पूर्व में अनुकंपा नियुक्ति कार्रवाई में 2 वर्ष का समय लगता था। माननीय मुख्य न्यायाधिपति महोदय की पहल पर उक्त कार्रवाई कुछ माह में ही करते हुए आश्रितों को शीघ्र अतिशीघ्र अनुकंपा नियुक्ति की जा रही है, जिससे लगभग 150 व्यक्ति लाभान्वित हुए हैं। मध्य प्रदेश न्यायिक प्रशासन में कर्मचारियों के पदों की रिक्तियां, तृतीय व चतुर्थ श्रेणी कर्मचारियों की कमी, न्यायिक अधिकारियों की भर्ती परीक्षा, निर्धारित कालक्रम से पीछे चलना महत्वपूर्ण समस्या थी। उक्त समस्या का निराकरण करते हुए कर्मचारियों के 1700 रिक्त पदों में से 1692 पदों की चयन प्रक्रिया पूरी कर पदस्थापना करने की त्वरित कार्रवाई की गई, जो मध्य प्रदेश के इतिहास में एक नया अध्याय है। विगत 2 वर्षों में मध्य प्रदेश उच्च न्यायालय में 77 तृतीय श्रेणी कर्मचारी, जिला न्यायालय में 898 तृतीय और 794 चतुर्थ श्रेणी कर्मचारियों की नियुक्ति करना, न्यायिक अधिकारियों के रूप में 284 व्यवहार न्यायाधीश और 2 जिला न्यायाधीशों की नियुक्ति करना, 169 न्यायिक अधिकारियों को पदोन्नति एवं उक्त दशा में निरंतर कार्य किया जाना न्यायिक प्रशासन के सुचारू एवं व्यवस्थित संचालन में महत्वपूर्ण सहायता प्रदान की है। आधारभूत संरचना की कमी, जिसमें न्यायालय परिसर को तथा न्यायिक अधिकारियों को किराए के मकान में निवास करना एक बहुत पुरानी समस्या थी। माननीय मुख्य न्यायाधिपति महोदय के पद ग्रहण करने के पश्चात आधारभूत संरचनाओं का कार्य त्वरित गति से आगे बढ़ा एवं उन्हें अविलंब पूर्ण करने हेतु निर्देश जारी किए गए, जिसके परिणाम स्वरूप वर्तमान में कोई भी न्यायालय किराए के परिसर में संचालित नहीं हो रहा है। मध्य प्रदेश के विभिन्न नवीन न्यायालयों के निर्माण के संबंध में भी माननीय मुख्य न्यायाधिपति महोदय के नेतृत्व में 7 नवीन न्यायालय परिसरों के 76 न्यायालयीन कक्षों को अतिरिक्त न्यायिक अधिकारियों हेतु 69 आवासीय परिसर का निर्माण चरणबद्ध रूप से किया गया। इंदौर, ग्वालियर और रीवा बृहद न्यायालयों का कार्य पूर्णता की ओर है। न्यायालय भवन और न्यायाधीशों के आवास के लिए भी विभिन्न स्थानों पर किए जा रहे निर्माण से अब एक ऐसी उम्मीद बन पड़ी है कि शीघ्र ही मध्य प्रदेश न्यायपालिका का एक सुविधाजनक और गरिमामय स्थान होगा, जहां अपने न्यायिक कार्य को हम संपादित कर सकेंगे। माननीय मुख्य न्यायाधिपति महोदय के नेतृत्व में मध्य प्रदेश जिला न्यायपालिका में प्रवेश लेने वाले प्रत्येक न्यायाधीश, चाहे वे सिविल जज जूनियर डिवीज़न हो अथवा जिला न्यायाधीश के प्रवेश स्तर का अधिकारी हो, उसके लिए गरिमामय ओरिएंटेशन प्रोग्राम माननीय उच्च न्यायालय में आयोजित किया गया। सभी नवागंतुक न्यायाधीशों को माननीय मुख्य न्यायाधिपति महोदय के द्वारा शपथ दिलाए जाने की जो नई शुरुआत की गई है, उससे न्यायपालिका में प्रवेश कर रहे न्यायाधीशों के मन में अपनी मातृ संस्था के प्रति एक सकारात्मक समर्पण और अपनत्व की भावना निर्मित हुई। उन्हें महसूस हुआ कि वह जिस संस्था में अपनी सेवाएं देने के लिए उपस्थित हुए हैं, उस संस्था ने हमें अपने परिजनों के साथ उपस्थित होकर माननीय मुख्य न्यायाधिपति महोदय के सामने एक गरिमामय शपथ समारोह, एक अद्भुत और आनंददायक वातावरण में कार्य करने का अवसर प्रदान किया है। यहाँ यह भी उल्लेखनीय होगा कि इस संबंध में मध्य प्रदेश जुडिशियल सर्विस में आवश्यक संशोधन भी किए गए ताकि यह परंपरा निरंतर जारी रखी जा सके। मैं मध्य प्रदेश जिला न्यायपालिका में शामिल हुए सभी नवागत सिविल जज जूनियर डिवीजन एवं जिला न्यायाधीशों की ओर से माननीय मुख्य न्यायाधिपति महोदय के प्रति इस नई योजना के लिए कृतज्ञता ज्ञापित करता हूँ। माननीय मुख्य न्यायाधिपति महोदय, मध्य प्रदेश जिला न्यायपालिका आपके उस कदम के लिए हमेशा आभारी रहेगी जब आपने जिला न्यायपालिका के वर्ष 2021 और 22 में दिवंगत हुए न्यायाधीशों के सम्मान के लिए एक रेफरेंस का आयोजन किया, जिससे पूरे मध्य प्रदेश के न्यायाधीश ऑनलाइन जुड़े और आपके नेतृत्व में ऐसे दिवंगत न्यायाधीशों को श्रद्धांजलि दी गई, जिससे उन दिवंगत न्यायाधीशों के परिजनों के मन में इस संस्था के प्रति आदर व सम्मान का भाव बढ़ा और उन्हें एहसास हुआ कि उनके परिजनों ने जिस न्यायिक सेवा में कार्य किया वह संस्था आज भी उन्हें याद करती है। इसी परंपरा को माननीय मुख्य न्यायाधिपति महोदय द्वारा निरंतर जारी रखते हुए दिनांक 4/1/2024 को भी वर्ष 2023 में दिवंगत न्यायाधीश गणों के सम्मान में फुल कोर्ट रेफरेंस का आयोजन किया, जिसमें उच्च न्यायालय के सभी न्यायमूर्ति गण, जिला न्यायालय के सभी न्यायाधीश गण एवं अधिवक्ता गणों को भी शामिल किया गया। माननीय महोदय, वर्तमान समय में महिला सशक्तिकरण के बारे में काफ़ी कुछ कहा जा रहा है। माननीय मुख्य न्यायाधिपति महोदय भी महिला न्यायाधीशों की संख्या को लेकर कई बार अपना गंभीर चिंतन देश के सामने रख चुके हैं। मुझे यह बताते हुए हर्ष हो रहा है कि मध्य प्रदेश न्यायपालिका के सुपर टाइम स्केल के 60 जजेज में से 6 महिला जजेज हैं। सिलेक्शन ग्रेड स्तर पर 102 जजेज में से 19 महिला जजेज हैं। जिला न्यायाधीश एंट्री लेवल के कुल 536 जजेज में से 87 महिला जजेज हैं और सिविल जज सीनियर डिवीजन न्यायाधीशों के कुल 453 पदों में से 117 महिला जजेज हैं। इसी प्रकार सिविल जज जूनियर डिवीजन के कुल 570 में से 329 महिला न्यायाधीश हैं। अगर हम प्रतिशत की बात करें तो मध्य प्रदेश जिला न्यायपालिका में कुल 1843 में से 700 महिला न्यायाधीश हैं, जो कि कुल संख्या का 37.06% होता है। अतः मध्य प्रदेश की जिला न्यायपालिका महिला सशक्तिकरण की कसौटी पर खरी उतरती है, जो कि मध्य प्रदेश न्यायपालिका के लिए एक गौरव का विषय है। मध्य प्रदेश उच्च न्यायालय सूचना प्रौद्योगिकी के उपयोग में अग्रणी है। माननीय मुख्य न्यायाधिपति महोदय द्वारा जिस प्रकार पेपरलेस कोर्ट, ऑनलाइन हियरिंग की कल्पनाएं की गई हैं और उक्त कल्पनाओं को प्रयास कर मूर्त रूप दिया गया है, वह प्रशंसनीय है। मध्य प्रदेश उच्च न्यायालय अथक रूप से सूचना प्रौद्योगिकी के माध्यम से आम जन की सुविधाओं के लिए कार्य कर रहा है। मध्य प्रदेश उच्च न्यायालय लाइव स्ट्रीमिंग प्रणाली लागू करने वाला अग्रणी उच्च न्यायालय है। देश का पहला ऐसा उच्च न्यायालय है जो अत्यंत महत्वाकांक्षी प्रोजेक्ट कोर्ट रूम लाइव ऑडियो वीडियो विजुअल स्ट्रीमिंग सिस्टम एवं इंटीग्रेटेड वीडियो सर्विलांस सिस्टम को सभी जिला एवं तहसील न्यायालयों में स्वयं के OTT प्लेटफॉर्म पर शीघ्र लागू करने वाला है, जो सभी हितधारकों में पारदर्शिता और जवाबदेही सुनिश्चित करते हुए सतत रूप से न्यायिक ज्ञान एवं योग्यता को विस्तारित करेगा। इस कड़ी में न्यायालयीन अभिलेखों के डिजिटाइजेशन के लक्ष्य को प्राप्त किए जाने का उल्लेख आवश्यक है। डिजिटाइजेशन का कार्य न्यायालयों को पेपरलेस करने हेतु तेज गति से चल रहा है। देश में सबसे अधिक न्यायिक अभिलेखों के पन्नों का डिजिटाइजेशन मध्य प्रदेश में किया गया है, जिसमें प्रतिदिन लगभग 30,000 पन्ने डिजिटाइज किए गए हैं। दिनांक 30/9/2023 तक 19 करोड़ 78 लाख पन्नों का डिजिटाइजेशन किया जा चुका है। विभिन्न जिला न्यायालयों में 44 करोड़ 64 लाख पन्नों का डिजिटाइजेशन किया जा चुका है। कुल मिलाकर 64 करोड़ 42 लाख पन्नों का डिजिटाइजेशन किया जा चुका है, जो कि देश में सर्वाधिक है। डिजिटाइजेशन के साथ साथ सूचना प्रौद्योगिकी का उपयोग ई कॉपिंग सॉफ्टवेयर के माध्यम से सभी सिविल तहसील न्यायालयों में लागू किया गया तथा ERTI पोर्टल के माध्यम से सूचना के अधिकार द्वारा पारदर्शिता को आम जन के हाथ में इलेक्ट्रॉनिक रूप से उपलब्ध कराया गया है। ई कॉपिंग सॉफ्टवेयर जहां किसी भी व्यक्ति को न्यायालय के किसी भी निर्णय या आदेश की प्रतिलिपि कुछ क्लिक अथवा निश्चित शुल्क उपरांत प्राप्त कराता है, वहीं ERTI सॉफ्टवेयर सूचना के अधिकार के अंतर्गत आमजन द्वारा मांगी गई सूचना को मामूली शुल्क के भुगतान पर प्राप्ति का रास्ता सुलभ बनाता है। सूचना प्रौद्योगिकी का न्याय प्रशासन में प्रयोग आमजन को न्याय एवं पारदर्शिता को सुलभ उपलब्ध कराने की दिशा में महत्वपूर्ण कदम है। आमजन में न्याय को सुलभ और सरल बनाने हेतु अधिवक्ताओं की महत्वपूर्ण भूमिका होती है। देश के साथ निरंतर प्रगति करती हुई कानूनी व्यवस्था में विधिक ज्ञान में कुशलता एवं पारंगतता हेतु अधिवक्तागण एवं पक्षकारगण को विधि के नवीन परिवर्तन व न्याय दृष्टांतों से अवगत कराने हेतु उच्च न्यायालय के निर्णयों को प्रति माह इंडियन लॉ रिपोर्टर में प्रकाशित किया जाता रहा है। माननीय मुख्य न्यायाधिपति महोदय द्वारा शपथ उपरांत पाया गया कि मध्य प्रदेश संस्करण का प्रकाशन 6 माह विलंब से हो रहा है। ILR मध्य प्रदेश संस्करण का प्रकाशन प्रति माह प्रथम सप्ताह में अवश्य हो जाए, यह सुनिश्चित करने हेतु दिशा निर्देश जारी किए गए। उक्त कठिन कार्य माननीय मुख्य न्यायाधिपति महोदय के भागीरथी प्रयासों से संभव हुआ और फरवरी 2023 से ILR का प्रकाशन नियमित हो गया है। पत्रिका की डिजाइन, लेआउट व उपयोग में लाए जाने वाले कागज में परिवर्तन किया गया, परंतु गुणवत्ता को प्रभावित किए बिना अधिवक्तागण की आर्थिक स्थिति को ध्यान में रखते हुए प्रत्येक अंक का मूल्य सिर्फ 100 रुपये निर्धारित किया गया। मुझे यह बताते हुए अत्यंत हर्ष की अनुभूति हो रही है कि माननीय मुख्य न्यायाधिपति महोदय के मार्गदर्शन में ILR की 5 ईयर एवं 2 ईयर डाइजेस्ट प्रकाशित की गई है तथा इस श्रृंखला को आगे बढ़ाते हुए प्रथम बार 1 ईयर डाइजेस्ट का भी प्रकाशन 11/1/24 को कर दिया गया है। उक्त परीक्षाओं हेतु सामाजिक रूप से पिछड़े एवं आरक्षित वर्ग के अभ्यर्थियों के सामाजिक संतुलन को ध्यान में रखते हुए अनुसूचित जाति, जनजाति, अन्य आरक्षित वर्ग के अभ्यर्थियों के प्रोत्साहन हेतु माननीय मुख्य न्यायाधिपति महोदय द्वारा विशेष परिकल्पना की गई है, जिसमें इन वर्ग के अधिवक्ताओं को प्रतियोगी परीक्षा हेतु मार्गदर्शन प्रदान करने के पवित्र भाव से क्षमता निर्माण प्रशिक्षण कार्यक्रम प्रारंभ किया गया है, जिसमें उच्च न्यायालय के सेवानिवृत्त न्यायाधीशगण के अतिरिक्त न्यायिक अधिकारीगण, विधिवेत्ता व संकाय सदस्यों द्वारा प्रति गुरुवार, शुक्रवार व शनिवार को शाम 6 बजे से ऑनलाइन प्रशिक्षण दिया जा रहा है। माननीय मुख्य न्यायाधिपति महोदय का अनूठा प्रयास निश्चित रूप से प्रतियोगी परीक्षाओं की तैयारी करने वाले ऐसे 384 योग्य अधिवक्ताओं के लिए वरदान साबित होगा, जो धन, आवश्यक सुविधा और अन्य अभाव के कारण परीक्षा में सम्मिलित होने में असमर्थ थे। शीघ्र ही सिविल जज जूनियर डिवीजन की परीक्षा की तैयारी कर रहे वंचित वर्ग के योग्य अधिवक्ताओं के लिए भी इस तरह का कार्यक्रम शुरू किया जा रहा है। मुझे यह बताते हुए हर्ष हो रहा है कि हमारे संवेदनशील माननीय मुख्य न्यायाधिपति महोदय द्वारा मध्य प्रदेश के सबसे बड़े शहर इंदौर में एम्बा अस्पताल, जो कि उस क्षेत्र का सबसे बड़ा अस्पताल है, मेडिकल कॉलेज है, जहां एक दिन में कई चिकित्सकों की साक्ष्य लेखबद्ध होती है, उस चिकित्सालय में चिकित्सकों की सुविधा हेतु BC पॉइंट की स्वीकृति दी और स्वयं उपस्थित होकर BC पॉइंट का उद्घाटन किया, जिससे अब बहुत बड़ी संख्या में चिकित्सक मरीज की चिकित्सा करते हुए भारत के विभिन्न न्यायालयों में अपनी साक्ष्य आसानी से दे पा रहे हैं। न्यायिक क्षेत्र से अलग हटकर मानवीय संवेदनाओं को बल देते हुए अभी हाल ही में एम्बा अस्पताल इंदौर में कृत्रिम अंगों के निर्माण केंद्र का भी माननीय मुख्य न्यायाधिपति महोदय द्वारा उद्घाटन किया गया, जिससे बेबस, लाचार और आर्थिक रूप से कमज़ोर ऐसे दिव्यांग व्यक्ति जो चिकित्सा के लिए अन्यत्र नहीं जा सकते हैं, उन्हें कृत्रिम अंगों का लाभ एकमात्र स्थान पर आसानी से उपलब्ध होने लगा है। ऐसे संवेदनशील और मानवीय पहलू को ध्यान में रखने वाले माननीय मुख्य न्यायाधिपति महोदय के द्वारा किए गए कार्य और उनके लक्ष्यों को मध्य प्रदेश न्यायाधीश संघ के सदस्य अपनी कड़ी मेहनत और लगनशीलता से पूरा करने के लिए प्रयासरत हैं। मुझे पूर्ण विश्वास है कि मध्य प्रदेश न्यायाधीश संघ के सदस्य के अथक प्रयास से वर्ष 2047 आज़ादी के 100 वर्ष पूरे होने पर किसी भी न्यायालय में 1 वर्ष से पुराना कोई प्रकरण शेष नहीं रहेगा। उक्त दिशा में मध्य प्रदेश न्यायाधीश संघ के सदस्यों के प्रयास निरंतर जारी हैं। न्यायाधीश संघ ने भी अपने सदस्यों के हितार्थ कुछ उल्लेखनीय कार्य करने का प्रयास किया है। माननीय सर्वोच्च न्यायालय और हिंदुस्तान के समस्त उच्च न्यायालयों के अद्यतन निर्णय उन्हें मोबाइल पर ही प्राप्त हो सकें, इस हेतु लाइव ला ऐप का 2 वर्षीय सब्सक्रिप्शन संघ के प्रत्येक सदस्य को प्रदान कराया गया है। उल्लेखनीय यह है कि लाइव ला का सब्सक्रिप्शन संघ के प्रत्येक सदस्य को 900 रुपये वार्षिक के हिसाब से 2 वर्ष के लिए 1800 रुपये के स्थान पर मात्र 42 रुपये 50 पैसे की दर से प्रत्येक सदस्य को प्रदान कराया गया है। इसी अनुक्रम में हमने सेवानिवृत्त होने वाले न्यायाधीशों के उल्लेखनीय कार्यों को रेखांकित करने और उन्हें गरिमा और सम्मान के साथ उनके न्यायिक कार्यों और संस्थाओं को दी गई उनकी सेवाओं को सम्मानित करने हेतु उनकी सेवानिवृत्ति पर संघ की ओर से सम्मानित करने की योजना बनाई और जुलाई 2022 से अभी तक न्यायाधीशों का सम्मान कर संघ का स्मृति चिन्ह भेंट कर गरिमापूर्ण विदाई की गई है। माननीय मुख्य न्यायाधिपति महोदय द्वारा अनेक प्रगतिशील योजनाओं को प्रारंभ किया गया। उक्त योजनाओं में से प्रत्येक योजना की महत्ता से अवगत कराने के संबंध में समय का अभाव है। मुझे विश्वास है प्रत्येक न्यायिक अधिकारी को यह भली भांति ज्ञात है कि विगत 2 वर्षों में मध्य प्रदेश न्यायपालिका में सकारात्मक रूप से क्या घटित हुआ है। माननीय मुख्य न्यायाधिपति महोदय द्वारा उठाए गए उक्त विशाल पद ध्वनि के परिणाम स्वरूप समस्त जिला न्यायपालिका में सारभूत परिवर्तन हुआ है। मैं ऐसा माननीय मुख्य न्यायाधिपति महोदय द्वारा प्रारंभ की गई विभिन्न योजनाओं के कारण नहीं, अपितु प्रत्येक न्यायिक अधिकारी के मनोबल, आत्मविश्वास, आत्मसम्मान में हुई कई गुना अभिवृद्धि के कारण कह रहा हूं। ऐसी योजनाओं के परिणाम स्वरूप एक न्यायिक अधिकारी की गरिमा शिष्टता के उच्च स्तर तक पहुंच गई है। न्यायाधीशगण के प्रति सम्मान पूर्व की भांति अपेक्षा अभिवृद्ध हुआ है। प्राचीनतम प्रकरणों के निराकरण के फलस्वरूप अधिवक्तागण द्वारा न्यायाधीशगणों के प्रयासों की सराहना की गई है। हम यह महसूस कर रहे हैं कि मध्य प्रदेश न्यायपालिका के न्यायाधीश के रूप में हम समाज के लिए कुछ करने में समर्थ रहे हैं। हम एक न्यायाधीश होने के मूल्य और उसके महत्व को महसूस कर पा रहे हैं। प्रत्येक न्यायिक अधिकारी का मनोबल अभिवृद्ध हुआ है। हम पूर्व की अपेक्षा अब अधिक आत्मविश्वास से भरे हुए न्यायाधीश हैं। हम पूर्व की तुलना में कहीं अधिक प्रभावी एवं अधिक तीव्र गति से निर्णय देने में सक्षम हुए हैं। माननीय मुख्य न्यायाधिपति महोदय द्वारा हमें मध्य प्रदेश न्यायपालिका का भाग होने पर गौरवान्वित होने का अवसर दिया है। उन्होंने हमें यह महसूस कराया कि हम एक ही कुटुंब के सदस्य हैं। आपने हमारे लिए जो भी किया है उसके लिए हम माननीय महोदय को हृदय तल से धन्यवाद ज्ञापित करते हैं। आपका समर्थन और मार्गदर्शन हमें और अधिक ऊंचाइयों तक पहुंचाने में सहायक होगा। हम माननीय महोदय को आश्वस्त करते हैं कि हम कठोर परिश्रम करना जारी रखते हुए राज्य के सर्वोत्तम हित में अपना सर्वश्रेष्ठ प्रयास करेंगे। संघ का यह मानना रहा कि सदस्यों से संवाद बना रहे, संघ की गतिविधियां प्रत्येक सदस्यों के संज्ञान में आए और उन पर प्रतिक्रिया प्राप्त हो, इसलिए न्यायाधीश संघ की आधिकारिक वेबसाइट को डिजाइन कराया गया है और उसे इसी कॉन्फ्रेंस में माननीय के कर कमलों से लॉन्च किया जाएगा। इस वेबसाइट के फीचर्स अत्यंत उपयोगी हैं। आप इस पर ब्लॉग लिख सकेंगे, जिलेवार उपयोगी सूचनाओं का आदान प्रदान कर सकते हैं। इसमें प्रयास किया गया है कि न्यायाधीशों के लिए आवश्यक लिंक जैसे माननीय सर्वोच्च न्यायालय, माननीय मध्य प्रदेश उच्च न्यायालय, नालसा, सालसा, विधि एवं विधायी कार्य विभाग एवं अन्य महत्वपूर्ण संस्थाओं तक पहुंचने के लिए पृथक से प्रयास न करना पड़े और यह वेबसाइट उनके लिए उपयोगी साबित हो सके। वेबसाइट में संघ की अद्यतन गतिविधियों को भी प्रदर्शित किया जाएगा और वेबसाइट को सहज दृष्टि से सभी सदस्यों को देखने योग्य बनाया जाएगा ताकि पारदर्शिता बनी रहे। हम जानते हैं कि संघ की सीमाएं अनंत नहीं हैं, उन पर निर्बंधन है। हम जानते हैं कि संघ की सीमाएं अनंत नहीं हैं, उन पर निर्बंधन है। आपका सक्रिय सहयोग और मार्गदर्शन सदैव अपेक्षित रहेगा। हम संघ के हित में और भी उल्लेखनीय कार्य करने हेतु सदैव प्रयासरत हैं। इसी स्तर पर मैं अपनी वाणी को विराम देते हुए इस अधिवेशन में उपस्थित माननीय उच्चतम न्यायालय के न्यायाधिपतिगण महोदय का हमारे बीच में पुनः स्वागत करते हुए मध्य प्रदेश की राजधानी झीलों की नगरी भोपाल में हार्दिक स्वागत, अभिनंदन और वंदन करता हूं। आप सबका बहुत बहुत धन्यवाद। जय हिंद।
Thank you, sir. The Madhya Pradesh Nyadhish Sangh has adopted a new logo and motto. We are all eager to see the same. I kindly request our esteemed Chief Guest, my Lord, Honorable Shri Justice Sanjiv Khanna, Judge, Supreme Court of India, to kindly release the new logo and motto of the Madhya Pradesh Nyadhish Sangh.
The Madhya Pradesh Nyadhish Sangh is an association of all the judges of the District Judiciary of Madhya Pradesh. It came into being on 27th August 1998. Its primary aims and objects are to uphold the constitutional values, to strive for intellectual excellence for its members, to strive towards zero pendency, to ensure a proper environment for its members, to secure appropriate service conditions, to enrich its members with newly developed principles of jurisprudence, to organize seminars to update the legal knowledge of its members, to formulate and implement appropriate welfare schemes for its members. The service rendered by each one of the judicial officers is symbolized by the scales of justice. The scales of justice represent the cardinal objective of rendering justice in each case without fear or favor, affection or ill will. Every single case that a judicial officer decides is weighed in golden scales. Justice must be rendered in a balanced manner without tilting to any side. The scales of justice in the logo is a reflection of this. The book in the logo is indicative of the revered Constitution of India. The Constitution is the guiding principle for all laws in the country and all citizens of the country. All statutes and laws are founded in consonance with the constitutional values. All judgments rendered by the judicial officers are in tune with the constitutional mandate. The scales of justice and the Constitution of India are ensconced in a semicircle containing the words Madhya Pradesh Nyadhish Sangh. This indicates that the values espoused by the scales of justice and the Constitution must both be at the very core of each judicial officer of the Madhya Pradesh Nyadhish Sangh. The sun is the source of all life and energy on this earth. The sun itself cannot be seen due to its brilliance, but its rays touch every corner of the earth, dispelling darkness. Similarly, each judicial officer has the ability to dispel darkness through his just verdicts in the lives of litigants who are subjected to injustice. These verdicts must necessarily draw from the core principles reflected by the scales of justice and the Constitution. Just like the rays of the sun, which reach every nook and cranny, the judgments given by the judicial officer have the potential to usher in wide-ranging positive changes in society. Apart from the symbolism, the logo also contains the terms integrity and competence, which form the motto of the Madhya Pradesh Nyadhish Sangh. Integrity, that is honesty, probity, righteousness, are absolutely indispensable for any person, more so for a judicial officer. A judicial officer without integrity does not have the moral right to adjudicate any case. It is the hallmark of a judge. Therefore, each judicial officer is expected to maintain the highest standards of integrity. Competence, that is capacity, skill, efficiency, knowledge, comprehension, are imperative to deliver justice in a judicious and efficient manner. Therefore, each judicial officer is expected to maintain the highest degree of competence. Therefore, the motto of the Madhya Pradesh Nyayadhish Sangh, integrity, competence. An amalgamation of all the above components forms the Madhya Pradesh Nyayadhish Sangh.
Thank you, my lord. In the last 2 years, the Madhya Pradesh judiciary has made path-breaking achievements. We have travelled from backlogs to breakthroughs in the quest to engineer an ideal justice delivery system in Madhya Pradesh. The efforts made by the Madhya Pradesh judiciary has been compiled in the book titled Backlogs to Breakthroughs. This book is a reflection of some of the developments made by the Madhya Pradesh judiciary in the last 2 years. I now request our esteemed Chief Guest, my Lord, Honorable Shri Justice Sanjiv Khanna, Judge, Supreme Court of India, to kindly release the book Backlogs to Breakthroughs. Thank you, my Lord. The judicial officers of Madhya Pradesh have written various articles on various issues. They have been compiled in the form of a souvenir. The articles in the souvenir cover various issues relating to law, justice and judges, and to strengthen the justice delivery system. The article provides an opportunity to the young judges to hone their personalities as well. I now kindly request our esteemed distinguished guest of honor, my Lord, Honorable Shri Justice Aniruddha Bose, Judge, Supreme Court of India, to kindly release this souvenir. Thank you, my Lord. The Constitution of the Association is in Hindi. The Association in its conference held in the year 2019 had passed a resolution for the Diglot edition. However, the same was not acted upon. Furthermore, there have been various amendments in the aims and objectives of the Constitution. One of the key objectives is to strive towards zero pendency. The Constitution is the heart of the association. It is a document which every judicial officer must have. Therefore, the association desired to have a Diglot edition of the Constitution and has now been published. I now kindly request our distinguished guest of honor, my Lord, Honorable Shri Justice J.K. Maheshwari, Judge, Supreme Court of India, to kindly release the Diglot edition of the Constitution of the Association. Thank you, my Lord. I would now request Shri Ajay Prakash Mishra, Executive Member of the Madhya Pradesh Nyayadhish Sangh and Principal Registrar, High Court of Madhya Pradesh, Bench at Indore, to kindly welcome and felicitate our esteemed Chief Guest, my Lord, Honorable Shri Justice Sanjiv Khanna, Judge, Supreme Court of India, by presenting his Lordship with a bouquet and a memento as a mark of our respect and gratitude. Thank you, sir. I would now request Shri Manoj Kumar Srivastav, Vice President of Madhya Pradesh Nyayadhish Sangh, and Registrar General, High Court of Madhya Pradesh, to kindly welcome and felicitate our distinguished guest of honor, my Lord, Honorable Shri Justice Aniruddha Bose, Judge, Supreme Court of India, by presenting his Lordship with a bouquet and a memento as a mark of our respect and gratitude. Thank you, sir. May I now request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, to kindly welcome and felicitate our distinguished guest of honor, my Lord, Honorable Shri Justice J.K. Maheshwari, Judge, Supreme Court of India, by presenting his Lordship a bouquet and a memento as a mark of our respect and gratitude. Thank you, sir. Now I would request Shri Amitabh Mishra, Principal District and Sessions Judge Bhopal, to kindly welcome and felicitate my Lord, Honorable Shri Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh, by presenting his Lordship with a bouquet and a memento as a mark of our respect and gratitude. Thank you, sir. I would request Shri Kamal Joshi, Special Judge Bhopal, to welcome our President, Shri Subodh Kumar Jain, by presenting a bouquet. Thank you, sir. I would now request Shri Amar Singh Sisodia, Chief Judicial Magistrate Bhopal, to welcome Secretary of the Association, Dr. Dharmendra Tada, by presenting a bouquet. Thank you, sir. I now request my Lord Honorable Shri Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh, to kindly address the gathering.
Honorable Shri Justice Sanjiv Khanna, Judge Supreme Court of India. Honorable Shri Justice Aniruddha Bose, Judge Supreme Court of India. Honorable Shri Justice J.K. Maheshwari, Judge Supreme Court of India. Shri Subodh Kumar Jain, President, Madhya Pradesh Nyayadhish Sangh. My esteemed sister and brother judges. Shri Manor Mamtani, the acting chairperson of the Madhya Pradesh Human Rights Commission, Shri S.K. Palo, Upalakayuktha, Madhya Pradesh, former judges of the High Court of Madhya Pradesh, the Registrar General and other officers from the registry, the principal district judges, session judges, and all my dear judicial officers. Shri Prem Singh Bhadoria, Chairman State Bar Council of Madhya Pradesh, Shri Sanjay Verma, President, High Court Bar Association, Jabalpur, ladies and gentlemen. A very good morning to everyone. We have all gathered here today to mark the momentous occasion of the inauguration of the 10th Biennial Madhya Pradesh Judicial Officers Conference. It is a celebratory occasion for us, especially since the last conference was held as far back as in the year 2019. Our joy is amplified by the presence of Honorable Justice Sanjiv, Judge Supreme Court of India, who has graciously joined us here today despite his busy schedule. The release of the new logo, the motto, and backlogs to breakthroughs by Honorable Justice Khanna has given a fiery start to the conference. The dual motto, that of integrity and competence, are sine qua non for a judge. These qualities are indeed present in abundance in my lordship. His commitment to work is worth emulating by all. A recent example on this is, despite assuming charge as the executive chairperson of the National Legal Services Authority just 2 weeks ago, Honorable Justice Khanna has already enthusiastically begun work on this front. He had scheduled field visits and has also expressed his desire to learn more about the Madhya Pradesh Legal Services Authority. This profound work ethic is what ultimately benefits the institution and leads it to great heights. We are beholden to Justice Sanjiv Khanna for his time. I am confident that the judicial officers would be inspired by Honorable Justice Sanjiv Khanna's address. Honorable Justice Aniruddha Bose, Judge Supreme Court of India, has generously let us partake of his valuable time today. My interactions with Justice Bose have led me to ponder deeper about specific questions of law and procedure. This quality of generating academic questions in the minds of others is indeed worthy of being treasured. It makes one think, and that helps you grow. We are indebted to Justice Bose for joining us here today. I'm sure his Lordship's address will enrich all judicial officers today. Honorable Justice J.K. Maheshwari, Judge Supreme Court of India, has considerately joined us despite a full calendar. Justice J.K. Maheshwari is from our very own state of Madhya Pradesh. I'm sure most judicial officers have had the fortune of interacting with his lordship. Those who have not would get the opportunity today. In addition to his professional commitments, Justice Maheshwari also has personal commitments that require to be urgently attended to. Despite this, he has joined us today in order to speak to the judicial officers. I'm sure the judicial officers would benefit from his lordship's address. To all the judicial officers present here today, a very warm welcome to each one of you. We have an intellectually enriching conference lined up for you. The theme of the conference is looking ahead. The pendency of the district judiciary in Madhya Pradesh is around 20 lakh cases. The reason for choosing looking ahead as the theme is to endeavor to build a roadmap through which we can navigate to these pendencies to reach our goals for the institution and the justice delivery system. The address by the chief guests and the distinguished guests of honor at this inauguration ceremony should build the momentum for the academic sessions and the technical sessions to come. The first academic session will be on Vision 2047. Honorable Mr. Justice Vikramnath, Judge Supreme Court of India, has kindly consented to chair the session. Justice S.A. Dharmadhikari and Justice Vivek Agarwal, the judges of the High Court of Madhya Pradesh, would be co-chairing the session. 5 judicial officers would also be speaking. The year 2047 has been chosen because it represents the 100th year of independence. What do we have to show after 100 years of independence? A pendency-free judiciary must be one of them. One of our primary goals for 2047 is for no case to remain pending in the district judiciary for beyond a year from its institution. This is quite ambitious and seemingly unattainable as of now. As Norman Vincent Peale once said, shoot for the moon. Even if you miss, you'll at least land among the stars. Drawing from this, we may not completely achieve the goal, but will certainly end up closer to the goal, provided there are sustained efforts by each and every judicial officer. The 25-debt scheme was instituted in October 21 to dispose of long pending cases, and it has been more than 2.5 years since the scheme has been in place. For a long time, statistics indicated the oldest case to be disposed of was of the year 1969. However, subsequently, statistics emerged which revealed that the longest pending case to be disposed of was from the year 1962. That is 60 years. The case was pending for 60 years in Madhya Pradesh. I can say nothing more on this part from the fact that the journey from 60 to 1 will be difficult, but we need to start. We have achieved incredible results through the 25-debt scheme. The years 23 and 22 have seen the highest ever disposal of cases that are older than 5 years in Madhya Pradesh. Cases that would never have been heard are now being heard judiciously and being disposed of. I congratulate each one of the judicial officers for this. It is due to your hard work that litigants who have been waiting for decades are able to see the light at the end of the tunnel. You deserve the highest of commendations for this. I have met many of you over the last 2 years, and each of you has been eager to narrate your own experiences with the scheme. The one common thread is that of satisfaction of having heard and equitably disposed of these cases. I had practiced as an advocate for around 21 years before I was elevated as the judge of the High Court of Karnataka. The happiness that you get when you win a case for your client as an advocate is enormous. However, the satisfaction that you get as a judge when you adjudicate a case so as to provide justice is unparalleled. Some of you might have experienced this. Ultimately, you will realize that it is these intangible things that give you peace of mind and ultimate happiness. The entire justice delivery system exists for the litigants. We may build the best of physical infrastructure, provide the latest technology, but none of that will matter if it does not provide relief to the litigants. Relief necessarily means justice within a reasonable period of time. Therefore, Vision 2047 will delve into how we can chart a vision for the litigants and go from 60 to 1. The second academic session will be on artificial intelligence and social media, the impact on the judiciary. Honorable Mr. Justice A.S. Oak, Judge Supreme Court of India, has kindly consented to chair the session. Justice Rohit Arya and Justice Vivek Rusia, judges of the High Court of Madhya Pradesh, would be co-chairing the session. 5 judicial officers would be speaking. The possibilities of the use of artificial intelligence in the justice delivery system are endless. Artificial intelligence has been replacing manpower in many domains, but the judiciary is yet to embrace the full potential of artificial intelligence. Through this session, we will attempt to dissect the employability of artificial intelligence in the justice delivery system, while at the same time remaining cognizant of the risks posed by an over-dependence on artificial intelligence. During this session, we would also try to spend some time on social media and its interplay with the judiciary. In addition to the aforementioned 2 academic sessions, we thought it important to include technical sessions as well, to delve into issues that the district judiciary is required to deal with on a daily basis. Session 1 would be on bails, especially on issues pertaining to parity, repeat applications, cancellations in bail matters. This session would be chaired by Justice Vijay Kumar Shukla and Justice G.S. Aheluwalia, judges of the High Court of Madhya Pradesh. Sessions 2 would be on the delay in the conduct of trial and its problems and solutions. This would be chaired by Justice Subodh Abhyankar and Justice Sanjay Dwivedi, judges of the High Court of Madhya Pradesh. Session 3 is on court and board management and would be chaired by Justice Vishal Dhagat and Justice Vishal Mishra, judges of the High Court of Madhya Pradesh. 3 judicial officers will also be speaking on these subjects. Therefore, academic session 1 would attempt to set up a roadmap for the future, and academic session 2 would seek to provide tools to reach that goal in a more efficient manner, and the technical sessions would deal with the day-to-day problems that would have to be eliminated to reach these goals. The sessions have been designed after careful planning, and I do hope each of you makes the best use of the same. Looking ahead seeks to build a better tomorrow for our institution. Building a robust institution requires conviction and hard work. It requires difficult decisions that place the institution before the self. At times, fearless actions may harm your personal interest. Nonetheless, these have to be taken without any hesitation, because it is these that ultimately shape a strong tomorrow. Let us attempt to chart a path for the institution which is in tandem with the new motto of integrity and competence. Let us bring about a positive change in the institution by placing the needs of the institution before our own. Let us ensure that we work for the institution rather than making the institution work for us. As John F. Kennedy said, ask not what the country can do for you, but what you can do for your country. I, on my own behalf and on behalf of the entire Madhya Pradesh judiciary, once again extend a hearty welcome to Honorable Justice Sanjiv Khanna and Justice Aniruddha Bose to the state of Madhya Pradesh and its capital Bhopal. We warmly welcome Justice J.K. Maheshwari back to his home state of Madhya Pradesh. The Madhya Pradesh judiciary looks forward to hearing each one of your lordships' address and also expresses a deep sense of gratitude for your presence here today. I wish the President of the Madhya Pradesh Nyayadhish Sangh, Mr. Subodh Jain, the office bearers, and all the judicial officers the very best, and once again congratulate each one of you for all that you have achieved. Thank you.
Thank you, my lord. I kindly request our distinguished guest of honor, my Lord Honorable Shri Justice J.K. Maheshwari, Judge, Supreme Court of India, to kindly address the gathering.
Brother Justice Sanjiv Khanna, Honorable the Judge, Supreme Court of India, Brother Justice Aniruddha Bose, Judge, Supreme Court of India, Justice Ravi Malimath, Chief Justice, Madhya Pradesh High Court, Honorable Judges of the Madhya Pradesh High Court present with their better half, Honorable former Judges, Chairman, Human Rights Commission, Up Lokayukt, Principal District Judges, all judicial officers, Registrar General, Mr. Subodh Jain, President of the Association, Dharmen Tada, Secretary, and all gracious ladies and gentlemen present, Mr. Prem Singh Bhadoria, President, State Bar Council, and Mr. Sanjay Verma, President, High Court Bar Association, Jabalpur, who are present. A very good afternoon to everyone. Hailing from the Madhya Pradesh, I deem it a matter of privilege and pride to be here in this 10th conference. My mind is boiling with my memories of my time when I was serving High Court of Madhya Pradesh. I see confident and familiar faces of our judicial officers who are here. Today, this conference has been designed in a different way. Earlier, as I was aware, because I belong to this place, it is only for the purpose of election of the association and some meeting, what happened, what did by the members of the association during past year. But by this time, it is designed in a different way. When I was going through this card, I was looking, there are 2 academic sessions and 3 technical sessions. It includes academics and technical includes practical problems, how it can be enriched and experienced and to solve all those problems. Calling me in this conference by the Chief Justice, I convey my gratitude and to all members and their association to call me here, that they decided to call me. It's my pleasure with all of you. I always thought any of the judicial officer, what he works, it is what he thought, what he is. And if a man who is doing something, who is a judicial officer, be it may be advocate, be it may be anything, if he is doing something, it is insight of that person and how he thought, how he worked. I reminded the wordings of the Martin Luther King Jr. He said, if you can't fly, then run. If you can't run, then walk. If you can't walk, then crawl. But whatever you do, you have to keep moving forward. That must be a thought process. The question comes, how can we move forward? The basic is whatever you do, either for living or for your passion or for both, becomes your profession. And leave service for self and start service for society. For a judge, from Gita, it goes from karma to karma yoga. And how Srimad Bhagavad Gita defines a judge. It says, A judge is a person bestowed with excellence. A judge ought to be bestowed with the sense of complete detachment and humility. He ought to remember that he is not himself an author of his deeds. He is only an actor who has to play his role conforming to the script which represents the will of the author, playwright, and thus surrendering himself to the will of God. If we go to Islam, then it says the supreme act of religion is the surrender, and you surrender. And we go for Bible, then it says, the will be done, O Lord, thy. How you have to behave yourself being a judge. That is the first concern. As you know, it was described that by this time, whenever our judicial officers are coming to the field, at the time of their training and its completion, they were administered the oath. Then what is oath contemplates? It is only a pleasure to the members of the family that they are taking oath and to look forward? No. The oath contemplates, and its every word and expression employed is potent with a message. The message has to be deciphered by reading between the lines and looking beyond that meets of the eyes. An option to swear in the name of the God or to make solemn affirmation is suggestive of secular character of the oath. It just must bear not only faith but true faith and allegiance to the Constitution of India. The oath demands of a judge not only belief in constitutional principles but a loyalty and devotion akin to the complete surrender to the constitutional beliefs. Then again, why is that? Why? Because under our constitutional scheme, the judiciary has been assigned the onerous task of safeguarding the fundamental rights of a citizen, upholding the rule of law. So please understand what you have started and you have taken the oath. My dear officers, legal profession is one of the most demanding, promising, as well as rewarding profession. We have to follow the maxim, live like a hermit and work like a horse. It applies to all individuals associated with the justice delivery system, especially judicial officers. It comes with a significant sense of responsibility and requires intensive preparation, tremendous dedication on aware mind to grasp and develop legal acumen, and lastly, the profound devotion to render a public service and ensure that justice in true sense and spirit should be served to the people of this state. How the duties of such importance must be performed? The next question comes in our mind. A judicial officer has to be an individual who not only lives with values but also believes in creating values. The life of a judge is not easy, and things in judicial life do not always run smoothly. Performing the function of a judicial officer on account of or occupant of time rises towards the heights at time of all will seems to reverse itself. So, friends, what you have to do? I will say your how, in what manner your working must be. I will start with some story. A patient visited to a doctor clinic and asked the receptionist, I want to see a specialist of eyes and ear. The receptionist said, there are doctors of ear, nose and throat. And there are doctors of eyes, but there is no specialist who treats both eyes and ears. But then why are you in need of such doctors? The patient replied, these days I do not see what I hear and what I see. So, all of you might be most probably wondering about the relevance of this story. Well, in my opinion, we should refrain from seeing and listening and what we ought not to. In order to ward, a judicial officer must be free from chains of prejudice. It is futile to think of excellence in judiciary unless the judges, howsoever highly or howsoever lowly placed, were to follow the canons of the judicial ethics. So, please, we have to follow the canons of the judicial ethics. While doing so, and in a practical field, we should know a difference between what you have right to do and what is right to do. To understand this, a story of Panchatantra of a monkey and crocodile can be well placed. A monkey lived on a tree on the bank of a river. Crocodile used to come, and once a day he was very hungry. He was on the tree of the berry when he saw that crocodile is hungry. He gave berries to him. He ate the berries and pacified his hunger. It was going on. Once a day, the crocodile asked the berry for his wife. The monkey gave one or two more berries to him for his wife. When this crocodile went to his wife and said this story, that it is the monkey who did all this, the wife of the crocodile thought, what a heart of a monkey. Then he asked that I need the heart of a monkey and I want to eat that. Crocodile visited to the monkey and asked to have a dinner at his home. Because they became friends, so crocodile started with monkey, and then crocodile said entire story to the monkey. Monkey found that if I will go, then this will finished. And he turned around and he said to the crocodile, my heart is at my tree, so please return back, and came back to the tree. Then he said, no, we should not go for that. The intent of that story, we see the perspective of the ethics of that crocodile and the perspective of the ethics of the monkey. If we see, the crocodile want to manipulate the monkey and call him for the dinner to fulfill his wife's wish. But did he do the right thing by betraying his friend? This where an individual more conscience comes into the picture. I am sure each one of us sitting here might have faced a situation where there are conflict, with what is the right thing to do. The question is, how do you deal with it? So again, it comes on yourself. If you are a man of ethics, you will do the right things. This question assumes a lot more significance in legal profession as novel as this profession is. There are equally difficult situations where, being a judge, you will come across a scenario where you will need to invoke your moral conscience and decide what you have the right to do and what is the right to do. In the lecture, Justice R.C. Lahuti, the judicial canons of judicial ethics, he quote that the discharge of a judicial function is an act of divinity. Perfection in performance of judicial function is not achieved solely by logics or regions. So, you have to act upon and establish the faith and confidence on our system, and our work must be in every field, whatever we are doing, should be confident to the public, and they have to trust that if we'll go to the court of law, we'll get justice. I will define, coming to the ethics, what we have to follow in our life. Then we have to go of the Sukraniti. 5 things have been specified if a judge is having in his mind and his body. One is Rag, he should be refrain from them. Rag, Lobh, Bhay, Dvesh, and Bidnosh Rastri. If you have 5 these things and maintain fidelity to uphold the rule of law and justice, it is your ideal responsibility. If you maintain public trust, confidence in the legal system, it is your social responsibility. Ensure fairness and impartiality, and foster integrity and accountability with legal system. This is your self-regulation. If you have all these things in your mind, you can act upon whatever you have decided. Hindu philosophy beautifully compares the judge with the flower. We have discussed I come across one story that a religious discussion was to take place between Adi Shankaracharya and Mandan Mishra. Ma Saraswati was the judge of both of them. Both were offered similar asanas to sit on. Having plucked fresh flowers, Ma Sharda strung 2 identical garlands in the necks of both. She put them around the necks of 2 scholars and said, during the discussion, the garlands will decide the winner and the loser. The wearer of the garland whose flowers fade first will be considered to have lost. Then Ma Sarda maintained that he who possesses the intellectual clarity, power of thinking, self-confidence will be calm and peaceful. His voice will be like the cool spring. Therefore, the flower will remain fresh for a longer time. On the other hand, one who does not have a clear intellect or a strong sense of logic, or where self-confidence staggers, will be frustrated. His voice will become harsh. The circulation of blood in his veins will become rapid, and his breath will become hot. Hence, the flower around his neck will wither sooner. the fragrance of the freshness of the flower become a part of the personality of a judge if what he thinks and what he does are all based on such values which I have described. On a conclusion, I will read one quote of the Professor John Hastings, the former judge of appeal of USA Supreme Court. He said, "It must be a conscience alive to the properties and the improprieties incident to the discharge of a sacred public trust. It must be conscience governed by the rejection of the self-interest and self-ambition. It must be a conscience propelled by a consuming desire to play a leading role in the fair and impartial administration of justice, to the end and public confidence may be kept undiminished at all time in the belief that we shall always seek truth and justice in the preservation of the rule of law. It must be conscience not shaped by rigid rules of doubtful validity, but answerable only to a moral code which derive the responsible judges from the profession. Without such a conscience, there should be no judge." So we should bear in our mind what should be the quality with us. If we go by these standards, then we should follow the following highest standards of the professional ethics, maintain good moral character, and inculcate a sense of differentiation between the right and wrong, developing courage to stand the right even in the face of adversity in the end. By two lines, I will close and I will say that you have done a lot, you will do a lot, but have a commitment for doing a right thing, for a righteousness, for a confidence, and to build the public trust and confidence on judicial system. And by two line I will end. I say, मिटा दे अपनी हस्ती को अगर कुछ मर्तवा चाहे, मिटा दे अपनी हस्ती को अगर कुछ मर्तवा चाहे, कि दाना खाक में मिलकर गुले गुलजार होता है. You have to do by your conscience for the system what you are doing. It is admirable, but I hope and trust that you will do more admirable. Thank you very much for calling me and listening.
Thank you, my lord. I now request our distinguished guest of honor, my Lord Honorable Shri Justice Aniruddha Bose, Judge, Supreme Court of India, to kindly address the gathering.
Good afternoon, everyone. Honorable Justice Sanjiv Khanna, Honorable Justice J.K. Maheshwari, Honorable Chief Justice Malimath, Shri Subodh Kumar Jain, President of the Madhya Pradesh State Judicial Officers Association, and all other dignitaries who are off and on the dais. It is indeed an honor for me to be here to speak on this occasion. A gathering of this nature offers us an opportunity to collectively introspect on our own functioning. And my preceding speaker, Justice Maheshwari, has already set the tone, how one should go ahead. We as judges seldom meet to exchange our ideas. The nature of work that we perform is highly individualized, and to a great extent dependent on the quality of assistance we receive from the members of the bar. Barring among very close colleagues, we rarely discuss a point on which we have to take a decision. Now, in many ways, the current phase which we are passing through is one of the most challenging phases in the history of our judiciary. Though we have had a very ancient tradition of law-based dispute resolution, the present system started evolving from the middle of 18th century, and which lays a great emphasis on fairness. Over the years, the number of litigations has multiplied. At present, we have around 5 crore cases on the boards of different courts of our country. A large number of legislations are being enacted calling for new interpretations. Massive technological innovation has started, and a serious attempt is being made to incorporate this technology in over about 3,500 district court complexes that we have across the country, in about 800 districts now, supervised by 25 high courts, functioning from 39 locations. Continuous updating of data regarding cases, which is taking place through the National Judicial Data Grid, has woken us up from an ignorance in bliss approach. I don't think my predecessor 40 years back had ever, whenever he decided a case, did he think how many cases are there on the board? This thinking started for the last 30 years, though as early as 1926, there was an area committee formed by the then British government for early resolution of cases. In 2022 itself, however, the number of litigations that were decided by the law courts in India were in the region of 2.5 crores. So this pendency is a dynamic figure, and large number of disposals, at least now, are taking place. In 2022, the number of disputes, pre and post litigations that have been resolved by Lok Adalat was almost 4.5 crores. Now, why am I quoting these figures in the inaugural session of this conference? It is because around 21,000 judges of this country are at the center stage of this huge exercise that the nation is undertaking of clearing the backlog of cases. We are not a country where the system has outpriced itself to deter the common man from approaching the court. Along with rich landlords and business houses trying to settle their multi-crore rupee disputes, the board or list of any court in this country, including the court I come from, would also reflect a large number of cases involving retrenched workmen, estranged homemakers, evicted agricultural tenants, jostling for justice. The socio-political atmosphere of the country, with the emergence of social media as a major communicator, is also consistently exposing the system to comments and observations, many times which are uninformed and unfair. At the broad level, we need to deal with three major challenges to take our system to the next generation. The first is acclimatizing ourselves with information technology and artificial intelligence, on which I think the second half there are sessions to enlighten all of us. The next is introduction of vernacular languages as the medium of communication in the judicial process. I find Madhya Pradesh fairly developed from the speech the president of the association gave, except I found compared to my state, Hindi here is a bit Sanskritized. Since the system in which we operate now has largely evolved through the principles of common law, most of the terminology used in the judicial process stems from that system combined with certain Persian influence. Well, in our part of the country, a judge is still referred to as Hakim, whereas here I think Nyayapalika is quite common, the standard, and High Court is Nyayamurti. Okay. The third challenge would be facing the social media. What does one do with it? Every comment you make, knowingly or unknowingly, consciously or unconsciously, next day it will go to some channel and there will be, that's not all. There will be comments on these comments, rows of them. My own suggestion is to deal with it is twofold. One is we speak in court only those words which we can write or which we write. And second is ignore those comments. No need of reacting all the time. Our predecessors did not have to face this situation. On the positive side, a development which is going largely unnoticed is that we are slowly emerging as the new global leader on jurisprudential thoughts in today's world. Legal communities in different parts of the world are now taking note of progress made by us in different areas of law. At least in our court, 1 out of 100 cases which are cited is an English precedent. You go through judgments of 50s and 60s, 60% cases cited would be of English precedent, English or American. Our courts have delivered path-breaking judgments in various fields that would include women empowerment, evolving entitlement rights for the socially deprived, child protection, to name a few. In the middle 80s, from Bhopal itself, a new concept came, dealing an interim order of an additional district judge, who later on became a judge of the High Court Justice, Deo. M.W. Deo. In a tort action, interim monetary compensation, that was never tried by at least to my knowledge, by the origin of this tort jurisprudence, the English courts. Though we often refer us as a common law country, our common law was never a carbon copy of the British or English common law. As early as 1861, Sir Barnes Peacock, who was that time the Chief Justice of the Supreme Court of Bengal, had crafted a new principle of sovereign immunity, which had diluted the strictness which was there in the English law. This was in Peninsular and Oriental Steam Navigation Company. There is one subtext to it. Because it went against the colonial masters that time, none of the law journals in Calcutta had published it. You will find reference to this in State of Rajasthan versus Vidyapati, which dealt with sovereign immunity, where the author of that judgment, possibly Chief Justice Sinha, he has commented that it's strange that a judgment of this dimension never was reported anywhere. Only in Bombay High Court reports, in the notes section, there is a summary of this judgment. Another judgment again, accidentally from my own court, where I come from, Calcutta, that is. In the case of Thakur Chandar Pamanik, the English principle that the chattel of the trespasser would remain with the landlord was deviated from. This principle possibly was the foundation of the Constitution Bench decision of Olga Tellis. It is not that we did not have our own principles of interpretation. An eminent social reformer, Ishwar Chandra Vidyasagar, when he was mobilizing public opinion for widow remarriage, and which ultimately became a statute in 1856, he had to hunt from various smrtis and found a particular sloka of the great sage Parashar, which laid down 5 conditions under which a married lady could contract a second marriage. There were, I'll give the transliteration of the sloka: when her husband is missing, or is dead, or has renounced the world, or is impotent, or has been degraded by the sin. Under these 5 conditions, according to the great sage Parashara, even a married woman could remarry, abandoning her husband. So that led to the 1856 Act. Much earlier, around 13th or 12th century, on the question of inheritance under Hindu law, the Mitakshara and the Dayavaga systems evolved through interpretation of a particular sloka from Manu Samhita. You can use artificial intelligence or simple Google. This is chapter 9, 104, verse number. So the Jimutabahan, who was the follower, who had evolved Dayavaga system, he went for a literal translation and said that only upon death of the father or mother, inheritance would be on the son or grandson, etc. Whereas Vijnaneshwar, who had given a more broader interpretation to this particular verse from Manu, and said on birth itself, a child will have access to the ancestral property. You look into K.L. Sarkar's Tagore Law Lecture, which is now published by LexisNexis, the Mimamsa system, which is as good as Maxwell in interpretation of statutes. Coming back to contemporary times, we now need to have a common theory based on our vast experience with the law to present to the world an Indian system of jurisprudence, an exercise in which all of us should participate. Rightly, we are spending still a lot of time and energy in reducing the pendency. But we'll also have to focus on quality, which we are doing, no doubt. We are on a path which is apparently contradictory, but in reality complementary exercise. We are inviting people to the court by floating this access to justice program, of which Justice Khanna is now at the helm of it as the executive chairman of NALSAR. We are also simultaneously restricting entry of many frivolous litigation and pushing them to the ADR system. This is also a complex exercise of finding a balance between docket exclusion and docket explosion. We are extending our hands to all those who cannot enter the docket. At the same time, we are pushing out all those who enter the docket by force. In this conference, we have very able judges as speakers and participants, and the subjects chosen for discussion in the technical session would also help in a significant way to equip ourselves to meet the needs of the future and the present. I won't take further time. Thank you very much for calling me.
Thank you, my lord. Now we all await to hear the inaugural address of our Honorable the Chief Guest. I request our esteemed Chief Guest, my Lord Honorable Shri Justice Sanjiv Khanna, Judge Supreme Court of India, to kindly inspire and enlighten us by delivering the inaugural speech.
Mr. Justice Aniruddha Bose, Mr. Justice J.K. Maheshwari, Judges Supreme Court of India, Mr. Justice Ravi Malimath, Chief Justice, the judges and the former judges of the Madhya Pradesh High Court, the President and the Secretary of the MP Judicial Officers Association, judges of the Madhya Pradesh Judicial Services and the attendees. Namaste and good afternoon. Before I delve into the questions of what makes us judges and the conference theme looking forward, I want to express my admiration and gratitude to the district judiciary. In my first years after enrollment and a significant portion of the subsequent decade, I had practiced extensively in the district courts at Tisazari in Delhi. It was within these courtrooms that as a young lawyer, I learned the foundation principles of law. I owe a debt of gratitude to the district judiciary and its judges, some of whom later were elevated to the High Court while the others retired as district court judges. My respect from them is profound and at par with the judges of the Delhi High Court before whom I had the privilege to appear and argue. Secondly, I say with a sense of pride that my father was a member of the judicial service in the state of Punjab and subsequently in Delhi. After a long and illustrious career spanning over 20 years as a civil judge and a magistrate, he eventually went on to become a district session judge and then was elevated to the Delhi High Court. Throughout my upbringing, I bore witness to his relentless work ethics, unwavering commitment to the legal cause, and tireless pursuit of justice. As a child, I recall never seeing him rest. He was always immersed in a sea of files that would arrive home in a steel trunk. But the times were very different. The district courts were very different from what they are today. Picture this: overcrowded courtrooms, frequent power cuts, files towering from the ground till the ceiling, blocking out windows and sunlight. I have seen in these challenging times judges committed to delivering justice found themselves working in the flickering candles, armed with handkerchief and towels to navigate through the darkness and for wiping the sweat. I recollect studying in Delhi University every morning, and then every morning I would accompany my father to the bus stop, nearly a kilometer away. Then I would head to the college. My father would go to district courts. Those were times when there were no cars, no reimbursement of petrol, electricity, and water. Times have changed, so have our court complexes. The remuneration, the perks, and service conditions of our judges have improved. Today, our judges enjoy not only good facilities, but also fair remuneration, placing them at par with their counterparts in other branches of government service. In spite of these changes, there is something which endures and is constant. It is the admiration, respect that the judges get, not only within the courtrooms, but in the society itself. This begs the question, why and what is the reason for this reverence and respect? I'll again go back to my student days, when some of my affluent classmates would refer and flaunt the comfort and the luxuries they would enjoy. When faced with their assertions of wealth, I would sometimes get angry and ask them with a hint of frustration, can your parents direct sending a person to prison? My articulation was certainly immature and flawed, but it did convey a profound truth, the unique position of judges, like you and me, hold and have been conferred by the Constitution and the society at large. We have been conferred the right to sit in judgment over deeds and acts of fellow human beings. We have been given the power to remedy a wrong, to protect the innocent, and appropriately deal with and even punish the guilty. We are the check against injustice and the fortress for the commoners, including the poor and the weak. When is justice possible? It is possible when we treat the two parties who appear before us, even if they are unequal, as equals, and give a fair opportunity to win to each party and succeed against the other, howsoever powerful one party may be, including the state. I have circulated the copy of my speech, but I'll be cutting short because I think we have already overstepped. I'll just like to refer to Arnold Ratsky's tribute to Just Holmes in brief. A judge must be capable of stern logic and yet refuse to sacrifice to logic the hopes and fears and the wants of men. He must know the hearts of men and women, and yet asked to be judged from the conscience of their minds. He must have constant sense of essential power, and yet be capable of humility in its exercise. He must be the servant of justice and not the master, the conscience of the community and not its dominant interest. He has to put his ambition, which drives the politician to search for power, and thinker to the construction of an abstract system. No one must be more aware of his limitations and more hesitant about his personal conviction. These are stern and exacting tests, but they set out an ideal and a goal for attainment of which, even though partially and not in fullest measure, there has to be ceaseless striving and sustained effort. In the vast realm of judicial system, the district judiciary often finds itself overshadowed by the High Court and the Supreme Court and receives less limelight and coverage. This is an incorrect perception. It is at the district level that the justice is rendered to the masses, with the district courts serving as a crucial first point of engagement for commoners seeking dispute resolution. To put the things in perspective, let's consider the caseloads. In the calendar year 2023, the High Courts presided over more than 20,67,000 cases. The Supreme Court dealt with about 52,000 cases. In stark contrast, the District Court handled 2 crores 37 lakh cases, almost 10 times more than the High Courts. This underscores the foundational role of the District Courts in carrying the most significant weight of the entire judicial institution on their shoulders. The second misconception is that district judiciaries primarily deals with statutory rights rather than protection of the fundamental rights. This perception is potentially damaging the cause of justice. Most of our statutes in the country flow either from fundamental rights or from the directive principles of the state policy. Statutes often address conflict between two fundamental rights, prioritizing one over the other. Thus, any interpretation or application of statutes entails a determination with respect to the Constitution. In this manner, the district judiciary is intimately connected with the fundamental rights of the citizens, whether through preserving liberty via bail applications or upholding dignity of victims and accused in the trial. Since district judiciary handles far greater caseload than the appellate courts, the acts of application of statutes become the linchpin for protection of the fundamental rights. My brother had referred to bias and prejudice. What do you mean by bias and prejudice? Have you ever tried and visualized that? I'll refer to a book called Thinking Fast and Slow by Daniel Kahneman. And he has described biases and prejudice as this, in the following words: we can be blind to the obvious, and we are also blind to our blindness. Many of us believe that we are immune from biases, yet our thinking, judgments, conduct are inherently shaped by our native perceptions, ideologies, and beliefs. Our experiences mold our perceptions, serving the lens through which we navigate the world. I'd like to talk about 4 or 5 different kinds of biases which in the book are also stated and which I found in personal life as a judge to be relevant. 1, we sometimes form conclusions based upon limited evidence. Secondly, the sequence in which the information is received influences its perception. Thirdly, initial impressions about an individual or an event can profoundly impact your subsequent attitudes. Lastly, which is closely related to the fourth, is the tendency to seek out information that supports our existing beliefs and ignores information that contradicts them. These, I feel, are 4 or 5 points which we must examine when we go into the question of biases and prejudice. At the same time, we must recognize the distinction between neutrality and indifference. Judges should be neutral but not indifferent. There are situations when a judge must not act as a wall, when justice demands that he choose the side of the oppressed, when the situation demands that we must take sides, as silence encourages tormentor and never the tormented. Another aspect which I find is when we apply the law, when we enforce the law, we must not leave the human aspect of application of law aside. We must remember that rigid, one-size-fits-all approach often risks injustice. Can I give 2 examples which I have personally felt in Delhi? One of the most difficult courts to handle in Delhi were the traffic challan courts. Why? I realized when I spoke to the accused who were appearing and had to pay money for the traffic challans. Invariably, their vehicles were seized and they were imposed hefty fines. Many of them were surviving on the self-employed paying EMIs. The moment their vehicle was seized and hefty fines were imposed, for that month they would have to forego a lot of even small comforts or even basic needs and requirements. The second example which I am giving is again from my experience when I was working in the district courts. Impoverished litigants attend court hearing with a hope, but are confronted with repeated adjournments. Delays leads to loss of precious daily wages, repeated payment to advocates, and expenses for court hearings, compounding the economic hardship. These are aspects which we cannot ignore, and when we are looking forward, we must first take them into account and ensure that what is in our hands is done for the public and the litigants. I'll now delve into the question of certain specific and pivotal data statistics which I've come across, and these are relevant for the purpose of effective administration of justice. The total pendency in the High Court of Madhya Pradesh is about 4,47,000 cases. About 40% is criminal, whereas 60% are civil cases. 18.5% of the criminal pendency comprises of bail applications. This is not a good sign. The figures are not very good to this extent. Out of the total cases pending adjudication, 28.3% cases are pending adjudication between 5 to 10 years. 23.5% cases are pending adjudication between 10 to 20 years. A policy has to be formulated how to deal with this pendency. In the district and Talaka courts in Madhya Pradesh, there are over 20 lakh cases. 19.7% cases are civil cases, whereas staggering 80.3% are criminal cases, which gives a ratio, pendency ratio of civil and criminal cases of 1:4. The national average is 1:3. What is the reason and cause for the same has to be introspective and gone into. Is it because civil wrongs are being made into criminal cases and we are unable to check it? If that is so, we must step in. On the subject of arrest, in a span of the year, 1 year, the NCRB Data for Crime in India report 2022 shows that there were about 250,000 arrests made in Madhya Pradesh in 2022. 61.5% of such arrests were made under the IPC, whereas 38.5% arrests were made under local laws. This does not mean that 250,000 people went to jail. Many of them may have been released by giving in bailable cases on bail bonds. But this is a sign of worry. 250,000 is a very, very high figure. But the more worrisome figure relates to the Prison Statistics Report of India 2022, which states that there are 26,877 under trial inmates in the prisons in the state, out of which 69% inmates were incarcerated for 1 year or less. 23.7% prisoners were incarcerated for 1 year and 3 years, and around 7% inmates were facing incarceration for 3 years. The situation nationally was also very grim. 69% of prisoners in custody are people for less than 1 year. There is also another worrisome sign. Most of the prisoners, almost 50% of the prison population, is under 30 years of age. So these are aspects which we have to take into account when we say we are looking forward. Until unless we have the data and figures, how do we correct where the correction is required? How do we move forward? Now, having said so, what does moving forward a legal system, what are the key principles which a legal system must, on theory, have? A, be just in the result it delivers. B, fair in the way it treats the litigants. C, offer appropriate procedure at a reasonable cost. D, deal with cases at a reasonable speed. E, be responsive to the needs for those who use it. And F, be effective, adequately sourced and organized. It is unless we factor in all these 7 factors and evaluate and work forward on them, we will not be able to achieve the goal which has been set of zero pendency. Merely a filing of a case or case being being filed in the court does not lead to pendency. It becomes a pendency once it has crossed over the threshold time within which it should have been decided. How do we achieve this? One is case management hearing and strict timelines. We have taken the first steps in this regard in the Commercial Courts Act, but we have to go forward and fix ourselves timelines as far as criminal cases is concerned. The second aspect is art of judgment writing. Judgment should depend upon the content or the subject matter in issue. There will be certain judgments which are complex and difficult, but most of the judgments which deal with facts and are dealing with common law issues, simple issues, should be short, brief, clear, and simple, because the reader is invariably the common man. Third is optimizing case pendency calculation methods. We have been normally following the judge population ratio. This is not correct. This does not take into account, whereas many nuanced indicators. There are several other methods which have come into picture, and therefore when we evaluate the judging, the number of judges we require, the performance of the judges, we have to factor in several other factors. The fourth is doing away with procedural formalities. We have to make a concerted approach, pointing out these procedural formalities are not required. Most of us suffer under a misconception that CPC or the Code of Criminal Procedure are complete codes. It is not so. Unlike the Evidence Act, which is a complete code, both the Civil Procedure Code as well as the Code of Criminal Procedure permit you to adopt a procedure as it is not, if it is not contrary to what is expressly stipulated or impliedly stated in that procedure. The other aspect, fifth aspect, which we must do is to encourage mediations, and especially community mediations. I'm told Madhya Pradesh has taken steps in this regard. No court in the world can handle litigation, court litigation on its own. Until unless we develop alternate methods of dispute resolution, the mediation being the first of them, we cannot deal with the dockets. Dockets are bound to increase as more people are enlightened, more people come to know about their rights, something which Document Justice Aniruddha Bose has pointed out. We should not shy away from that, but the way to deal with it is mediation. The sixth aspect is using the National Judicial Data Grid and self-evaluation. When I talk about self-evaluation, I'm reminded of what our school principal had given. He had visited a school in Europe where the students were asked to write their own report cards every day. Fill it up. How did you behave today? How much work did you put in? Whether you were courteous to your teachers and your fellow students, or did you make a mistake and did something wrong? Nobody could have a look at the report card. That report card was meant to be kept with the student. Only when something really went wrong that the principal could ask for the report card. So our principal said, I'll adopt this system for our school also. The answer of the head of that school was, don't do it. Until unless you are sure that your students will answer it honestly. If they answer it dishonestly and they cannot self-evaluate themselves, they do not have the self-discipline to evaluate themselves properly, it will be counterproductive. We have to adopt this system of self-evaluation. Until unless we evaluate ourselves, our performance, we will not be able to improve and proceed forward. This is an robust internal process which has to be adopted, and until unless this can be only done by individuals, this doesn't require any institutional force or institutional direction. In the end, I'll say in our judicial constellation, the district judiciary is the North Star and the foundational edifice on which the weight of our system essentially rests. You are the crucial part of our judicial family and the face of our system. Through humanism, grace, diligence, you have the power to bring smiles to helpless faces. By being true to yourself, you'll be able to do your duty to your own satisfaction. Thank you for listening to me, and thank you for inviting me.
Thank you, my lord. Arriving towards the end of this inaugural program calls for an expression of heartfelt gratitude towards our esteemed guests and this august gathering. Therefore, I would now request Shri Manoj Kumar Srivastav, Registrar General, High Court of Madhya Pradesh and Vice President of Madhya Pradesh Nyayadhish Sangh to kindly deliver vote of thanks.
Hon'ble Chief Justice Sanjiv Khanna, Judge, Supreme Court of India. Hon'ble Chief Justice Aniruddha Bose, Judge, Supreme Court of India. Hon'ble Chief Justice Maheshwari, Judge, Supreme Court of India. Hon'ble Chief Justice Ravi, Malimath, Hon'ble Chief Justice of the High Court of Madhya Pradesh. Hon'ble Judges of the High Court of Madhya Pradesh. Shri Manohar Mamtani, Executive Chairperson, Human Rights Commission. Honorable Sri Justice S.K. Palu, Uplokayukt, Honorable former judges of the High Court of Madhya Pradesh, Shri Prem Singh Bhadoria, Chairman, Madhya Pradesh State Bar Council, Shri Sanjay Verma, President, High Court Bar Association, Jabalpur, respected dignitaries, esteemed participants, ladies and gentlemen, good afternoon to all of you. I feel honored and privileged to tender a vote of thanks on behalf of the Madhya Pradesh Nyayadhish Sangh and on my own behalf to all the dignitaries who have made it convenient to attend this inaugural session. At the outset, I would like to express my sincere thanks to our chief guest, Honorable Sri Justice Sanjiv Khanna, Judge, Supreme Court of India, for accepting our invitation and giving His Lordship's valuable time generously. Your Lordship has mentioned that your Lordship father was a civil judge who rose to become a High Court judge. Your Lordship also stated that your Lordship learned from your father and that your Lordship watched him closely. Your Lordship has therefore a close vision of the working of the district judiciary. Your Lordship therefore understands us much more than others. We feel you are there to guide us properly. My Lord's participation and insightful words, I'm sure, will bless us in the long run. Thank you, my Lord, for coming and blessing us. We also have the gracious presence of our distinguished guests of honor, Honorable Sri Justice Aniruddha Bose, Judge, Supreme Court of India, and Honorable Sri Justice J.K. Maheshwari, Judge, Supreme Court of India, who have been kind enough to accept our invitation despite their Lordships' busy schedule. We shall ever remain grateful to their Lordships for the motivation and invaluable guidance provided to us. Once again, I express my deepest gratitude to their Lordships for gracing this program. Thank you, my Lords. I convey deep regards and hearty thanks to my Lord, Sri Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. His Lordship has been extremely kind in providing motivational support and valuable guidance, which has helped us in shaping this conference. We are also heartily grateful to His Lordship's enlightening and thought-provoking address, as this will surely encourage the sessions to be followed. Thank you, my Lord. We are also thankful to the Honorable Judges of the High Court of Madhya Pradesh for gracing the occasion and blessing us. We are also thankful to the former judges of the High Court of Madhya Pradesh for gracing the occasion and blessing us. I thank all respected dignitaries whose presence has added warmth to this function. I'm also thankful to the participants for their fullest involvement. The success of this program depends upon the participation and interaction of the participants. Hence, I request all the participants to interactively participate in the program so as to attain the desired goals. I cannot thank everyone by name, but I must place on record appreciation to each and every person who have contributed for organizing this program. I sincerely hope that this conference will be meaningful with insightful thoughts and ideas of all who are involved. I'm sure that with our earnest endeavors, we'll be able to develop a roadmap for achieving the desired goals. As the theme of the conference is looking ahead, I sincerely hope that the Madhya Pradesh judiciary will keep looking ahead and move forward by each passing day. Thank you to all of you. Thank you.
Thank you, sir. With the permission of the dais, I declare the conclusion of the inaugural session. I now request everyone to kindly join us for the lunch, and the next session will resume at 2:30 p.m. Thank you.
I seek permission of Chair to commence the program. Thank you, my Lord. Ladies and gentlemen, warm greetings to all. I, Tabassum Khan, Civil Judge Senior Division, Jabalpur, welcome you all to the first academic session. In this session, we'll be deliberating on Vision 2047. To deliberate, we have with us today some very eminent panelists with deep understanding and experience in this area. I am honored to introduce our guests to you all. This session will be chaired by Honorable Shri Justice Vikram Nath, Judge, Supreme Court of India, and co-chaired by Honorable Shri Justice Sushruta Arvind Dharmadhikari and Honorable Shri Justice Vivek Agrawal, Judges, High Court of Madhya Pradesh. Honorable Shri Justice Vikram Nath was born on 24th September 1962. His Lordship enrolled with Bar Council of Uttar Pradesh on 30th March 1987 and was elevated as Additional Judge of Allahabad High Court on 24th September 2004. His Lordship took oath as Judge of the Allahabad High Court on 27th February 2006 and was elevated as Chief Justice of the Gujarat High Court on 10th September 2019. His Lordship was elevated as a Judge of the Supreme Court of India on 31st August 2021. As Chief Justice of High Court of Gujarat, he started live streaming of court proceedings, and thus his Lordship became the first Chief Justice of a High Court in India to broadcast live streaming of court proceedings on a YouTube channel. We are extremely delighted to have your Lordship amongst us. We are also honored to have amongst us Honorable Shri Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. Honorable Shri Justice Sushruta Arvind Dharmadhikari and Honorable Shri Justice Vivek Agrawal, Judges, High Court of Madhya Pradesh, are very well known to all of us. Commencing with felicitation, I would request respected Shri Alok Mishra, District Judge Sagar, along with Shri Yogesh Chalisa, Civil Judge Junior Division, to kindly welcome and felicitate my Lord Honorable Shri Justice Vikram Nath, Judge, Supreme Court of India, by presenting him a bouquet and a memento as mark of our respect and gratitude. Thank you, sir. I would request respected Shri Girish Dikshit, Special Judge Jabalpur, along with Shrimati Surbhi Katakwar, Civil Judge Junior Division Jabalpur, to kindly welcome and felicitate Honorable Justice Shri Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. Thank you, sir. I would request respected Shri Hiten Kumar Mishra, Special Judge Narmadapuram, and Sushri Aditi Mandloi, Civil Judge Junior Division, to kindly welcome and felicitate my Lord Honorable Shri Justice Sushruta Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh, by presenting him a bouquet. I request audience to please clap. Thank you, sir. To further ornate this gesture of felicitation, I now request respected Shri Dilip Gupta, District Judge Sivni, and Sushri Gargi Sharma, Civil Judge Junior Division, to kindly welcome and felicitate my Lord Honorable Shri Justice Vivek Agrawal, Judge, High Court of Madhya Pradesh, by presenting a bouquet. Thank you, sir. Honorable High Court of Madhya Pradesh has issued various circulars from time to time. These circulars are known to some of the judges, while most of them are not aware of the same, as a result of which they face hardship. The various circulars issued by High Court of Madhya Pradesh have been compiled and made available online on the official website of High Court of Madhya Pradesh for the convenient access of judges. I request the Chair, Honorable Shri Justice Vikram Nath, Judge, Supreme Court of India, to kindly release the manual of circulars by clicking on the mouse pointer. Thank you, my lord. May I have the video, please?
Searching for circulars is a difficult, time-consuming exercise for each judicial officer. Under the directions of Honorable Chief Justice Shri Ravi Malimath, the High Court of Madhya Pradesh has introduced the latest feature on mphc.gov.in, a comprehensive manual of circulars. This feature is designed to make it easier and faster to find circulars and related information needed by judicial officers. Let us see how to access this feature. Firstly, log into the website of Madhya Pradesh High Court, www.mphc.gov.in, with your username and password. Right under the dashboard, click on the tab named Circulars. Now you can see the search bar. Type in the keyword relating to the circulars you are looking for. You must click on the radio buttons and or phrase search to optimize your search. For example, for searching the circulars relating to 25 death scheme, we will type the keyword 25 old cases in the search bar and select the radio button and click on the search button. All circulars related to the keyword will appear in a tabular form. You can preview, print, or download it as per your convenience. The results are relevant, organized, and also include the title of the circular and their date of issue. Now, searching circulars relating to units, facilities and allowances, 25 debt scheme, etc., and all circulars related to the day-to-day work of judicial officers is less complicated. This excellent facility is a result of the vision of Honorable Chief Justice Shri Ravi Malimath to help judicial officers in their pursuit of excellence. Searching for circulars is a difficult, time-consuming exercise for each judicial officer. Under the directions of Honorable Chief Justice Shri Ravi.
Thank you. The Madhya Pradesh judiciary is poised to embark on a transformative journey, prioritizing swift dispensation of justice. Acknowledging the challenges faced by district judiciary in its daily operations is crucial for progress. Deliberations on these issues aim to propel us forward by identifying the viable solutions. This session serves as a platform to explore new possibilities and envision the future endeavors of MP judiciary. As we look ahead to 2047, our institutional goals include an efficient and accessible judicial system. My Lord, Honorable Shri Justice Vikram Nath is going to enlighten us on this crucial topic, that is Vision 2047. I request Honorable Chair, Justice Vikram Nath, Judge Supreme Court of India, for the opening remarks. So.
Thank you. A very warm good afternoon to everyone present in this beautiful hall. At the outset, before I start my address, I would like to thank the
Madhya Pradesh Nyayadhik Sangh, which has given this platform to each one of us to think, deliberate, and come up with a blueprint as to what would be the vision for 2047, that is 100 years of independence. I would also like to thank Honorable Chief Justice of Madhya Pradesh High Court for inviting me to this two-day conference and allowing me to chair a session with two eminent judges of this court, Brother Shri Justice Sushrat Arvind Dharmadhikari and Shri Justice Vivek Agarwal, along with 5 judicial officers of the Nyayadhish Sangh, Shri Krishnamurti Mishra, Director, MP State Judicial Academy, Shri Dhirendra Singh, Principal Judge, Family Court, Dhar, Shri Bharat Vyas, Additional Secretary, Law Department, Bhopal, Srimati Anu Singh, Civil Judge, Senior Division, Devas, and Shri Harshvardhan Dhakad, Civil Judge, Junior Division, Nagaur. All these distinguished panelists will of course enlighten you after some time of I finish my delivery. But after that we will have a open house discussion for as much time as we have left, because this is not something which 2, 3, 4, 5 or 10 people can decide about what would be the vision for 2047. But it will be a combined and a joint effort of all of us who are part of the judiciary. And I believe this initiative taken by this state will cover and encourage the other states also to follow up on this Vision 2047. And whatever roadblocks and difficulties we are facing today would not be there in 2057, and it would be much more accessible and efficient. So now, please bear with me for some time. Till now I was speaking without reading. Now I will do some reading work. Before that, addressing such a learned gathering of 1,500 judicial officers is a proud privilege for me. I honestly have no reason not to confess that I could never have cleared the examinations which you all have cleared, and you are here as judicial officers. As a judge of the Allahabad High Court, I have corrected copies of HJS examinations because that Allahabad High Court used to hold. And I have taken interviews for the judicial officers from the junior selection in the junior division cadre with the UPPSC, where one nominee from the High Court would be there. But I congratulate all of you for having been successful in clearing these examinations, and you are here. So I don't need to educate you. You are much more educated than I am. But at the same time, there are certain practical issues which maybe I have better experience or more experience, and I can help you out in case you come up with your questions in the open house session. And with all my panelists here, and we are also lucky to have the Honorable Chief Justice also. Although I was requesting him to leave us, but he doesn't want to, and he wants to make sure that I don't cut down on his program. So we are here for 2 hours. Everyone is ready? Good. So today, as we convene for the 10th Biennial Conference of Judicial Officers, we are not just participating in an event. We are part of a momentous occasion that shapes the future of our judiciary. The theme looking ahead aptly encapsulates our collective mission, a mission to forge a path for a judicial system that is not only resilient and robust, but also agile and anticipatory in the face of evolving societal needs. This conference is a remarkable platform for intellectual exchange and visionary thinking. It is a testament to the unwavering commitment and dedication of the Indian judiciary to uphold the rule of law and to strive for excellence in the face of myriad challenges. At this moment, it is pertinent to acknowledge the rich tapestry of Madhya Pradesh's history and culture, which seamlessly intertwines with its distinguished legal heritage. This heartland state, known for its architectural splendors like the temples of Khajuraho and the palaces of Gwalior, has been equally instrumental in sculpting the judiciary of modern India. The legal landscape of Madhya Pradesh, originally the central provinces under the British India, has been as varied and profound as its cultural heritage. The establishment of its High Court, initially at Nagpur, which later became the High Court for the newly formed state, marked a significant milestone in the state's judicial journey. This court's principal seat in Jabalpur has a monumental building blending Baroque and Oriental architecture, a testament to the state's historical grandeur and commitment to justice. The lineage of distinguished jurists from Madhya Pradesh mirrors the state's cultural depth. Justice Hidayatullah, not just a legal luminary but also a scholar, resonates with the intellectual richness that characterizes Madhya Pradesh. His tenure, along with those other eminent judges who have presided over the High Court, reflects the state's significant contribution to the legal and judicial evolution of India. In contemplating our future, particularly as we approach the centenary of our nation's independence in 2047, our goals are not just ambitious but necessary. Vision 2047 is not confined to the courts of Madhya Pradesh but extends to the entire Indian judiciary. It represents our collective aspiration for a system where justice is not only delivered but is seen to be delivered promptly and efficiently. Fulfillment of this aspiration needs navigation through complex issues, acceptance of some unpleasant truths, and overcoming multiple challenges. Mahatma Gandhi's words, "The future depends on what we do in the present," resonate deeply as we navigate through our sessions today. It is with a spirit of proactive change and innovation that we shall discuss and debate not just the hurdles we face, but also the vast opportunities that lie before us. My vision of the judiciary for 2047 would circumnavigate taking the Constitution of India closer to we the people. An effective, responsive, and efficient judiciary which ensures to the common man legal security, a promise enshrined in the Constitution. The Constitution cannot remain a document by and for lawyers alone and must truly seep into the lives of we the people in whose name it is enacted. Before talking about Vision 2047, it is a perfect opportunity to reflect upon the remarkable journey of Indian judiciary over the past 75 years, a journey marked by resilience, reform, and unwavering commitment to justice. Since 1947, Indian judiciary has grown from its colonial past to establish an independent system anchored by the Supreme Court, supported by 25 high courts and thousands of district courts and subordinate courts, all working towards justice in India. The courts have evolved to meet people's needs, introducing local languages in lower courts to make justice more understandable. The creation of fast-track and specialized courts for specific areas like violence against women or corruption has sped up justice delivery. In recent years, our judiciary has embraced technology, especially during the COVID-19 pandemic, courts quickly moved to online hearings, keeping justice going during the crisis. The e-courts project has brought major technological advancements like the National Judicial Data Grid, case information software, live streaming in courts, virtual courts, a new e-filing system, e-seva kendras to help lawyers and litigants both. This shift to a technological-driven approach has made our judiciary more efficient, transparent, and accessible, showing our commitment to evolving and providing justice for all. With this backdrop of how judiciary has changed so far, let us now carve a path to Vision 2047 and what should be our goals by the time this great republic of ours completes its century. To chart the course towards Vision 2047, a dual approach is essential. We need to first define our aspirations for 2047 and then delineate the means to realize these aspirations and ambitions. At this juncture, I must emphasize that a vision for the future must be grounded on the strength of the judiciary, founded on the faith and aspiration of the common man as the upholder of justice. A candid assessment of our progress in delivering justice to all is vital. This introspection will empower and equip the judiciary to fulfill its mandate of providing accessible and fair justice to every citizen, the very foundation of our legal system. To this end, I propose 5 key objectives for the judiciary to strive towards, serving as cornerstones for its commitment to the people. 1. Accessibility. 2. Independence. 3. Transparency. 4. Efficiency. And lastly, accountability. Vision 2047 should be firmly rooted in these 5 pillars. As we move forward, the realization of our 5 pillars will be furthered through specific transformative means. These include eliminating case backlogs, enhancing judicial strength and quality, integrating artificial intelligence in our judicial processes, adopting eco-friendly practices in our courts, and fostering the growth of informed litigants. The judiciary cannot fail to rise to the aspiration of the common man as an institution which dispenses justice. The oft-flung criticism at the judiciary relating to the delay in dispensation of justice is in one sense reaffirmation of the faith of the common man in the justice dispensation system. In order to achieve better accountability as well as efficiency in judiciary, at the forefront of our aspirations must be the complete elimination of case backlogs. By the year 2047, our vision should be a judiciary where no case remains pending for more than a year from the date of its admission. This goal, while ambitious, is a cornerstone in our quest for delivering timely and effective justice. The backlog of cases has been a long challenge for our judicial system, often leading to prolonged delays in justice delivery. This not only erodes public trust in our legal system, but also denies timely justice to those in need. Our vision for 2047 is rooted in the belief that justice delayed is justice denied. And it is imperative that we work collectively to turn this vision into a reality. The judge to population ratio is a major problem considering the growing population of India and the number of judges remaining the same and not increasing as the population is increasing. In India, there are 21 judges per million, which means approximately 1 judge for 50,000 people. This is a particularly concerning statistic given the judge to population ratio of countries like China have 100 judges for a million people. In USA, the ratio is 107 judges per million, whereas in UK it is 51 judges per million. Despite concerted efforts to increase judicial appointments, the volume of cases far outpaces the number of judges, leading to delays and impacting the quality of justice. The evolving nature of disputes, encompassing areas like cyber crimes and intellectual property demands specialized knowledge and agility from our judiciary. The complexity of these contemporary cases requires us to continuously evolve and adapt. I also believe that a change is needed in the litigation policy for the state. It is crucial that government institutions do not take up frivolous and petty cases, especially against retired employees and especially against class 3 and 4 employees for meager monetary disputes. These matters have a tendency to last for years, keeping the employees in limbo during the entire period. Additionally, it is imperative for the state to adopt a pragmatic and rational approach to litigation. At the onset of such legal proceedings, legal tribunals and departments should aim to deliver robust, well-reasoned decisions that firm against challenges. Drawing upon my tenure as the Chief Justice of Gujarat, I have observed a striking pattern. A significant portion of the High Court's workload, as much as 30% and much more before the district judiciary, is due to frivolous litigation involving state departments. Addressing and resolving these cases would markedly alleviate the court's burden. Furthermore, while the CRPC endows the authority to withdraw cases, this power is seldom utilized to its full potential in resolving or closing inconsequential and long-standing cases. In Gujarat, for instance, I can tell you with my own experience, around 30% of the cases pertain to prohibition matters and other petty matters covering additional 25-30% of the pending litigation before the district judiciary, many of which languish in the system for extended periods without substantial progress. The conviction rate for prohibition is less than 1% in Gujarat, and cases are pending for 30 years. They have not been able to find the accused, and the case is going on, and the magistrate is fixing a date after date, or it is on the dormant portal. But if you request the state to withdraw all these cases, they will not do it. We held a meeting with the Secretary Home, the Law Secretary, the DGP, and even the Chief Secretary. And we requested, why are you keeping all these matters pending? You invoke 320, 321 for political matters, withdrawing cases under 302 and 307. And here, these are petty cases where the fine and penalty would be, sentence would be 6 months or 1 year or 2 years. And you are not willing to withdraw. We gave them a list. Everything is now available on the data. Yes, we will follow it up, we will get the reports and everything. Thousands and lakhs of cases are pending in the district courts, especially officers dealing with criminal matters would be knowing that. I think the same would be the situation here, I don't know. So if the state proactively identified and eliminated such stagnant cases, it would not only streamline the judicial process, but also significantly reduce the litigation load throughout the country. A similar approach should be taken up throughout India by the various state departments. Imagine if 30% of your pendency of the district court is withdrawn. For ultimately, there is going to be no result in those cases. You don't even have the accused. Where are you going to get the witnesses and prove a conviction? It's all futile exercise. But the courts are flooded with those cases. It is high time that some policy should be taken up by the respective states, or maybe on the judicial side. I wanted to take it from the judicial side in Gujarat, but then the Chief Secretary and the Law Secretary said, sir, please don't take, wait, we will do something. They did nothing, and then I came here. Someday I get an opportunity, I'll definitely do it. I feel bad. Judicial officers are being asked, you are not deciding cases. How do they decide? The investigation is asking for time every day. And the file has to move, the officer has to write, has to sign, give a date. All the work increases. All that time can be utilized for doing more effective work. Anyway, just like that only. Let's see, we'll take this up seriously. And in any case, in a couple of years, I believe the state government will be put to task to take up all these cases, withdraw them. If you can't find, why, if you can't prosecute, why do you keep them pending? In addition, we must address the infamous practice of seeking multiple adjournments. Anyway, that's a very delicate issue, which inevitably leads to unnecessary delays. By limiting the number of adjournments and encouraging more stringent adherence to timelines, we can significantly expedite the judicial process. We must not be hesitant to even introduce, I don't know whether I should say this or not, radical rule changes such as prohibiting adjournments, not completely, but to limit them to a number. Especially in particular types of cases where encouraging community mediation and local dispute resolution can also be particularly effective in rural and remote areas. There is a need for closer interaction with the litigants and the community. Understanding the needs and challenges of those we serve is vital in ensuring that our reforms are effective and grounded in reality. A critical aspect to improve efficiency and independence amongst our ranks by the year 2047 is the enhancement of judge strength and the quality of recruitment. This endeavor is not just about increasing numbers, it's about enriching our judiciary with skilled, knowledgeable, and empathetic individuals who are committed to the ideals of justice. While increasing judge strength is essential, it must be done thoughtfully with an emphasis on quality recruitment. This involves not only selecting candidates with strong legal acumen, but also those who demonstrate a deep understanding of the societal context in which they operate. Our judges need to be equipped with not just legal knowledge, but also with skills in areas like mediation, technology, and an understanding of complex emerging areas of law. By 2047, I also hope and foresee a significant shift in our approach to judgment writing. Currently, our legal system often sees lengthy and complex judgments. My vision is a future where our judgments are brief, clear, and straightforward, applicable at every level of our courts, from the local courts up to the Supreme Court. Supreme Court also writes very long judgments at times. Anyway, not to comment. Jonathan Swift in Gulliver's Travels described a society where lawyers used a language so unique that it was incomprehensible to ordinary people. This scenario mirrors our current legal system, where the language used is often too complex for the average person. The legal jargon or legalese has been overly complicated for too long, making it hard for people outside the legal profession to understand. A judgment should be clear not only to lawyers, but also to the people it affects. If a judgment is hard to understand for those who seek justice, then it fails to serve its true purpose. We need to use simpler words and straightforward sentences in our legal language. Imagine how much time would you save if you don't have to write 10 pages and you have to write 2 pages only, and the result is the same. Be as brief as possible. I don't say don't spell out the relevant facts or don't decide the questions of issues raised, but then repetition of those things again and again ultimately enhances the length of the judgment, your time, and also the reader loses interest. If I am given to read a 200-page judgment, I would think, well, when I have time I will read, and I'll never find time to read a 200-page judgment. It's so difficult. But if the same thing is written in the law is laid down in 25, 40, 50 pages, maybe I will be, interested in reading it. Same, all of you write judgments in trials, session trials and everything. So many times we get judgments of 300 pages, 400 pages. Maybe sometimes it is necessary where there are 70, 100, 200 witnesses. But otherwise it's not necessary. And if on a point, one case law is sufficient, why should you quote 10 judgments and 10 paragraphs from each judgment for the same point? One, either the latest or the first one is good enough. And rest can be mentioned as referred to. Or simply mention that this has been continuously followed and lastly it was followed in this case. Or the last one. Anyway, all these things can be, we can save our time and utilize this for more active and, positive manner. Our legal documents also need to be better organized. They should be clearly structured with headings and subheadings and include summaries, tables, lists, and even charts and graphs. These changes are not just about looks. They are essential for making our legal documents easier to understand, This way, justice is not only done, but is also clear to everyone. Another point for consideration is the well-being of our judicial officers and the legal practitioners. The nature of judicial work is inherently demanding and often stressful. To ensure that our officers can perform their duties effectively and without detriment to their health, we must develop comprehensive wellness initiatives and support frameworks. This includes providing access to mental health resources, stress management programs, and creating an environment that encourages work-life balance. By prioritizing the well-being of our judicial officers, we not only enhance their quality of life, but also ensure a more focused, efficient, and compassionate judiciary. Judges, while being masters of law, must recognize that they are not experts in every field. It's essential that we, as part of the judiciary, embrace the expertise of professionals from various disciplines. This interdisciplinary collaboration is not a sign of weakness, but of wisdom and strength. It is pivotal for the enhancement and better management of our courts and judicial life. Incorporating management professionals can bring a fresh perspective and efficiency to our administrative processes. Their skills in organization and optimization can significantly improve the way our courts function. Additionally, for the effective management of our official and residential complexes, consulting with interior designs and space utilization experts can lead to more functional and efficient environments. This is not just about aesthetics, it's about creating spaces that are conducive to productivity and well-being. Furthermore, hiring professionals for rationalization and administration of court staff can bring about a more streamlined and effective operation. This approach ensures that every aspect of our judicial system is managed with precision and expertise, ultimately contributing to a more robust and efficient judiciary. As we envision India's judiciary in 2047, it is impossible to overlook the transformative impact of artificial intelligence in our legal system and how it can help make judiciary more accessible as well as transparent. The evolution from traditional legal practices to the integrated of advanced AI models like OpenAI's ChatGPT and Google's Bard is inevitable. Many in the legal fraternity have already started using these tools for document verification and brief preparation, symbolizing the beginning of a profound shift. By 2047, AI is expected to revolutionize the way our judiciary operates, addressing critical challenges such as case backlog and broadening access to legal assistance for those with limited financial resources. The application of AI in the legal sector will be multifaceted. There's somebody who's disturbing me here. Anyway, for judges and lawyers, AI will serve as an indispensable tool for legal research and case analysis, processing extensive information with unprecedented speed and accuracy. This will enable a more thorough and efficient review of cases, enhancing the quality of judgments and legal representation. Looking forward, while the potential of AI in autonomously handling minor legal cases is an exciting prospect, the indispensable human element in our judiciary, especially in major or landmark cases, cannot be overstated. The role of AI should be seen as complementary, not as a replacement, for the nuanced judgment and ethical considerations inherent in legal decision making. Moreover, AI in legal education will empower the next generation of legal professionals with a more comprehensive understanding of the vast corpus of legal texts. In embracing AI, it is crucial to recognize it as a tool that enhances rather than threatens the roles of legal professionals. By automating routine tasks, AI allows lawyers and judges to focus on the more complex and critical aspects of their work, improving overall efficiency and effectiveness. The transition to paperless operations and the construction of green courts facilities would be consequent to the adoption of artificial intelligence. These environmentally responsible practices align the judicial system with international ecological sustainability targets, reducing our carbon footprint and promoting a healthier environment. Green court facilities designed with energy efficiency and sustainability in mind not only benefit the environment but also offer healthier workspaces for our judicial officers and staff. The adoption of these technological and environmental initiatives signifies a shift towards a judiciary that is not only just and efficient but also ecologically conscious and adaptable to the future. As we embrace these changes, it is imperative that they are implemented thoughtfully. Over the years, the litigants, empowered by a surge in legal awareness and education, are becoming increasingly astute. Knowledge of the law, once the purview of a select few, is now spreading far and wide. Today, every citizen carries a spark of legal understanding, aware of their rights and duties. The growing of AI will also democratize legal knowledge, offering guidance, increasing accessibility, and answers to routine queries through AI-powered legal assistance bots. This will not only improve the understanding of legal processes for laypersons, but also make legal advice more accessible. It will mark a shift towards a more informed and intelligent litigant, and could even make the litigant representing himself as party in person a normal practice. As I conclude my address today, I do so with a firm hope and an unwavering belief in the visions we have outlined. I would like to thank Madhya Pradesh Nyayadhish Sangh for organizing this remarkable and forward-looking event. Engaging in the discourse of Vision 2047 in the company of esteemed judicial officers on such an exceptional platform is not only a significant milestone, but also a step towards a promising future. The Indian judiciary has been and will continue to be a fundamental pillar in shaping the fabric of our nation. It has profoundly impacted the lives of the Indian people and will persist in this vital role as we move forward. In 2047, as the Republic of India commemorates a century of independence, our judiciary's vision must evolve in tandem with the nation's growth. What we have discussed today, the elimination of case backlogs, the enhancements of judicial strength and diversity, the embracement of technology, and the commitment to environmental sustainability, these are not just goals. They are milestones on our journey towards a more just, efficient, and inclusive future. Vision 2047 is not just a dream, but a blueprint for action. It requires dedication, innovation, and a collective commitment from every member of the judicial fraternity. In this journey towards realizing our Vision 2047, the role of every individual within our legal ecosystem, from judicial officers and lawyers to court staff, is absolutely pivotal. Furthermore, achieving our ambitious goals requires not just passive cooperation, but proactive involvement from all stakeholders in the system. This includes not only those who administer the law, but also those who are served by it. As we conclude today's discourse, it's important to remember that the goals and strategies we have outlined are not comprehensive, but rather key benchmarks that, in my view, are crucial for us to aim for. They serve as stepping stones toward a broader, more inclusive future for our judiciary. In this spirit, I invite very warmly the other distinguished speakers to contribute their insights and visions. Let us stride forward with determination and purpose, ensuring that the Indian judiciary grows and flourishes alongside our great nation. Together, we will continue to shape a judiciary that upholds the highest ideals of justice and equality, mirroring the progressive spirit of India as it soars into its next century. Thank you.
Thank you, my Lord, for enlightening us with your Lordship's deep insight, vivid knowledge, and vast experience in this field. I now request Honorable Shri Justice Sushrut Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh, for the opening remarks. Sir.
A very good afternoon to all of you. Honorable Justice Shri Vikram Nath, Judge, Supreme Court of India, Honorable Justice Ravi Malimath, Chief Justice, MP High Court, Honorable Justice Vivek Agrawal, Judge, High Court of Madhya Pradesh, Honorable sitting and retired judges of the High Court of Madhya Pradesh, Shri Prem Singh Bhadoria, Chairman State Bar Council of Madhya Pradesh, Shri Sanjay Verma, President, High Court Bar Association, Jabalpur, judicial officers, ladies and gentlemen, I totally subscribe to what Honorable Justice Vikram Nath has said just now. Vision 2047 is a very important topic of discussion. I am deeply honored to stand before this distinguished gathering as a representative of the judiciary and address upon the pivotal role of the judiciary in our nation's journey towards progress and prosperity. As we embark on this academic session, envisioning the world 27 years from now, it is imperative to consider the profound impact of our decisions today we have on the generations to come. The judiciary, guided by the principles of justice and equality, holds a profound responsibility in shaping the future of our society. Guided by the beacon of the Constitution, the judiciary serves as a guardian of fundamental rights and liberties, thereby fortifying the very pillars upon which our nation stands. Upholding constitutional values and ensuring the equitable application of the law are paramount responsibilities that contribute indispensably to our nation's strength and resilience. One of the key elements empowering the judiciary in this journey is the integration of mediation. In a world where disputes can hinder progress, mediation provides a peaceful resolution mechanism, fostering harmony and reducing the burden of our courts. By promoting dialogue, understanding, and compromise, mediation not only resolves conflicts efficiently but also nurtures a culture of cooperation and unity, essentially for a thriving nation. Its role in nation building cannot be overstated, as it contributes significantly to the preservation of social cohesion and stability. We expect that by 2047, mediation in the judiciary would evolve into a primary method for dispute resolution. Advanced AI algorithms would assist mediators in analyzing complex cases, providing tailored solutions, and predicting outcomes based on vast databases of legal precedents and human behavior patterns. The process might become more accessible, efficient, and personalized, fostering greater satisfaction among parties involved. Additionally, virtual reality could enable remote mediation sessions, making it easier for individuals to participate from anywhere in the world. Ultimately, mediation might be seen as the first choice for resolving conflicts, offering a more human-centric and collaborative approach within the legal system. Moreover, the infusion of technology within the judiciary has been transformative. Embracing technological advancements enhances accessibility, transparency, and efficiency in legal process. From digital case management systems to online dispute resolution platforms, technology expedites legal proceedings, ensuring swifter justice delivery while catering to the evolving need of a technologically driven society. However, while technology and artificial intelligence streamline processes, the essence of justice must not be lost. The human touch, empathy, and the impartiality of judges remains integral in upholding the fundamental principles of justice. As we navigate the complex terrain of the future, the ethical conduct of legal professionals become increasingly crucial. Upholding the standards of integrity and ethical behavior is non-negotiable. A judiciary rooted in ethics is the cornerstone of a just society, and the judges must lead by example in preserving the integrity of the legal system. On the cups of 2047, let us envision a judiciary that not only interprets the law but also stands as a vanguard of societal progress, a judiciary that transcends boundaries, embraces innovation, and remains unwavering in its pursuit of justice for all. Thank you.
Thank you, my lord. I now request Honorable Shri Justice Vivek Agrawal, Judge, High Court of Madhya Pradesh, to kindly address the gathering.
Honorable Justice Vikram Nath, Judge, Supreme Court of India. Honorable Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. Honorable Justice Sushruta Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh. Sister and brother judges, sitting and retired. Members of the District Judiciary, sister and brothers. It gives me a lot of satisfaction to stand before you because this topic has been chosen by Madhya Pradesh Nyayadhish Sangh, Vision 2047. Your choice of the topic and the arrangement of the sessions under 2 academic sessions, one dealing with the vision and another with the technology, and 3 technical sessions which encompasses most of the burning issues required to be tackled by the district judiciary, shows your commitment that you are already committed to achieve the vision of 2047. There is, because well begun is half done. Once you conceive this topic, once you imbibe yourself about thinking, then you have already begun your journey to achieve the goal. There is a special significance to me in this topic. 2047 is not only a watershed year where we will be completing 100 years of our independence, but that will also be a time when India will transform from a developing to a fully developed nation. We may be probably amongst first 2 world economic powers where there will be lot of expectation from the Indian judiciary to dispense justice in time so that the economic momentum which is required to be gathered and which is many a times stopped because of judicial delays can be overcome and we can become a partner in India becoming a world power. Therefore, this topic has a special significance. Another issue which is ingrained in your subject is looking ahead. To best of my understanding, that looking ahead also means looking around and looking within. When you look ahead, you not only look ahead, but you look within. There is a theory called looking glass, self-glass theory. That theory propounds that to make any change, one is required to have a deeper in look, so to understand the complexities in our behavior, complexities in our functioning, and then to decide how to overcome them with the concerted effort of the society. We are not only required to look within, but look around. We are required to gather opinions of the people who are the stakeholders in our work. Therefore, this is a time when we should begin to take opinions of the society for which we are working and delivering justice. This is also a time of self-evaluation and facing the challenges arising out of social engineering, where one is required to balance merit with equanimity. We are also required to see that how marginalized persons are reached to, how we are able to achieve gender neutrality, how we deal with our differently able population, and how we deal with our juvenile and children. Children are future of this India. There is a famous saying that child is a father of man. That means that we will have to invest in children of this country so that we can achieve our vision of 2047. We are also required to understand that how system works. Legal literacy is to be taken to a higher level. We'll have to take inputs from the society about their perception. Here, the use of technology will be very crucial. People are talking about use of AI, but we'll have to understand that how AI and to what extent AI can help us. Machine learning is one of the finer aspects of artificial intelligence. Machine learning deals with creation of statistical algorithms so that we can understand the repetitive nature of work, and that work can be sorted out through the use of those algorithms. In court functioning, we see that many a times same kind of issue requires attention again and again because there is lack of bunching of similar nature of issues. Thus, technology can be used to begin with to bunch the matters involving similar or same issues so that that repetitive effort can be reduced to a great extent. The vision of Honorable the Chief Justice is to reduce the pendency to 1 year, that a case which begins should finish within a year. That to achieve that, we are required to have not only better perks, but a better commitment towards the system. I don't wish to insult anybody, but I was part of Transparency International, and a comprehensive study was carried out by Transparency International, which is an international body, that when Fourth Pay Commission recommendations were implemented by the then Prime Minister in 1986, the common perception was that with the increase in pay and perks, the position of India in the list of corrupt countries will considerably improve. But when the next time this exercise was to be undertaken, it was found that position of India in the list of Transparency International had come down. Therefore, this is a mild and sober reminder to all of us that perks are only to provide you an environment to work better, but that commitment, that drive to work better should come from within. Another challenge will be to have a faceless litigation. It is a common management study that wherever the system is allowed to work faceless, there is substantial reduction in different forms of aberrations. And therefore, we will be also thriving to achieve a faceless litigation system by 2047, where we are able to reduce the human interaction with the faces, so to reduce the bias in the system which already exists and which we cannot deny in the true sense. Then another challenge will be reaching to the poorest of poor. I think when we will be celebrating 100 years of our independence, we will be remembering our father of the nation and the other flag bearers of the independence movement who had a dream of wiping out tears from the eyes of the poorest of the poor. The system which works today is working in the favor of society which is in a better position rather than underprivileged or marginalized section of the people. There are several welfare measures which are undertaken, but if a comprehensive study is undertaken, then that will reveal, as my practical experience makes me to say, that benefits have yet not reached to the marginalized section of the society. So when we see 2047, we'll have to also see that these benefits are actually given to a marginalized section of the society. Then for a judge, it is not just a career or profession, it is a commitment, and that commitment should actually translate in terms of the Maslow's need hierarchy theory, which is a famous management theory which prescribes and which motivates a person after achieving physical needs. One should thrive to achieve the need of self-actualization. So another challenge for the young generation will be, and for all of us will be, to have a feeling of self-actualization and look back and see that what we have actually given to the society in terms of what we are receiving from the society in the form of such a hefty pay and perks. There will be also, I also see a shift in the nature of litigation. I also see a shift in the working conditions. There will be not only spatial changes, but also changes in the form of demand on the judges in 2047. We should start preparing for those changes, otherwise that may be a shocker in the future. I also feel that judges will have a greater role in establishing a stable society and resolving conflicts between different castes, creeds and religion, conflict between various interest groups, and we will be ourselves required to upgrade ourselves constantly, both in terms of knowledge and sensibilities towards the society, to achieve the goal of 2047. With this, I hope that other speakers will follow and explain these concepts in better details. Thank you.
Thank you, my lord. Setting institutional goals for the year 2047 with a focus on building an efficient and accessible judicial system reflects a long-term vision. We have 5 eminent panel speakers amongst us for deliberation on this issue. I firstly invite respected Shri Krishnamurthy Mishra, Director, MP State Judicial Academy, for the first presentation.
Honorable Shri Justice Vikram Nath, Judge Supreme Court of India, Honorable Shri Justice Ravi Malimath, Chief Justice of High Court of Madhya Pradesh, Honorable Shri Justice Sushruta Arvind Dharmadhikari, Judge High Court of Madhya Pradesh, and Honorable Shri Justice Vivek Agrawal, Judge High Court of Madhya Pradesh, Honorable sitting and former judges of the High Court of Madhya Pradesh, President and office bearers of the Madhya Pradesh Nyayadhish Sangh, all the judicial officers of Madhya Pradesh, ladies and gentlemen, namaskar and good afternoon to all. It is indeed a great privilege and honor to be a very first panel speaker in today's conference. The theme of conference is looking ahead, and it would not be an exaggeration if this topic be called the soul of the conference. Today in this session, we try to explore new horizons for Madhya Pradesh judiciary. In the year 2047, India will be celebrating a century of independence, 100 years, maybe more than an entire lifetime of an individual, but so far as a nation is concerned, a 100-year-old nation is considered to be a young nation, and a nation like India with the maximum population of youth still is one of the youngest, yet one of the steadfast democratic republics. Distancing modern independent India from its colonial past was not an easy feat. The judiciary was also confronted with many challenges over this 77-year period. The Supreme Court distinguished itself by ironing out many wrinkles and merging welfare with the rule of law. The courts have played an important role in ensuring that the rights enshrined in the Constitution are not a dead letter. It is because of these reasons that today we thrive as the largest democracy governed by a written Constitution. The Indian Supreme Court has immensely contributed towards the establishment of a constitutional culture in the nation. As we are aware, in the year 2022, Azadi Ka Amrit Mahotsav was celebrated, and the duration from the year 2022 to 2047 is being called as Amrit Kal. In the upcoming 23 years, we not only as a nation, but each one of us is individually responsible to make all possible efforts to ensure the perception as an ideal nation can be achieved. As India embarks on the journey of 100 years of freedom, 23 years from now, the main thing to focus is the importance attached to the development of the judiciary. What kind of judicial system would we like to see? How do we make our judicial system so capable that it can fulfill the aspirations in 2047? These questions should be our priority today. Framing a blueprint for the future is impossible without taking a glance back to the past. The foundation of modern structural system of justice delivery in Madhya Pradesh can be traced to 1861, that is almost 160 years. An institution with such a glorious past and which has ensured that the justice is rendered even in the most challenging times, the plan for the future must be so that the institution reaches new heights. Without identifying the hurdles in the path, there is no way to confront them. This brings me to the various challenges before the judiciary. Before these can be categorized into two groups, the first relate to issues before the judiciary due to changing times. I call these new challenges, although some of them are already being faced by us. These include issues such as necessity of domain expertise, absence of well-considered legislation, non-cooperative executive, dysfunctional criminal justice system, new threats to the judiciary, and increasing judicial resilience. The second category relates to perennial issues before the judiciary. These are issues that have been a concern for many years. Much has already been said about them. Despite this, I am highlighting these challenges again because they require immediate resolution. I call these challenges persistent challenges, and they are as improving judicial infrastructure, filling judicial vacancies, ever-increasing caseloads. First thing first are the lack of domain expertise. Due to the rapid development of science and technology, new types of problems and cases are coming up every day. Sale of illegal material on the dark web, identity theft, fraudulent online transactions, hacking, spread of defamatory content, and hate speech, etc. are all challenges that we must confront. Apart from changing dimensions of criminal law, there are also new and complicated civil law issues that have arisen due to advance in technologies. These are all transforming the legal landscape and require judges and other authorities to have vast technical knowledge. Our understanding and the law cannot lag too far behind changing technology. We are still discussing issues related to internet, while technologists are talking about the metaverse. The complexities involved and in adjudicating such cases necessitates the co-opting of technical members. However, no such provision is to co-opt expert is available to the judiciary. Talking about the absence of well-considered legislation includes, while making laws, legislature must also think of providing effective remedies for issues which may arise out of the law, but these principles seemingly are being ignored. Recently enacted acts like the Protection of Women from Domestic Violence Act 2005 is one such example. Unrefined law leads to a mushrooming of litigation. A proposed law can only be refined through the involvement of all stakeholders and through meaningful debate. Non-cooperative executive is another matter. Courts do not have the power of the purse or the sword. Court orders are only good when they get executed. Another issue is dysfunctional criminal justice system. There is a need to liberate the institution of public prosecutors. Total independence must be granted to them and to make them answerable only to the courts. A holistic rework needs to be undertaken. In order to insulate the public prosecutors, an independent selection committee may be constituted for their appointment. Another facet of the criminal justice system that needs to be changed relates to investigators. There is absolutely no system of accountability in place of faulty and inordinate delayed investigations. An altogether independent and separate investigation as well as process-serving cell is the need of the hour. Judicial resilience is something on which each one of us needs to think and rethink. The main challenge is to turn it into an effective system. For the same, courts, litigants, and advocates must be equipped with adequate infrastructure across the country. Unfortunately, this is not yet in place. There is a wide gap to be bridged. Advocates and litigants who are from rural areas, smaller towns, or who are economically weaker are disadvantaged and excluded. They have suffered immensely. Now, coming to the perennial issues, the most significant one is the issue of infrastructure. The current state of judicial infrastructure is terrible, to say the least. It does not even meet the requirements of already existing judicial officers. It is disheartening to state here that the basic necessities, even restrooms, are not available. The courtrooms in some places are so small that even 5 people cannot stand comfortably. Judicial officers are expected to deliver the best of their work in this situation, and they are trying hard to do so. To meet the present and future needs, a major influx of funds and a systematic plan is imperative. The appointment of judges is a continuous process. It is expected that the government needs to strictly adhere to the timelines laid down in the Malimath case. The process to fill vacancies must be accelerated at the institutional level too. An important aspect worth highlighting relates to improving the service conditions of judges to attract the best talent and fill vacancies. Even after 2-3 decades of service in the judiciary after retirement, judges are not given basic security, housing, or health care. If we are deliberating about a strong, vibrant, and independent judiciary, these must also be deliberated upon. I have consciously decided to address the issue of pendency towards the end of my address. This is because I believe pendency is the most complicated and misunderstood topic. Pendency relates to cases which have not yet been disposed of. Without any reference to the period it has spent in the system. Delay relates to cases which have been in the system for a period longer than what is generally required. Every delay is not an arrear. Some delays might be due to valid reasons. Unwarranted delays are arrears. Backlog refers to a situation where the number of cases instituted in a period is more than the number of cases that were disposed of. Tackling judicial delay refers to reduction of arrears and backlogs. The overall pendency of cases in the state of Madhya Pradesh by the end of the year 2023 is 20,89,042. The institution of new cases in 2023 was 14,13,462. And the disposal during the year 2023 was 13,98,691. The data in itself reflects that we have a surplus of 14,771 cases in the last year itself. The recent trends of last 5 years indicate that there is a surplus between the yearly institution and disposal. The population of India, which is nearly 104 billion, and the judge to population ratio is 21 judges per million, must be kept in mind. Same as this in relation to the state of Madhya Pradesh. Target recommendations by the Law Commission report is 50 judges per million. That means we are working with the less than half of this strength. Therefore, attributing this issue only to the judiciary is only viewing one side of the coin. To resolve this challenge, we need to view the larger picture. We need to have a roadmap so as to fulfill the aspirations, and for that, we need to fix our goals today. The goals may be categorized as long-term and short-term. The short-term ones may be those which we deal on day-to-day basis or weekly or monthly or maybe yearly basis. Once we achieve these short-term goals, we are already at the verge of achieving long-term ones. It is high time now to overcome mediocrity and strive towards excellence. Coming to the setting of the goals, I will take up the issue that was referred in last. First and foremost is the magnanimous pendency of cases. To reach the goal of no 1+ year case in any court by the year 2047, we need this surplus to go in negative. To cope up with the pendency of cases, one such short-term goal that was set up as 25 debt scheme, which was the brainchild of our Honorable Chief Justice. Successfully achieving the short-term target each year will bring us to closer our perception of ideal pendency in each court. Now, we aspire that no court in Madhya Pradesh should have any pending case for more than 1 year. Due to the increasing backlog of cases in the traditional legal system, there is a need to explore possibility of alternative dispute resolution methods. Mediation and ADR are important tools for settlement of pending cases in the courts, especially at the local levels. Pendency is a complex issue. It can only be resolved through a multi-pronged approach. Judges should identify their own approach to dispose of a case expeditiously. Timelines should be adhered to. Judges should be strict with respect to adjournments. Additionally, technology should be effectively utilized for case management purposes. As we deal with mounting caseloads and calls for greater transparency, artificial intelligence can emerge as a valued ally. Technology is changing many industries, including the legal field. Legal technology tools such as artificial intelligence, machine learning, data analytics, and cloud-based platforms can simplify legal research, contract management, case management, and document review, making legal process more efficient and cost-effective. As the legal environment becomes more complex, the importance of specialization in some areas is expected. This includes areas such as intellectual property, cyber security, data, privacy, etc. Companies navigate complex legal frameworks and regulations. There is therefore a requirement of domain expertise. We not only need highly trained judges and lawyers well-versed in fundamental legal principles, but also those with an understanding of development across various fields. It is in this spirit that at the behest of the Honorable Chief Justice, Madhya Pradesh State Judicial Academy has organized training programs and conferences not only for judicial officers but also for other stakeholders, including advocates. It is necessary to have continued judicial training from technical experts. So far as improvising the infrastructure for this purpose of judicial training, it is worth mentioning here that taking into consideration the increasing number of judicial officers, our visionary Honorable Chief Justice and patron, Madhya Pradesh State Judicial Academy, has meticulously monitored the proposal of the new building of the Academy and made sure that the design of the Academy is such that it would suffice the needs of the institution not only up to 2047, but far many years ahead of that. The new motto given to the Academy by Honorable Chief Justice is Pursuit of Excellence. And it goes without saying that Honorable Chief Justice is determined to achieve excellence in each facet. Transitioning to a litigant-centric judiciary is the need of the hour. To determine what ought to constitute the comprehensive policy, a determination of the core principle of the judiciary is essential. 6 principles that are essential to a good justice system and should form an integral part of how the judiciary envisions itself. These are accessibility, efficiency, accountability, transparency, independence, and inclusivity. The dawn of 2024 is a particular interesting for this discussion. India is over 75 years into life as a constitutional democracy, and enough markers, social, political, economic, exist to examine whether our constitutional promises have been sufficiently secured and upheld for all our people. Ultimately, what is essential is for the judiciary is to be quick to adapt and be flexible to resolve any challenges that comes in its way. The only constant in life is change. Only by resolving issues and challenges, we can maintain the credibility and legitimacy of the institution. It must also be understood that the success and failure of any organ is not dependent solely upon it. All of us are stakeholders in this judicial enterprise. When we fail to meet new challenges, we betray the constitutional trust imposed on us by the people that we are meant to serve. Therefore, at last, I will point out 10 visions for Madhya Pradesh judiciary as the long-term goals by the year 2047. Madhya Pradesh judiciary must be driven by a human, reformative, and right-oriented justice system. It must have better engagement with the stakeholders and mechanisms to assess progress. It must have accountability frameworks to monitor all stakeholders. It must evolve to the robust framework for judicial education and training of all stakeholders. It must protect and promote independence. It must fully utilize its judicial capacity, resulting in optimum pendency in each court. MP judiciary must have modernized and accessible infrastructure. It must have an efficient administrative machinery. It must have a mechanism to promote diversity and heterogeneity. It must uphold the ideals of an open judiciary. हमारा लक्ष्य बहुत बड़ा है, तो निश्चित ही मार्ग भी सुगम नहीं होगा. अनेक कठिनाइयां भी आएंगी. ध्येय अगर ऊंचा हो, तो उसको पाने का संघर्ष भी उतना ही बड़ा होता है. परंतु यदि आज हम सामूहिक रूप से संकल्प कर लें और अपने लक्ष्य को पाने के लिए समर्पित होकर पुरुषार्थ करने के लिए जुट जाएं, तो मुझे विश्वास है कि वर्ष 2047 तक हम अपने लक्ष्य को प्राप्त करने में सफल होंगे. हमारे संकल्प का बहुत बड़ा महत्व है और एक कवि के शब्दों में, संकल्पों से ही जीवन की दूर हुई हर बाधा, संकल्पों ने ही मानव का संकट में हित साधा, संकल्पों की दूरदृष्टि से राह प्रगति की दिखती, संकल्पों की कठिन लेखनी भाग्य मनुज का लिखती, पूरी होती संकल्पों से मन की 100 चाहें, आसमान भरती अपनों में संकल्पों की बाहें, लक्ष्य स्वयं ही संकल्पों से पास चले हैं आते, दृढ़ निश्चय वालों को पथ से मुड़ नहीं भटकाते, अंधकार हो दूर जगत से सबको मिले उजाला, मन अपना सबका हित सोचे शुभ संकल्पों वाला. थैंक यू वेरी मच.
Thank you, sir. I invite respected Shri Dhirendra Singh, Principal Judge, Family Court Dhar, for the presentation. Looking to the paucity of time, I humbly request our speakers to kindly adhere to the timings.
I request the honorable speakers, because of the paucity of time, with the permission of the chair, I request you to make fine points instead of going through the text, and try to finish it with less than 5 minutes so that we have more time for the open house discussion.
Sir. Honorable dignitaries on and off the dais, respected member of the Madhya Pradesh Nyayadhish Sangh. Namaskar and a very warm welcome to all of you gathered here today to deliberate on a topic of immense importance, Vision 2047. As we stand on the cusp of centenary of our independence, it is both an honor and a responsibility to reflect upon the path of our judicial system must tread in the coming decades. The vision we articulate today will shape the future of justice in our great nation. As we envision the future, it is imperative to build upon this legacy while addressing the challenges of the 21st century, because a free society exists only so long as it is governed by the rule of law, the rule which binds the governors and the governed. Because of the paucity of time, I am presenting only the main points of my speech. While the Indian judicial system serves as the bedrock of justice in the country, it is not without the challenges. And the main challenges are backlog of cases, insufficient judicial infrastructure, shortage of judges, procedural delays, lack of modern case management system, limited access to legal aid, and geographical disparities. जैसा कि आप सभी जानते हैं कि मध्य प्रदेश आदिवासी बाहुल्य राज्य है और यहाँ बहुत सारे ज़िले ऐसे हैं जहाँ पक्षकारों को न्यायालय तक आने के लिए 100-150 किलोमीटर की यात्राएं करना पड़ता है। ऐसे पक्षकारों की समस्याओं को दूर करने के लिए ग्राम न्यायालय अधिनियम की कल्पना की गई थी और मध्य प्रदेश में भी ग्राम न्यायालय अधिनियम स्थापित किए गए हैं। बट निश्चित रूप से ये बहुत खेद का विषय है कि मध्य प्रदेश में ग्राम न्यायालय अधिनियम का उचित रूप से निष्पादन नहीं हो पा रहा है, क्रियान्वयन नहीं हो पा रहा है। और जिस उद्देश्य के लिए इस अधिनियम की स्थापना की गई थी और ग्राम न्यायालयों की स्थापना की गई थी, उन ग्राम न्यायालयों के माध्यम से वो उद्देश्य पूरा नहीं हो पा रहा है, क्योंकि अधिकांश ग्राम न्यायालय जिला या तहसील के मुख्यालय में काम कर रहे हैं, जबकि उनको ये कार्य दिया गया था कि वो 2-2, 4-4 पंचायतों के क्लस्टर बनाएं ग्राम न्यायाधिकारी और गाँवों में जा जाकर जिनके लिए ये अधिनियम बनाया गया है उनके पास जाकर न्याय आपके द्वार की संकल्पना को साकार करें। लेकिन दुर्भाग्य का विषय है कि अभी हमारे यहाँ ये संकल्पना साकार नहीं हो पा रही है। तो जो हमारे साथी ग्राम न्यायाधिकारी के पद पर पदस्थ हैं, मेरा उनसे अनुरोध है कि वो ग्राम न्यायालय अधिनियम के मूल उद्देश्यों के अनुसार कार्य करना प्रारंभ करें। दो 2024 की आज ये जो बैठक हो रही है, इसमें हम 2047 के बारे में जब चिंतन करते हैं तो अब हमको ये देखना भी आवश्यक है कि 2047 कैसा होगा, क्योंकि जिस हिसाब से टेक्नोलॉजी में परिवर्तन हो रहे हैं तो निश्चित रूप से वर्ष 2047 में तकनीकी रूप से बहुत तीव्र परिवर्तन हमको देखने को मिलेंगे। एंड फॉर अ रोबस्ट जुडिशरी, ट्रांसपेरेंसी एंड अकाउंटेबिलिटी आर वेरी इंपॉर्टेंट फैक्टर्स। इन 2047 वी एनविजन अ जुडिशरी where proceedings are not only open to the public but are also easily accessible through digital platform. The use of technology in court reporting and case management will enhance accountability and reduce the scope for corruption. यहाँ पर करप्शन का शब्द सुनने में चौंकने की आवश्यकता नहीं है, क्योंकि मैं यहाँ आर्थिक भ्रष्टाचार की बात नहीं कर रहा हूँ। मैं यहाँ पे अधीनस्थ न्यायपालिका के दूसरे तरह के एक भ्रष्टाचार की बात कर रहा हूँ। डेली वर्किंग में अनावश्यक स्थगन प्रदान करना, ये भी एक तरह का भ्रष्टाचार है। प्रकरण की जटिलताओं से घबरा के लंबी पेशी देना, ये भी एक भ्रष्टाचार है। न्यायिक कार्य के प्रति उदासीनता प्रदर्शित करना और जो नवीन वैधानिक परिवर्तन हो रहे हैं उन परिवर्तनों का संज्ञान नहीं लेते हुए वही पुराने तरीकों से प्रकरणों का निराकरण करना। और सबसे बड़ी बात, अपने काम को बोझ मानना। मेरी दृष्टि में ये जो 4-5 काम हैं, ये न्यायिक भ्रष्टाचार के उदाहरण हैं और इस तरह का न्यायिक भ्रष्टाचार अभी भी हमारे बीच में व्याप्त है। और अगर हमको 2047 के टारगेट पूरे करने हैं, उन लक्ष्यों को प्राप्त करना है, तो इस तरह के न्यायिक भ्रष्टाचार से हमको अपने आपको सभी को मुक्त करना पड़ेगा। जहाँ तक स्विफ्ट जस्टिस का प्रश्न है, निश्चित रूप से स्विफ्ट जस्टिस बहुत ज़रूरी चीज़ है और यहाँ पर मैं अपने मध्य प्रदेश में पिछले 2 वर्ष से जो 25 डेट स्कीम चल रही है उसका उल्लेख करना भी ज़रूरी समझता हूँ। निश्चित रूप से जो हमको 100 पुराने केसों के टारगेट मिल रहे हैं, उन टारगेट को अचीव करने के लिए हमारी न्यायपालिका के सभी सदस्य जी जान से लगे हुए हैं और लगभग पिछले वर्ष 95% टारगेट हमने अचीव किया है। तो इस तरह हम पिछले वर्ष लगभग 1.5 लाख के पुराने केस निराकृत करने में सफल हुए हैं और निश्चित रूप से अगर यही गति हमारे कार्य की रही तो जो 2047 का हमारा जो मेन लक्ष्य है कि 1 वर्ष से पुराना कोई केस बाकी नहीं रहना चाहिए, तो निश्चित रूप से हम उस टारगेट को प्राप्त करने में सफल रहेंगे। For this vision 2047, a balanced judiciary is also needed, and balanced judiciary in India is not a mere aspiration. It is a foundational pillar of a thriving democracy. Judiciary's commitment to impartiality, protection of constitutional values, and accessibility to justice is paramount. As the nation progresses, it must continually strive to reinforce the delicate balance that ensures the judiciary remains an unwavering beacon of justice, earning the trust and confidence of the diverse citizenry. In achieving and sustaining this equilibrium, India secures not only the principle of its constitution, but also the bedrock of a just and equitable society. So how do we make our judicial system so capable that it can fulfill the aspiration of India up to 2047? These questions should be our priority today. Our vision in Amrit Kal of our independence should be of such a judicial system in which there is a easy justice, speedy justice, and justice for all. So in the spirit of a progressive and inclusive India, let us collectively work towards a judiciary that not only dispenses justice, but also fosters a society where every citizen can live with dignity, equality, and freedom. May the vision we articulate today be a guiding light for generation to come. Jai Hind. Thank you.
Thank you, sir. I now invite respected Shri Bharat Vyas, Additional Secretary, Law and Legislative Affairs Department, Bhopal, for the next presentation.
The future is not some place we are going to, but one we are creating through our act in present. Honorable dignitaries on the dais and off the dais, a very good afternoon to all. I believe that to become a developed nation for a country like India, that is Bharat, need an unbiased, strong, and independent judicial system. Madhya Pradesh judicial services are always leading in each and every sector of dispensing justice to the domicile of the state. The High Court of Madhya Pradesh is always keen to develop a great work culture and also leading in disposing of cases and providing access to justice system to each and every domicile of the state. In state of Madhya Pradesh, after around 8 rounds of scheme of 25 old cases, the pendencies decreased a lot, but still we have the pendency issue, and the heavy pendency in few districts hamper the swift dispensation of justice. We need to see the tendency of hike in population and criminal cases, for which data of Madhya Pradesh Police Academy compiled in one study is very important. In 2001, the population of Madhya Pradesh is 603.85 lakh, which is increased to 848.08 lakh in the year 2021. Simultaneously, increase in the crime instituted in 2001 was 3,33,127, which is increased in the year 2011 by 3,35,430, and it again increased to 4,75,198 in the year 2021. I will like to draw the attention that from 2001 to 2021, the institution of crime has been increased by just 0.68%. But from the year 2011 to 2021, the institution of crime is increased by 42%. For that, we need to see that we have to dispose of cases in such a manner that incoming should be less than the outcome. So for that, we have many tools. We have to decrease the time in framing of charges, and a judicial officer must be cautious and to have to opt a proper mode of trial which leads to proper and early disposal of case. Calling a witness is taking much time for our court, so we have to need to adopt machineries like serving of summons through email, SMS, and other telecommunication mediums. We have to opt video conferencing and other source to take evidence. Now, increase in number, I will like to draw the attention on this slide that increase in number of judges are very essential. But for that, we have to see the data of year 2021. It is relating to institution of crime. We have seen that some districts like Shopur, previous slide please. Thank you. Shopur, Niwari, Umaria, Alirajpur having institution of case less than 2,000 cases per year, while district like Chhindwara, Sivni, Balaghat, Datia, Tikamgarh, Panna and Damoh having institution of cases between 2,000 to 5,000 annually, while districts like Indore, Bhopal, Sagar, Gwalior and Jabalpur having more than 10,000 criminal cases instituted per year. So we not only increase the number of judicial officers, but we have to redistribute them in such a way that where the number of cases are higher side, the judicial officer would be higher, and where the number of cases is at the lower side, the judicial officer should be less. Apart from pendency, another major issue is proper infrastructure. For that, the constitutional framework is as such that the judicial system is lack of financial autonomy. The judiciary need to coordinate with the executive to fulfill the financial need, and it imposes a serious limitation upon the possibility of crafting holistic solution from the entire judiciary. To grant justice at large till 2047, we hope that judiciary must get financial autonomy. Judiciary need not to face lack of budget for the infrastructure development. We must get a bigger and better part of a state budget from for our different financial need, and that the state must consider that the independence of judicial system, the financial autonomy is very much essential. The infrastructure plays the key role in ensuring the quality of justice delivery. One who visited the court recent past must be agree that now, at least in Madhya Pradesh, we have started building courtrooms with a litigant-centric approach. That means our building with respect to all stakeholders. Infrastructure plays a major role in facilitating or restricting participatory justice in courtroom. Till 2047, we will aim to build best quality infrastructure which will have modernized court complex that provide state-of-art facility to all users from the first point of interface till the exit of the court complex. Such facilities will extend to digital infrastructure within the court and e-court services relating to justice delivery. Improvement in digital infrastructure must not be limited just the hardware and backend software, but also to include a rethink and its internal process. There is need for standardization of process such as collection, processing, storage, and dissemination of personal data across the case type and the courts. Till 2047, Madhya Pradesh, which already has dedicated websites and a unique IT team, which has built many software for betterment of justice system, will lead to state by providing access to records, order, judgment of the court. Litigants need not to come to the court to attend proceeding, but through system of video conferencing and live streaming of the court proceeding, one will always be in access with judicial system and court will much approachable to last person of the society. To conclude myself, I will like to say that the future is a vast, dynamic and unpredictable domain. It is virtually impossible to know all the emerging issues or concerns that may conflict the court in 5, 10 or 25 years down the road. Planning for future must be ongoing as opposite to one-time activity. But we have to, step by step and day by day, have to work in such a way that Madhya Pradesh shall strongly believe that we will having a strong, fearless, independent judicial system which is working in such a dynamic way that the words like old pendency will extend from the legal glossary of each and every judicial officer of Madhya Pradesh. In the end, maybe many of us think that in 2047 it's a long time, इस प्रकार की चीज़ हो सकती है या नहीं हो सकती. मैं ये कहना चाहूँगा कि कौन कहता है कि आसमां में सुराग नहीं हो सकता, एक पत्थर तो तबीयत से उछालो यारो. Thank you so much.
Thank you so much, sir, for your enlightening thoughts. I now invite Srimati Anu Singh, Civil Judge Senior Division, Devas, for the next presentation.
Honorable dignitaries on and off the dais, respected seniors, dear brother and sister judges, ladies and gentlemen, a very warm good afternoon to all. In 2047, like all other citizens of India, I envision India as a technology-driven and knowledge-based developed country with strong and independent judiciary. In this India, strong, committed to the cause of justice and independent judiciary is pertinent. This moment allows us to revisit our dreams and expectations for the future. These expectations can't be summarized in few minutes, but by sharing their thoughts, my seniors made my task easy as they always do in the difficult times. As pointed out by my Lord Honorable Shri Justice Vikram Nath, my vision for the judiciary of 2047 is not only to have thriving infrastructure, but to have widespread adoption of renewable energy sources. It will provide clean and efficient energy. This shift towards the clean energy will reduce our carbon footprints. This can be one of our contributions to the sustaining the ecosystem. As pointed out by the Honorable Chief Justice Shri Ravi Malimath, that justice has to be real and speedy. And in his lordship's words, I quote, "Real and speedy are synonymous with the justice." I unquote. So my vision for 2047 is of administration of effective and swift justice. One more aspect of the effective administration of justice is execution of orders and decrees of the court. Recently, in the year 2021, while deciding upon a property dispute, a 3-judge bench of Honorable Supreme Court of India emphatically discussed the plight of decree holders and challenges they face in execution of the decree. In this landmark decision of Rahul S. Shah versus Jinendra Kumar Gandhi, 14 directions were issued to expedite the execution of decree. The direction aims to allow a decree holder to enjoy the fruits of litigation without an inordinate delay and unnecessary hurdles. The faith of citizens of India has been successfully carried out by our predecessors. It is now our turn to carry the faith reposed in the judiciary and ensure that this faith is fortified. So, I vision a system where effective justice is delivered swiftly. As we all know, reformative services or community services have been incorporated as one of the mode of punishment by Section 4 of Bharatiya Nyaya Sanhita 2023. Although it is yet to be implemented and results are yet to come. But this inclusion of a reformative aspect of punishment indeed gives a positive sign. As in many cases, we have observed that अपराध किया नहीं जाता हो जाता है, or in other words, it is the circumstances which leads to offense. This reformative justice delivery mode also encompasses the Gandhian philosophy. Curb the crime, not criminal. That is, पापी नहीं पाप को खत्म करें. I envision the optimum use of this reformative services for the better administration of criminal justice system in the developed India at 2047. The Vision 2047 attempts to foresight a growth story for the next 25 years. Easy dissemination of the case information to litigants through various service delivery channels like kiosk, web portals, mobile apps, emails, SMS push and pull have a great impact as they give administration of just citizen-centric. Honorable E-Committee of the Supreme Court of India has successfully rolled out Phase 1 and Phase 2 of E-Court project aimed to develop networking infrastructure and digitization of the process to provide easy access to information and different services. Honorable E-Committee has embarked on Phase 3 of the project with the noble aim of providing unhindered access to an efficient and equitable justice delivery system in an inclusive manner. I hope that all efforts to build a robust judicial infrastructure will pave the way for a futuristic judicial system. I envision that by adoption of AI tools and harnessing other technological advancements, we will be pioneer in the citizen-centric administration of justice. There are many challenges, but each of it can be addressed by determined efforts to pursue the future with a view of attaining excellence, endurance, and eminence. We have two excellent examples for the same. One is adaptation of technology during COVID-19 pandemic, and another is 25-day scheme. On his very first day in High Court of Madhya Pradesh, during the welcome ovation, Honorable the Chief Justice, Shri Ravi Malimath, in his reply to the pleasing reference from the bar, manifested in the clear words that, I quote, "My only endeavor has been to ensure justice is delivered, both real and speedy," I unquote. And with that vision, his lordship came up with the novel idea of 25-day scheme, and the results are evident. This scheme and its results leaves a pious hope that with committed and concerted efforts, nothing is impossible. In the futuristic vision of 2047, I see Indianization of the justice delivery system. By this, I not only mean simplification of the language and the procedure, but also a revisit to our ancient legal system, whose edifice rests on the Tadetat Shastrasya Shastram Yat Dharmaham Tasmat Dharmat Param Nasti, that the dharma that is law is the king of kings, and no one is superior to dharma that is law. Thank you. Jai Hind.
Thank you, Madam. I invite Shri Harshvardhan Dhakar, Civil Judge Junior Division, Nagaur, District Satna, for the last presentation.
Honorable and venerable judges on the dais, honorable judges of the dais, respected judges of the district judiciary. It is no exaggeration of veracity if I unlock my heart in the miracle of words that Madhya Pradesh judiciary, under the abled and passionate guidance of Honorable Shri Justice Ravi Malimath, the Chief Justice of Madhya Pradesh High Court, reigns supreme in the hierarchy of states of India. As we march towards the completion of 100 years of India's independence by 2047, the work which is being carried out in the last couple of years in Madhya Pradesh judiciary is not of an age but of all ages. It gives me great pleasure to present this little piece of prose among the galaxy of intellectuals, in other words, august body of judges. I am indeed fortunate to give my words and feelings and idea through this core conference organized here. At the outset, without wasting any time further as has been directed, it would be worthwhile to focus certain components of Madhya Pradesh judiciary such as technological growth, growing ADR mechanism, access to justice to all, skill enhancement through continuous training, environmental consciousness by resorting to paperless courts. Madhya Pradesh judiciary will also pave the way for a greater transparency in the district judiciary by live streaming its court proceedings, likewise Honorable High Court. The institution also aims at reducing the oldest and total pendency of cases to a significant number, thereby upholding the fundamental right of the litigants to have a speedy trial. Constant efforts will be made to sensitize the litigants and the advocates of the state regarding the gender sensitivity and inclusivity, cyber security, digital literacy, and pro bono initiatives. Furthermore, A data has been published by the National Crime Records Bureau about the criminal cases registered with respect to the crimes committed against the women at public places in Madhya Pradesh. The data shows that record number of 10,133 cases have been filed, which is about passing obscene comments on women at public places. Also, unfortunately, there is a steep rise in the number of POCSO cases, which leads to children attending the courts more often than not. And therefore, a special emphasis will be given in educating the children about the proceedings of the court through especially dedicated legal literacy camps under the aegis of Madhya Pradesh State Legal Services Authority. Similarly, it has been found that the state of Madhya Pradesh is burdened with the cases registered under POCSO Act, mostly in tribal parts of the state. And the common aspect about such cases is the fact that the boy and a girl below the age of 18 years marry each other without the knowledge of the law, punishing such an act, as girls' consent is no consent at all in the eyes of law. The aftermath of the act is heart-wrenching, as the boy finds him in a court as an accused who is mostly found guilty. This situation needs a behavioral rejig to curtail the augmenting number of such cases. With the aid of SALSA, providing legal literacy amongst the lower strata of the society will also have far-reaching ramifications in terms of the behavioral front of the society. The State Judiciary of Madhya Pradesh will not only be able to reach and provide an easy way to seek free legal aid, but the awareness would also help in curbing the crime rates. It pains me when I find children begging on the public roads. Our vision is to ensure the implementation of Juvenile Justice Act 2015 in true letter and spirit by 2047 to completely end the plight of the children. Time and again, the issue pertaining to providing legal aid to the needy has been raised. With the persistent efforts, we have ensured that no one is left without a legal aid. We not only aim to provide free legal aid, but it is the quality legal aid which is our priority today. And I'm glad to make you all know that the Honorable High Court has already started acting in this direction, and we are improving every day to achieve this vision of providing quality legal aid to the needy and marginalized. Certainly, when we think of having no 1+ year old case pendency by 2047, I must not forget about mentioning the importance of ADR mechanism. As has been suggested by honorable judges, it is the future of India which would help us in reducing the number of cases significantly, and thus giving rise to a humane approach as well, and it would somehow give a very good message to the society. So this should also be our vision, to provide as much as access relating to the ADR mechanism as we can. Lastly, I would like to say, in the words of Urdu poet Firaq Gorakhpuri, who says, बहुत पहले से उन कदमों की आहट जान लेते हैं, बहुत पहले से उन कदमों की आहट जान लेते हैं, तुझे ए ज़िंदगी हम दूर से पहचान लेते हैं. The theme of the conference, looking ahead, our topic for discussion, Vision 2047, and the above lines of the poet are drawing an uncanny similarity, which is about preparing, planning, and pondering in anticipation of an unseen future. And lastly, I would say that as an institution, we never shy from working very hard in the service of our nation and the people. This is quite evident that the results signify everything about us, that we are treading on a right path in order to achieve all what we have set for ourselves by 2047. Thank you very much.
Thank you, sir. The insights shared by our esteemed panel speakers during these deliberations will undoubtedly play a crucial role in shaping the vision for Madhya Pradesh judiciary on Vision 2047. Now, it's time to move ahead for open discussion session.
Dear officers of the Madhya Pradesh judiciary, before I throw the house, this session open to the house, I would request Honorable Chief Justice to also, bless us with a couple of minutes only, not very long, and then we'll.
Well, when the Supreme Court says couple of minutes, it has to be couple of minutes only. Can't be more than that. There's nothing more for me to add, except that the idea was to look at it on a much broader scale. Now we celebrated 75 years Amrit Mahotsav. What did we do as an institution? Nothing. 100 years after we get independence, what do we have to tell the country? Have we done anything? Or are we only interested in the third pay commission, perquisites to be increased? Is that the only thing that we are going to do? Can we not tell the country that we don't have any pendency in my state? That is the contribution that we should do to the country. And it's not something that's not achievable. It is something within your hands. And I say so, I write it on granite that you people can do it. I have seen your performance in the 25 debt scheme. Have you all not performed? It is the same set of judges, the same people, the same litigation, the same lawyer, the same clients. You have done it. You have cleared all those 25 dead cases. There are 56 officers who have done 100%. Congratulations. But many of you are almost there, 90%, 80%, 96%. That's fantastic. That only shows you have the capacity to do it. So you just need to push yourself a little. If you push yourself a little, you will be the finest judiciary in the country. If we are able to tell the country that Madhya Pradesh, there is just a 1-year pendency, how proud the country will feel of each one of you. It can't be done by one person. We all have to do it. You, me, everybody. And you can do it. I have this conviction. We'll start with that.
What a great motivator. Thank you, Chief Justice. And thank you, judicial officers of the Madhya Pradesh, for having performed so well. And your Chief Justice is so happy with you. So now, looking forward to 2047, what I propose is we will start from the officers of the junior division, because they are at least definitely going to be there in 2047. The district judges and the PDJs may not be. I am more concerned about 2047. So all the young officers who are in the junior division, please raise your hands. Very good. Upstairs. In the balcony. Good. Are there mics up there? Hello, organizers, are the mics there? In the balcony? Acha, in the meantime, you arrange for 2 mics for the balcony, and we'll ask some questions from the, the judicial officers, junior division, who are in the first class sitting here, to ask their questions. Yes, come on. Who's the first one to raise a hand? With a suggestion or with a question, whatever, to the 4 of us, we will try and answer it. Or maybe you have a suggestion for the Vision 2047, as we have just spoken, and we can hear you. Anybody? No one? See, you are failing your Chief Justice, and not only him, but me also. I said you are going to be there in 2047. Come on, come up. I thought girls were smarter than the boys. So, junior division girls. In Uttar Pradesh, the selection is out of 100, 60 girls and 40 boys. That's the issue. Far ahead. Oh, that's wonderful. And still see none of them speaking. Mr. Agarwal, your High Court. It is disappointing. Anyway, so in the meantime, you think, I'll come back to you. I'll now float it for the senior division officers. Who are all senior division, raise your hands. Who wants to say something or raise a question? See, this is a very comfortable panel sitting here. If you ask even a stupid question, there is nothing wrong going to happen to you. Ask something, whatever comes to your mind. Sometimes very many foolish and stupid things, ultimately result into very good things. You start. No one is asking. So this is The chief is appreciating everyone, and I can see fright on everyone. Nobody is even coming forward to ask a question. All right, PDJs and DJs have any questions?
May it please your Lordship. Lordship, I'm Kushum Hara Chakrabarti. I have a question.
Where are you? Please stand up.
Lordship.
Acha, there. Okay.
Lordship.
Yes.
Lordship. Lordship, with due humility and permission, I seek to be condoned if I make a mistake in humbly submitting my point. What the difficulty that we face while doing the our board part is that we are not sure while we fix the files for hearing, in which case the witness would turn up. So what happens is there are certain number of files, a plethora of cases are lined up before us, and we are not sure as to the time which it would take. Although it is up to the judge to control the time it takes, but often when we try to stop an advocate from asking unnecessary questions, it becomes a challenge. And when we don't have a time frame as such for cross-examination, sometimes cross-examinations, even in trivial cases, run in for days. So what happens is that we are unsure about how can we deal with this kind of problem, and how we deal, like the other cases automatically get adjourned for no fault of us or even these other stakeholders who are waiting for their turn. So this is my humble submission. How can we have a solution to this problem? Thank you so much.
It's a very good question. First of all, you should not feel apologetic. I think you have highlighted the problem of many of us, be it in High Court or be in District Court. Issue is that this has two basic dimensions. One is case management system. We all know that if 100 cases are coming on board, then all 100 are not going to be sorted out. So there is an element of probability which is to be assessed by a judge while fixing the number of cases on a particular day, that under different heads, say issues, charge, arguments on charge, evidence, final argument, you fix the cases in such a proportion that your board does not fail on that particular day and you are able to do substantial work. That is the art which is to be learned and which can be learned with some basic tricks which are taught in the academy and with your practical experience.
Yes, who's next? Yes, please.
Good evening, respected dignitaries. We, as a judges, are doing our best to dispose of the cases, but we all know that we are a kind of stakeholder in many other stakeholders for justice delivery system. We are putting our best to dispose of the cases, but at the same time, contribution of other stakeholders is as important as our endeavor is. So sometimes cases are not getting matured due to their non-cooperation, or suppose, sir, there are cases where it doesn't happen that all the things happen at the same time. Due to this reason, sometimes we take time in disposal of cases. Sir, as a responsible member of judiciary, we are doing our best, but sometimes we are failed due to non-cooperation of other stakeholders. Sir, how we can sort it out? Please let me know. Thank you. Thank you, sir.
That answer is to us or to the other stakeholders? Huh? The other stakeholders must answer your question. You see, what you mentioned may be very right. I mean, these are problems that every judge faces, not only this one problem. There are hundreds of problems that you face on a day-to-day basis. You as a judge sitting in your court, you should find your own ways and means to solve each one of these. And non-cooperation from the other stakeholders, that is a fact. We cannot deny that. But how do you ensure that it happens? That depends how good or how effective you are. So these are all day-to-day problems. It has nothing to do with anything else.
Here we are talking of how you are going to reach the 2047. You don't have to worry about any of the things. You just got to worry whether you are using every minute of your time for the betterment of the judiciary. That's all.
Sir, we are doing, and that's the result. His Lordship is appreciating our effort. Thank you, sir. Thank you very much.
Thank you, brother. Thank you. If you don't ask questions, I will start picking some names from here. I have a big list of all the officers. I've seen all your ACRs. I'll start calling out names. See, abhi aa gaya. Yes, please.
Kapil Dev, sir, from Narsingarh. श्रीमान, आप सभी के हृदय में विराजमान ईश्वरीय अंश को सादर प्रणाम करता हूँ. सर, we don't want anything, sir. We want only real independence, sir. We want only fearless judiciary, sir.
Kapil Dev ji. Sorry, you start.
Sir, we have all the powers, Shriman. सर, एक न्यायाधीश में सर सारे पावर्स अंतर्निहित हैं. उसके पास यदि सर समस्या है तो सर वो खुद उसके लिए जिम्मेदार है. वी वांट सर ओनली फियरलेस जुडिशरी. सर, सादर प्रणाम सर. सर, कुछ पंक्तियां श्रीमान. क्यों नहीं मिलेगी मंजिल, तू अपनी जिद पर अड़ तो सही. क्यों नहीं मिलेगी मंजिल, तू अपनी जिद पर अड़ तो सही. खुल जाएंगे सभी रास्ते, तू रुकावटों से लड़ तो सही. थैंक यू सर.
Mr. Kapil Dev, were you born before 1983 or after 1983?
Sir, my date of birth is 19th July 1993, sir.
93. So I suggest you must watch replay of 1983 World Cup.
Sir.
In a match against Zimbabwe, how your namesake Kapil Dev stood alone to get victory for the India. So these are the things to learn from history.
Sir, 2047 means 24 into 7 is equals to, sir, 365 days, Shrivan. So we make it possible before 2047, Shrivan. Sadar Pranam, sir.
Is there any other Kapil Dev?
Honorable Sir, myself Vinayak Gupta, I am presently posted as Civil Judge Senior. May I go ahead, Your Lordship? Your Lordship, I am Vinayak Gupta, Civil Judge Senior Division, Ujjain, Your Lordship. I am really moved by a book called India Unbound, Your Lordship, written by Gurucharan Das. He really explained how 5-year plan helped India grow. And I feel in judiciary also, we need something like that. We are really indebted, Your Lordship, to Honorable Chief Justice, sir, that he has given a direction to judiciary. He has given a direction to judiciary by giving this 25 debt scheme, Your Lordship. A vision that how, a roadmap that how a pendency can be disposed of, Your Lordship. Your Lordship, we are really indebted to Your Lordship. Now, Your Lordship, we are talking about Vision 2047, Your Lordship, which is, again, I should say that a very visionary document, a very visionary statement in itself, Your Lordship. Your Lordship, I feel I have a request, Your Lordship, with you, Your Lordship. Very humble request, Your Lordship. As 5-year plan helped India grow in economy sector, we can have a 5-year plan or something like a 3-year plan for every station with a consultation of 1-to-1 judge, which can help us reduce pendencies substantially, because each station, each judge has has a different set of problems, have a different set of issues, Your Lordship. Your Lordship, I again wish to thank you very much from bottom of my heart for 25 debt scheme, Your Lordship. William Shakespeare once said after a praise that I have nothing else to make. Thanks, 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 thanks again and again. From entire judicial family, we are thankful to you from the bottom of our hearts, but for you, our heart has no bottom.
Gentlemen, what's your good name?
Vinayak Gupta, Your Lordship.
You are a Chief Justice sponsored candidate? Well said, huh? Anyway. Now next.
Thank you.
Yes.
सर मैं कला भमरकर जिला हरदा की तहसील खिरकिया से हूँ। सर ये 25 केसेस को लेकर जो मेरे अच्छे अनुभव है वो मैं शेयर करना चाहती हूँ। सर पहले तो जब 25 केसेस डिसाइड करने का जो चैलेंज मिला था तो बड़ी खुशी हुई थी कि चलो इसमें हम अगर कुछ अच्छा करते हैं तो कुछ अलग हमका दिखेगा। तो जो सबसे पहले 25 आए थे उसमें से 23 किए थे। उसके बाद हर समयावधि में टारगेट पूरा किया और उसमें जो मुझे देखने को मिला कि जो खिड़कियाँ है वहाँ काफ़ी गरीब और दूर दराज से ग्रामीण क्षेत्रों से लोग आते हैं। तो जब नोटिस जारी किए गए और उनको बुलाया गया, पुलिस को भी काफ़ी बोला कि नहीं इसमें तो किसी भी स्तर में गवाह आना चाहिए। तो जब है आरोपी और गवाह साथ साथ आए और वो कह रहे हैं कि हम तो भाई भाई हैं, हम काफ़ी समय से साथ ही रह रहे हैं और हमको तो पता नहीं केस चल रहा है। तो कुछ अभियुक्त की उपस्थिति में चल रहे थे, कुछ ऐसे डिसाइड हुए, कुछ ऐसे है कि पति पत्नी हैं, चूँकि ग्रामीण क्षेत्र है तो शराब पीकर भी लड़ाई हो जाती है, पति पत्नी को मार देता है, भाई भाई की लड़ाई हो जाती है। तो मेरे पास एटलीस्ट 25 केसेस ऐसे डिसाइड हुए हैं जो पारिवारिक मामलों को लेकर थे और जिसमें अपनी थोड़ी सी पहल को लेकर उसमें हमें अच्छे परिणाम मिले हैं। तो और बेहद खुशी हुई कि उनको हमने थोड़ी देर से न्याय मिला लेकिन उनको मिला और वो खुशी खुशी घर गए। और लोक अदालत में भी इसी तरह हमको सफलता प्राप्त हुई है। तो ये हमारे लिए बहुत चैलेंजिंग था और बहुत मज़ेदार था और आगे भी हम बिल्कुल कंधे से कंधा मिलाकर साथ देंगे और ज़्यादा से ज़्यादा काम करेंगे। धन्यवाद सर।
Anybody else wants to ask anything? No? Okay. No, it's very nice to hear the last speaker that she not only said that she has cleared the 25, but she said, "Bahut maja aaya." Now, that is very important for a judge. You must love your work. You must enjoy doing your work. It's not a job that you work for 30 days and get a salary. You must enjoy your work. Only then you can really do justice, not otherwise. And as far as Vinayak, as far as you said about this good plan and all that, that is fine. Wherever I've gone around in the state, I've always requested the judges that if you have any ideas for the betterment of the state, please let me know. Just pen it down and send it to me by email. We will consider it. We need every judge to contribute towards it. It's not that we are the planners and you are the executioners. No, it is not like that. A good idea can come from anybody. So it is an open request to all my judicial officers. If you have any ideas, if you have any suggestions as to how to improve the system, please write to me. We will certainly consider it and put it into motion. Thank you.
So, I believe that Madhya Pradesh Nyayadhish Sangh, right, will be the pioneer and the first of the institutions to achieve the aspirations we have determined today for 2047. And as expressed by Honorable Chief Justice, let's do it. I am also with you and we will all jointly do it and then spread the word around the country that look here, Madhya Pradesh is the first. So please, all of you, I request, work to the best of your ability, walk a mile further, focus on your work. The government and the High Court and the Supreme Court are providing the best of facilities and services. to judicial officers. Wherever there is anything lacking, please do let the registry of the High Court know, and the Chief Justice will take care of that. And I firmly believe that until unless you have a environment which is work friendly, the output cannot be 100%. So we'll work on that side. If there is any deficiency anywhere, please do inform the PDJs, the principal district judges of the district may inform the Chief Justice, and the registrar dealing with the infrastructure, and things will be taken care. Any other difficulty, you can always come to your administrative judge, whatever be the status here in Madhya Pradesh. Somewhere they are inspecting judges, somewhere they are administrative judges. Here, administrative portfolio judges. Okay, portfolio judges. And get your things sorted out. And I would love to come again to address the judiciary of Madhya Pradesh, not on this topic, but sometimes share my life experiences, and maybe you find it little motivating and interesting. You may pick up some things from there some other time. Thank you, everyone. Thank you very much.
Thank you, my lord, for the concluding remarks. So, if your lordships permit, may I tender vote of thanks? If your lordships permit. So, arriving towards the end of this session calls for an expression of heartfelt gratitude. I consider myself fortunate to present vote of thanks. I, on behalf of all the participants and on my own behalf, extend my deepest regards and sincere thanks to Honorable Shri Justice Vikram Nath, Judge, Supreme Court of India, for sparing time from his extremely busy schedule to grace the occasion. I also express my sincere gratitude to Honorable Shri Justice Sushruth Arvind Dharmadhikari and Honorable Shri Justice Vivek Agrawal, Judges, High Court of Madhya Pradesh, for the gracious presence. I am also thankful to Honorable Chief Justice for the august presence. I am thankful to the panel speakers for presenting the subject in a very lucid way. I am also thankful to all the organizers of this conference for organizing such a wonderful event. Your efforts in orchestrating this event have provided valuable platform for collaboration, knowledge exchange, and professional growth of the judges. Last but not the least, I am gratified to all the wonderful audience for being here. Have a great day ahead. Thank you. And with the kind permission of dais, may I declare the session concluded?
Yes,
the
please.
session stands concluded. Thank you. Next session is going to start in 5 minutes. So if I request all the audience, they can freshen up and come after 5 minutes. But I request to please kindly be seated. If anyone wants to go, if there's some emergency, and if they want to freshen up, then they can leave. And please be seated after 5 minutes. Thank you.
Good evening, everyone. It has been directed that the session will start in a while. I request all the participant judges to please be seated on the seats. Please take your seats. We will start in a while. आप सबसे निवेदन है प्लीज़ अपने सीट ग्रहण कर लें। थोड़ी देर में हम अगले सत्र की शुरुआत करेंगे। सभी आदरणीय न्यायाधीशगण से निवेदन है अपनी सीट ग्रहण कर ले। थोड़ी देर में हम अगला सत्र प्रारंभ करेंगे। सभी को नमस्कार। आप सब कृपया अपना पद ग्रहण कर लीजिए। Kindly be seated. We are going to start with our next session. A very good evening to all of you. We are starting with our technical session 1, that is bail issue pertaining to parity, repeat application, cancellation and the like. I request Honorable Shri Justice Vijay Kumar Shukla and Honorable Shri Justice G.S. Ahluwalia to kindly grace the dais. And I request Sushri Aparna Soni and Sushri Riya Daheria to kindly escort the honorable dignitaries to the dais. Please rise. Our dignitaries have arrived. आप सबसे निवेदन है अपनी सीट पे खड़े हो जाइए. Thank you. With the kind permission of the dais, may I commence with the session? Thank you, my lord. Honorable Shri Justice Vijay Kumar Shukla, my lord, Honorable Shri Justice G.S. Ahluwalia, Judge, High Court of Madhya Pradesh, Honorable respected panel speakers, participant judges, a very good evening to all of you. In this session, we have distinguished privilege of having the august presence of Honorable Shri Justice Vijay Kumar Shukla for chairing the session, and the session will be co-chaired by Honorable Shri Justice G.S. Ahluwalia. To welcome our dignitaries, I request Srimati Mamta Jain, Principal District Judge, Khandwa, and Shri Siddharth Kumar, Civil Judge Senior Division, Khandwa, to kindly felicitate and welcome Honorable Shri Justice Vijay Kumar Shukla with a bouquet of flowers. Now I request Shri Arun Kumar Verma, Principal District Judge, Ali Rajpur, and Shri Shubham Jain, Civil Judge, Junior Division, Ali Rajpur, to kindly felicitate and welcome Honorable Shri Justice G.S. Ahluwalia, Judge, High Court of Madhya Pradesh, with a bouquet as a token of our respect. Since Shri Arun Kumar Verma, Principal District Judge, Alirajpur, is not present here for some reason, so Special Judge Sir will be felicitating Honorable Shri Justice G.S. Ahluwalia. Our panel speakers for this session are Shri Bhagwati Prasad Sharma, Principal District Judge, Indore, who will be speaking on repeat bail applications. Shri Jiten Kumar Sharma, Principal District Judge, Chhindwara, who will speak on the topic of parity, and Shri Zakir Hussain, Principal District Judge, Vidisha, who will be speaking on cancellation of bail. I welcome all these panel speakers to this session. Each panel speaker will have 3 to 4 minutes to share his views. I request all the panel speakers to kindly adhere to the time limit. I request the Honorable Chair to kindly give the opening remarks for this session. My Lord.
Good evening, everyone. Honorable Chief Justice, Brother Justice Ahluwalia, and Honorable Judges, former Judges, Principal District and Session Judge, all Judicial Officers. First of all, I must express my gratitude to Honorable Chief Justice and the Madhya Pradesh Judicial Association for organizing such good seminar, enlightening everyone on the topic. Before coming to the subject, it would be proper to talk about the motive or the seminar, that is looking ahead. Just we have discussed in the previous session the vision of 2047. I think looking ahead is that learn from the past and forget past. Now we have to focus on future. We have to see that what would be the performance in future. I know that all judicial officers have worked very hard for last 1.5 years. And the performance has been very good. It has been appreciated by Honorable Chief Justice and other speakers in the previous session. Yes. Now the topic of this session is issue pertaining to parity, repeat application, cancellation. To understand this issue, I was thinking, what is bail? Where from we got this concept of bail? Pre-trial detention. Why it has come from where? I find at the era of Ramayana, Mahabharata, there was nothing like bail. Though principles of natural justice, we find something in our Ramayana and Mahabharata. Like that when Ramayana में राम समुद्र से प्रार्थना करते हैं कि हमें रास्ता दो, और उसके बाद जब पनिशमेंट देने लगते हैं तो उसके पहले अपॉर्चुनिटी ऑफ हियरिंग ही अफोर्ड्स टू समुद्र. ऐसे ही महाभारत में जब लॉर्ड कृष्णा शिशुपाल को का मर्डर करते हैं, किल करते हैं, दंड देते हैं, तो उसके पहले उसको अपॉर्चुनिटी ऑफ हियरिंग देते हैं और 10 गलतियां माफ़ करने की ये देती हैं. तो हमारे पुराने ग्रंथों से कुछ एग्जाम्पल ये तो मिलते हैं कि प्रिंसिपल्स ऑफ नेचुरल जस्टिस उस समय रिकग्नाइज था जब देयर वाज नो पावर ऑफ सेपरेशन. सारे पावर्स एक ही आदमी रूलर के पास में रहा करते थे. concept of bail basically is releasing an accused on furnishing surety and bond during trial. Now, after that, if we go to the ancient India, I could not find anything about bail, but Kautilya said something about in Arthashastra in chapter 4, page 9. He said to avoid detention pre-trial. I will quote his wordings of Kautilya. He says, a king who observes his duty of protecting the people justly according to law goes to heaven, unlike one who does not protect his people or inflict unjust punishment dand. This shows duty of a Raja that before an accused is found guilty, pre-trial detention should be avoided. And he said a judge, a king who does it will go to hell, and if he follows it, he will go to heaven. This is the wordings of Kautilya in Arthashastra. Then gradually we look to the history of bail. We find that in the Mughal period, these two words which are oftenly used today also, muchalka and jamanat, still we use these words. They started during Mughal period. Muchalka means, as we know, personal bond, and jamanat is surety. And what I could find, which was the first case in which the bail was granted, there is nothing much material on that. But I could find that first time the Punjab ruler granted bail to an Italian traveler, namely Manukki. He was caught for committing theft. But prima facie, there was no material against him to prove theft. Then Punjab ruler released him on bail on the surety. This is the first example where the bail was granted. Apart from that, in the history we find that where from the bail has come, that is 377 BC. So long, that time Plato tries to create a bond for release of Socrates. This is example that he said, I will furnish this much for the surety and let the Socrates released on bail. So these are the history of the bail, but that was not written, not codified. It's only after in the British rule, the law in this regard was codified. And the CRPC, IPC, CPC, etc. were introduced. And civil courts were known as Jamanat Adalat, and the criminal courts were known as Fauzdari courts. Now, bail word has come from where? It's a French word. Bail means it has been taken from barrier. Barrier means that to give or to deliver. Now, after the independence, about the bail, I think most beautifully written by Justice Krishna Iyer a great jurist who has written what should be the considerations for grant of bail. That in his own wordings, in Good Kanti Narsimha case in 1977, Justice Krishna Iyer said in his words, the issue of bail is one of liberty, justice, public safety, and the burden of the public treasury, all of which insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process. I think if his words are taken of Justice great jurist Krishna here, these should be the considerations to grant the bail. We all know there is no fixed criteria for grant a bail. It's a discretion of the court depending on the facts and prima facie material. Now, in a dictionary, I was looking what is the meaning of the bail. So it's just like a security in the form of cash or bond. Now, question of parity, which is the subject, on this lies very clear that parity alone is not the criteria to grant a bail. Oftenly, in courts, parity is claimed that one accused is granted, co-accused is granted bail, therefore it should be granted. But it should not be the sole consideration. For grant of the parity, the judge has to see the facts and the material available on the record to consider that whether his case exactly stands on the same footing or not. This controversy regarding the parity was considered in various judgments by the Supreme Court. In the case of Chandra, in 1998, Justice Karju declined to grant bail on the ground of parity, and he referred the matter to the larger bench, that what should be the criteria for granting bail on the ground of the parity. Now recently, the Supreme Court has decided it and said that on the ground of the parity is one of the ground for consideration of bail, but it is not the sole consideration for grant of bail. They held that balance has to be seen, consistency is essential, and therefore parity is also one of the consideration for grant of bail. Now, what type of order should be passed? Order of bail, initially, even in the High Court, when I joined the practice, there was a practice to grant the bail. No order was being written. Only a seal was prepared in which only amount was used to be written. No reasoned order was passed. Only simple it is written that application is allowed. Amount used to be dictated by the judge. It has been held by the Supreme Court, that is in the case of Ramesh Rathore, that the order of bail should not be unreasoned. Some consideration of facts should be reflected in the order. Now, the second aspect of the subject of this session is cancellation of bail. Remember, for considerations for grant of bail are totally different from considerations for cancellation of bail. Cancellation of bail can be on the ground of violation of conditions of the bail, involvement in the subsequent offenses. But while cancelling the bail, court has to record cogent reasons. You can't simply cancel the bail without recording the reasons. This has been held in the case of Daulat Ram by Supreme Court. Now, another question comes that if there is no violation of conditions of the bail, whether still bail can be cancelled or not. Supreme Court held that yes. In the case of Mahipal, that is in 2020, Supreme Court said if the bail order is passed arbitrary, without application of mind, improper, without consideration, or on erroneous consideration of facts, bail can be cancelled. This is one of the consideration for cancellation of bail. Another topic is repeat application. Earlier, this was not the practice that the bail should be listed before the same judge who has rejected the previous application. This came later. In the case of, in the year 1989, perhaps it was noted that looking to the judge's perception or judge's view, the repeated bail applications were being filed, considering the roster, etc. So it was being misused. Then the Supreme Court held in 1989 in Buddhi Kota case that to prevent this abuse of process of law, it would be proper to list the bail repeat applications before the same judge. Now the question is that on what grounds a repeat bail application can be considered. First is that change of circumstances. If there is a change of circumstances, then repeat bail application can be entertained and the subsequent bail application can be filed and considered. The question regarding the criminal appeal in SC/ST, recently there are judgments and the views have been taken. In one of the case, one judge has taken a view that in SC/ST it is not a bail, it is criminal appeal. And since it is a criminal appeal under the SC/ST Act, there can't be repeat bail. Once an appeal is filed and it is dismissed, remedy is exhausted, then you can't file application. There are divergent views. One court says, though the nomenclature is criminal appeal, but it is in fact bail, and therefore subsequent application in SC/ST Act is maintainable. Then one judgment came, I would not name the judge. He held that it is not maintainable, but it can be filed before the trial court on the as a fresh application on changed circumstances. Recently, another judgment has come which said that if after withdrawing or dismissal of the application by the High Court, if the applicant files another application before another appeal before the trial court on subsequent events or on changed circumstances, it can be considered and it will be treated to be as a first criminal appeal. And against that, the appeal would be maintainable before the High Court. These are the views. Now, just because we are discussing bail, question comes of anticipatory bail also. There is, before 1973, there was nothing, any provision like anticipatory bail. On anticipatory bail, there are divergent views which has been now settled. In the first case of the Constitution Bench is very celebrated case which still holds the field is Guru Baksh Singh. We all know that 1980 judgment. But question came whether anticipatory bail comes to an end as soon as charge sheet is filed before the court. That was the question. Then the views came in Salaruddin Sheikh that the anticipatory bail would be for limited period and it cannot be granted till the trial. It has been followed in number of cases. Then the one view was taken in SS Mahatra. I think every judicial officer is aware of this judgment, which came later in 2011, which said that no, once the anticipatory bail is granted by the court, it will continue till the end of the trial. And then again another view came in the Satpal case in 2018. They took a different view that no, again saying it is for limited period and it will be operative till the charge sheet is filed. Now the position has been settled by the Supreme Court. In the case of Sushil Agrawal, they said that once the anticipatory bail is granted, it shall continue till the conclusion of the trial. So these are the issues on this topic, and one thing is made clear: if the High Court passes an order in bail and makes some observations on merit, always remember these observations should not be influenced. The trial court, while passing the order on merit after the trial, these orders are never on merits, even if the court has not observed in the bail order that the trial court will not be influenced. It goes without saying that any observation made in the bail order is not an order on merit, and the trial court has to decide its case on its merit after evaluation of facts and evidence. Thank you.
Thank you, my lord. I now request the co-chair to give his remarks regarding the session.
Honorable the Chief Justice, my esteemed brothers and sisters, all participants, good evening to all of you. My brother Shukla, Justice Shukla, has already given an insight of the concept of bail, cancellation of bail, repeat bail, even anticipatory bail. So I would not like to repeat the same things, but I would like to add only a few things. That what should be the relevant factors for considering the bail application, and what should be the relevant factors for cancellation of bail application, and what is the difference, how many types of applications for cancellation of bail can be there, and who should exercise that power. So far as the concept of grant of bail is concerned, first of all, we have to look into the severity of the allegations. If the allegations are serious, then the impact of the release of the accused on the society, even on the complainant, then the chances of fleeing away from the court, then the chances of tampering with the witnesses, the chances of committing these offenses may be of the similar nature or some other nature of offenses which can be ascertained from the track record of the accused, that is the criminal antecedents. These are few relevant factors which are to be considered. And apart from that, the period of detention which a person has already undergone as a pre-trial detention, under trial prisoner. The period of detention also plays a very important role, because for a trivial offense, you cannot keep a person behind the bar for months together or even years together. But that principle may not apply in a case of a murder or a rape or I would say heinous offenses. So these are the aspects which are to be considered by the judge while considering the bail applications. Now, so far as the applications for cancellation of bail is concerned, there are two types of applications which are to be exercised by two different forums. The first application is on the basis of misuse of the liberty which has been granted to the accused. Now, if that application is filed, then it has to be considered by the same court which has granted bail. It is not a cancellation on the merits. And another application is that if a person files an application before a higher forum, like an appeal, challenging the grant of bail on the merits that he should not have been granted bail. If such an application is filed, then that application for cancellation has to be considered by the higher court, not by the same court, because Section 362 review will also apply to the bail applications also. And a person, if a judge has granted a bail on merits, then he cannot recall his order on merits itself. It has to be done by the higher court, not by the same court. So if an application is made that he has misused the liberty, it has to go before the same court which has granted bail. So far as the repeat applications are concerned, The similar thing is that what are the change circumstances? Period of detention is one of the main change circumstances. Delay in trial, that is also equally one of the main circumstances. These can't be the only circumstances. These are one of the circumstances, and then you have to consider that whether the accused is also responsible for delaying the trial, and what are the allegations against him, and whether he has any criminal history, possibility of fleeing away, tampering with the witnesses, and all these aspects. So far as the other aspects are concerned, I would not like to take your much time because we have already late by more than 1 hour. And I just wanted to add these things. Now I would take my seat so that the other speakers may share their experiences or their views with you, and then we can have some questions, and we will try to answer those questions. Thank you.
Thank you, my lord. I now invite our first speaker, Shri Bhagwati Prasad Sharma, Principal District Judge Indore, to share his views on the topic, repeat bail applications.
My Lord, Honorable the Chief Justice, Ravi Malimath, Chief Justice, High Court of MP, Honorable Judges of the MP High Court, on the dais, off the dais, all respected judges who have come from different places. I have been provided a grateful opportunity to speak regarding one of the issues faced, especially by the judges of the higher judiciary with regard to the successive bail application. As all of you know, that right of bail is not a constitutional right, rather it is a statutory right. If the case is a fit for grant bail, then the object should not be that accused stay in jail for a few days, then it consider it. Due to paucity of time and some issues already discussed regarding the successive bail, it is not possible to deal with every aspect in detail, but for effective understanding, I am dealing with the main principles related to the successive bail application. If the first bail application of the accused is decided by a judge, then all subsequent bail application of the same accused related to the particular matter should be decided by the same judge. If any bail application of the accused is decided by a judge as in charge of another judge who is on leave or absent from his headquarters, and a subsequent bail application of the same accused is filed in a same case, then it should be decided by the in charge judge. Even if the earlier bail application of the accused has been dismissed as withdrawn or not pressed, a subsequent bail application of the same accused in that case should be placed before consideration before the same judge. If one bail application of an accused is decided by Judge A and subsequent bail application is filed by the same accused after his criminal case is transferred for trial to the Judge B, then such subsequent bail application should be decided by Judge B because the previous judge ceased to exercise their jurisdiction. When the Superior Court has refused to grant bail to an accused on merit and the order remain in force, judicial discipline and propriety required that the trial court not to entertain an application unless the Superior Court has permitted the accused to move again before the trial court. In the case of Satish Jaggi versus State of Chhattisgarh 2007, Honorable the Supreme Court had held that while deciding the bail or subsequent bail application, the court cannot go into the question of credibility or reliability of the prosecution witnesses. In the case of Sarad versus State of Maharashtra, Honorable the Supreme Court has held that there is no provision in CRPC or in any other law laid down by the court, by this court, that once an accused had withdrawn his bail application before the Honorable High Court, he cannot file the subsequent bail application before the Session Court. In the case of Hari Singh versus Harbhajan, Honorable the Apex Court has held that a subsequent bail application without the change in circumstances would be deemed to seek review of the earlier order, which is not permissible under the criminal law. Law for deciding subsequent bail application is well settled, and there are least possibility of misuse of due process of the court if the concerned judge, who is vigilant, I am very much grateful to provide this opportunity to deal with this issue. Thank you.
Thank you, sir. I now invite our second speaker, Shri Jiten Kumar Sharma, Principal District Judge Chhindwara, to share his views on the topic parity.
Honorable Chief Justice Shri Ravi Malimath, all Honorable High Court Judges, due to paucity of time, I would explain short. I would highlight the exceptions of rule of parity. All of us know grant or refusal by bail is a discretionary power, but the problem of its applicability, where the bail orders of higher courts are placed before us. Then in cases, and the problem is us how to differentiate, how to determine whether it is a principle of parity or not parity should be applied. I would only exceptions it. Previous criminal history of the accused. With regard to having criminal character of accused, we should determine whether parity or non parity should be applied or not. Seriousness of charges of the accused, so many times individual acts may be different. We should consider individual acts in the light of all facts and circumstances of the cases. Discovery of new material pointing out more heinous offense, sometime during investigation, sufficient material was not, in absence of sufficient material, bail are granted. Whenever whenever other application is filed before us, if new material come before us, we should not apply this principle. So many times, previous order passed in ignorance of law. It is basic principle. Honorable Supreme Court has discussed in so many cases that if a benefit or advantage is conferred in favor of an accused by virtue of wrong order, without legal base or justification, other principal could not claim a counterclaim due to this wrong order. Absconding for a long time, so many times, it is also a factor to be taken in consideration. But we should apply this principle, not a hyper-technical view. So many times it may be possible that an accused, due to some labor work, goes out of the station. This may be differentiated. Suppression of material facts, of pleading incorrect facts. If co-accused obtain bail order due to correct or wrong facts, we should differentiate other accused. In some cases, parity law not applicable. For example, some special acts has strict provisions of bail. For example, MP Excise Act, the MP Dakati or Pravat Kshetra Adhiniyam, NDPX Act, Custom Acts, Money Laundering Acts. These acts have some special principle, some special provision. we should never apply in this cases rule of parity if bail are granted by higher court, because higher courts have some special power. Being trial court, we have no such those power. In default bail cases, release of so many times accused are released under section 167 to CRPC. This is statutory right. Accused when investigation was completed 19 or 60 days. In these cases, we should not apply parity rules. In some cases, so many times, under 4371 CRPC, bail are granted considering the age of victims, considering age of accused, woman, illness, infirm person, or a special reason. Then in cases, we should not apply this principle. By and large, this parity rule of parity is basically based on Article 14, equality before law. It should be implemented in realistic and pragmatic approaches, considering the individual act in light of all circumstances fact. Individual act is particular considered. So many times, a person, considering the status, position of person, even so many political persons, these may be cases where parity or non-parity may be decided. Due to shortage of time, thank you, Lord.
Thank you, sir. I now invite our third speaker, Shri Zakir Hussain, Principal District Judge, Vidisha, to share his views on the topic cancellation of bail.
My Lord, Honorable the Chief Justice, my Lord, Honorable the companion judges, respected distinguished guests, my fellow judges, ladies and gentlemen. It is my privilege that the Honorable High Court has given me this opportunity to interact with this august presence. Criminal Procedure Code has classified bail into two segments, as bail in bailable offense and bail in non-bailable offense. Bail in bailable offense is governed by Section 436 CRPC, whereas bail in non-bailable offense is covered under Section 437, 439 CRPC. Furthermore, Section 1672 CRPC rules the concept of default bail. Section 436A, 3893 CRPC gives its wider scope. With the development of legal system, many special enactments has been added to the book of statute, which has a specific provision of bail. Likewise, Section 20 of TADA Act, Section 37 of NDPS Act, Section 45 of Prevention of Money Laundering Act, etc. Similarly, statute books has recognized the concept of cancellation of bail in Section 437(5) and 439(2). First question that comes in mind is that who can cancel the bail? Where bail was granted by a session judge, any cancellation or alteration of the condition of bail can be made by the session judge himself or by High Court, and not by a magistrate. Similarly, the provision of Section 437(5) of the CRPC applies to the case where bail has been granted under that section. It has no application where bail has been granted under Section 436 or 432 of the CRPC. However, if the Superior Court has authorized the concerning magistrate to cancel the bail in certain circumstances, the magistrate has power to cancel the bail. Next point of consideration is who can file application for cancellation of bail. It is settled law that complainant can always challenge the order of granting bail. The application for cancellation of bail can be moved by the public prosecutor or the complainant. With the legal development in this area, the Honorable Supreme Court in the matter of Naveen Singh held that application for cancellation of bail can be moved even the third party. The court can suo motu order the cancellation of bail in appropriate case. Thank you. In the celebrated case of Daulat Ram and others versus State of Haryana and other category of judgments, the Honorable Supreme Court has enumerated various considerations for cancellation of bail. Few illustrative instances which become across in our day-to-day working are addition to graver offense. Delay in trial. The accused misused his liberty by indulging in similar criminal activity. Interference with the course of investigation. Attempts to tamper with the evidence or witnesses or threatens witness. There is likelihood of his fleeing to another country. Attempts to make himself scarce by going underground or becoming unavailable to the investigating agency. Attempts to place himself beyond the reach of his sureties. Chances of accused absconding. Interference or attempts to interfere with due course of administration of justice. Another is accused is absent during the trial. Now question is arise whether the anticipatory bail can be cancelled. In this case, Honorable Supreme Court in case of P versus State of Madhya Pradesh and others, AIR 2022 held that anticipatory bail can be cancelled. Similarly, in State of Haryana versus Dharamraj 2023 SCC online, it is held that anticipatory bail can be cancelled. Another point is cancellation of bail in bailable offence. In Rasiklal versus Kishore Vadwani, the Honorable Supreme Court held that an application for cancellation of bail in bailable offence can either be made before the Sessions Court or the High Court and not before the magistrate, as he has no power. But where a person accused of a bailable offence is granted bail by a magistrate and subsequently the offence is found to be a non-bailable offence, he can cancel the bail. Another point is cancellation of default bail. In case of state through CBI versus T. Gangi Reddy, 2023 Live Law SC, the Honorable Supreme Court held that default bail can be cancelled on merits and the courts are not precluded from considering the application for cancellation of the bail on merits. Broadly speaking, each case has its own unique factual scenario which holds the key for adjudication of bail matters including cancellation thereof. It would be fruitful to recapitulate the well-settled legal principle that the cancellation of bail is to be dealt on a different footing in comparison to a proceeding for grant of bail. Bail once granted to an accused cannot be cancelled in a mechanical manner without considering whether any supervening circumstances have rendered it no longer conducive to a fair trial to allow the accused to retain his freedom by enjoying the concession of bail during trial. Grounds for cancellation of bail may be based on satisfaction of the court. In the end, I would like to conclude my words by saying that it is necessary that cogent and overwhelming reasons are present. Thank you very much.
Thank you, sir. I request the Honorable Co-Chair to share his closing remarks.
First of all, I would like to thank the speakers, क्योंकि थोड़े समय में गागर में सागर भरने का प्रयास हुआ है और अगर गागर थोड़ी सी रह भी गई है तो इतनी सी रह गई है कि छलक के बाहर नहीं आ पा रही है. In fact, all the major issues concerning the bail applications, cancellation of bails, parity, they have been discussed within a short span of time. I don't think that there is anything to add, but what I would like to say is that assigning reason that is mandatory to show that you have applied your mind, but the reason should not be so exhaustive which may indicate that you have already decided the case. So we have to strike balance between the application of mind and to show that the aspects which are necessary to decide the bail application, whether for grant or for rejection, those were taken note of. Secondly, we must not forget that bail is not a punishment, the rejection of bail is not a punishment, or jail is a punishment, because we cannot award punishment to a person without convicting him. But that should not be the sole criteria for grant of bail. The impact, as I said during my initial speech, that the reasons or the consideration should be the seriousness of the allegations. Now that word serious of an allegation doesn't mean that we are not supposed to consider the role played by an individual accused. If there are multiple accused persons, then merely because they are facing trial for offense under section 302, therefore they are not entitled for bail irrespective of the allegations which have been made against them. Now suppose there are multiple accused persons, some of them are being prosecuted with the aid of section 34 or 149, and there are allegations that they were instigating, but they did not play a role which ultimately caused the death of the deceased. Their case is to be considered separately from the case of the persons who had actually caused the death. So seriousness of the allegation doesn't mean that merely because a person is being prosecuted for a heinous offense, therefore he is not entitled for bail at all. Seriousness of allegation has to be with regard to the role played by him and the period of detention. So far as the cancellation is concerned, it is true, in case of a bail jump, yes, the consequences would be that the bail has to be cancelled. But as I said, misuse of the liberty. Now suppose if a person comes up, he files an application under section 70 subsection 2 after he was declared absconding on account of bail jump, and he points out the reasons, sir, for these reasons I could not appear. Then it can be considered, if the reasons are bona fide, it may be 2 years of absence or 3 years of absence or even 1 month of absence. I would like to share one of my order, although I am not recollecting the name, the cost title of that order. And a person absconded for 3 months only. When I was going through the order sheets of the trial court, I found that earlier the witnesses were not coming. And thereafter that person went missing. He stopped appearing before the trial court, and he absconded for 3 months. And thereafter he surrendered. And on the very next day, all the witnesses had turned hostile. Then it gave an impression that something must have been done by this person. Then ultimately, when I was going through the evidence of the deposition sheets of the witnesses, I got a glimpses of my suspicion that yes, it was there. Because when a question was put by the public prosecutor to one of the accused, to one of the witness, he admitted that yes, during his period of absconsion, I had met him for twice or thrice. Why the accused was meeting with the witnesses, that gave a clear picture to me that during this 3 months, he had misused his liberty to win over the witnesses. So what I want to say is that the period of absconsion, that may not be very crucial. The reasons for absconsion may be bona fide, as one of my speakers said, that he might have gone out for earning his livelihood. So these are the aspects, but first of all, sir, we have to keep only one thing in mind. Jail is an exception to the life and liberty. But that doesn't mean that under the garb of Article 20 or 21 of Constitution of India, we should release everybody without considering the pros and cons of that release. We have to strike balance between the accused, rights of the accused, society, as well as the complainant. So each and every case has to be decided on its own merits. We cannot lay down a general principle of law, except by saying that every order must be supported by reasons, may not be in very detail, but giving enough indication that the judge has applied his mind. So far as the parity is concerned, in one of my case, which was ultimately affirmed by the Supreme Court, as I am recollecting, the post title was Sikandar Singh, Narwaria versus State of Madhya Pradesh, where a bail was granted by the sessions judge, and I found that the role played by the person who was released by session judge and the person who was released by me, that was completely different. The person who was released by me had played a role of against whom the allegations were that he was instigating, he was provoking the others, and they had committed the offense, so he was being prosecuted with the aid of section 149. And the person who was released by the session judge, there was specific allegations that he had fired, which caused an injury on the abdominal region, although the cause of death was the another gunshot injury caused by the third person. So there was a completely difference between the role played by both the person who was released by me and the person who was released by the sessions judge. Then I highlighted the role which is to be considered, that what role was played by an accused and that matter went to Supreme Court, and that order was upheld. So the aspect of parity was considered by me in that case in very detail. In one more case, Suresh Kumar versus Rajendra Kushwaha, the aspect of parity was also once again considered by me in a very detailed. So what I would say, each and every case has to be decided on its own merits. We are just required to keep the broad factors under consideration, and then to come to a conclusion whether the period undergone by an accused vis-a-vis the allegations against him is sufficient for his release or not. So far as the cancellation is concerned, as I already said, that there are two types of cancellations apart from the jumping of bail, because in case if a bail is jumped, there cannot be a question of grant of anticipatory bail. Either the 439 has to be granted, or he has to surrender and file an application under section 70 subsection 2 of CRPC. What I would say that for the first time, as I recollect that prior to 2001, the general concept was that the bail can be cancelled only when there is a misuse of their liberty. But ultimately, the Supreme Court, in the case of Puran versus Ram Bilas, it was reported in 2001, Supreme Court 2023. The concept is that an order which was unjust or where the bail should not have been granted to the accused, then that can also be cancelled by the higher court. So these are the basic aspects. As I already said, that our speakers have already done a marvelous job in discussing almost all the factors regarding all the three issues. So myself and my brother Shukla will be the happiest persons to if some questions are put to us and if we succeed in answering those questions. Thank you.
Thank you, my lord. I now request the Honorable Chair to give the concluding remarks.
First of all, I must express again gratitude to Honorable Chief Justice and the Judicial Officers Association for organizing this seminar and on different topics which we daily deal our judicial officers. As my brother Justice Ahluwalia almost covered all the issues regarding the parity, grant of bail, cancellation of bail, etc. One thing it is made clear that while deciding the issue, while deciding the application for bail, don't be under this impression that if you grant bail, you will be put to a question. Don't keep it in your mind. Decide a case on its merit and without being on any other considerations. The bail, as it has been long back by Justice Krishna here, it has been held that bail is a rule and jail is an exception. So keep it in mind and decide all these applications. Thank you.
With the kind permission of the dais, may I give the vote of thanks? Thank you, my lord. I would like to express my heartfelt gratitude to Honorable Shri Justice Vijay Kumar Shukla, Judge, High Court of Madhya Pradesh, and Honorable Shri Justice Gurpal Singh Ahluwalia, Judge, High Court of Madhya Pradesh, who have been kind enough to spare their valuable time for this conference. Your Lordship's insights and expertise has added immense value to the discussion, enriching the knowledge of all the participants present here. I express my deepest gratitude to all the panel speakers who have shared their invaluable experience relating to bail and made this session successful. With the kind permission of the Honorable Dais, may I declare this session concluded? Thank you, my lord. This session stands concluded. We will begin with the second session in just a minute. In the meanwhile, we'll make arrangements for the second session. Kindly be seated. Thank you. I request the audience to remain seated. I request Honorable Shri Justice Anil Verma and Honorable Shri Justice Sanjay Dwivedi, Judge, High Court of Madhya Pradesh, to kindly grace the dais. I request Civil Judge Junior Division Arpita and Civil Judge Junior Division Sangshikha to kindly escort the dignitaries to the dais. With the kind permission of the dais, may I commence with the session? Thank you, my lord. Honorable Shri Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. Honorable Shri Justice Anil Verma, Honorable Shri Justice Sanjay Dwivedi, Judge, High Court of Madhya Pradesh. Respected panel speakers, participant judges, a very good evening to all of you. This session, we have the distinguished privilege of having the august presence of Shri Anil Verma, Judge, High Court of Madhya Pradesh, for chairing the session, and the session will be co-chaired by Honorable Shri Justice Sanjay Dwivedi. I welcome my lords in the session. To welcome our dignitaries, I request Shri Pawan Kumar Sharma, Principal District Judge, Ashok Nagar, and Shri Satinder Pannu, Civil Judge, Junior Division, Ashok Nagar, to felicitate and welcome Honorable Shri Justice Anil Verma, Judge, High Court of Madhya Pradesh, with a bouquet of flowers. Now I request Shri Alok Avasthi, Principal District Judge, Jabalpur, and Sushri Urvashi Suryavanshi, Civil Judge, Junior Division, Jabalpur, to kindly felicitate and welcome Honorable Shri Justice Sanjay Dwivedi, Judge, High Court of Madhya Pradesh, with a bouquet of flowers. Our panel speakers for the session are Shri Arun Kumar Verma, Principal District Judge, Ali Rajpur, Kumari Suman Srivastav, Principal Judge, Family Court, Sihor, and Shri Ashish Kumar Mishra, Principal Judge, Family Court, Narsinghpur. I welcome all the panel speakers in this session. I request the Honorable Chair to kindly give the opening remarks for this session.
Honorable the Chief Justice, my esteemed brother and sister judges and judicial officers present here, very good evening. See the plight of the speaker. The subject is delay in conducting the trial and to avoid delay in concluding the trial. I have been instructed first you show how can you curtail your speech, then only you have a right to speak. I have been given 4 minutes to speak, therefore I am coming directly on the point. This is 2 minutes. No delay. So I am directly coming to the point. No doubt, this is the main issue, a problematic issue before us. We have been noticing that there is a delay in trial. Unnecessarily, trial has been concluded 8 years, 10 years, unnecessarily there is a delay in trial. So many ideas, so many mechanisms have been introduced, developed for conducting the trial. I have one idea to share with you. I am of the opinion that all the members involved in the process stand for timely resolution of a dispute and carry the spirit of to do everything in their power to ensure the same. Adding to this very notion, I invite your thoughts towards the formation of a 3-member committee in every district, assigned with one very simple yet complex agenda, keeping a check on the timely conclusion of trials and determine the causes of its delay. This shall be done so with the aim of taking necessary actions to expedite prolonged trials and eliminating future delays. This committee can be given a broad mandate to determine the party responsible for causing a significant delay in a particular case, so necessary actions may be taken. Given the nature of the problem at hand, I believe that a major step is called for in this direction. It is time for us to stop anticipating the change and to be the change that we desire to see. I request all district judges take permission from Honorable Chief Justice and constitute a committee of 3-member judges, 3 senior member judges, to scrutinize regularly old cases of more than 5 years, 3 years, and check how delay is being caused, whether judge is not competent to decide the case, whether there is any other reason for delay in trial, and if it is possible to remove that fault or to transfer the case to some other judge according to the committee who is competent to decide or expedite the trial in a very limited time. Thank you very much.
Thank you, my lord. I now request the co-chair to give his remarks regarding the session.
Honorable the Chief Justice, all my respected brother and sister judges of District Judiciary. Today's topic is delay in conduct of trial, problems and solutions. As per the Article 21 of the Constitution, the constitutional guarantee of speedy trial is an important safeguard to prevent undue and oppressive incarceration prior to the trial. The right to a speedy trial is firstly mentioned in that landmark document of Magna Carta. The constitutional philosophy preponderant as a right to speedy trial has grown in an age by almost 2.5 decades. Our Honorable Justice V.S. Malimath, who is the father of our Honorable Chief Justice, he was the chairman of the committee on the reforms of. He was the chairman of the committee on the reforms in judicial system. The committee has given valuable recommendation for speedy trial, including the judicial reforms for making the delivery of justice in a common man closure. The factors for delay in conduct of the trial can be two types. Court system delay, which accounts for the period of entering the cause till it's taken up for the trial. Second, delay due to the professional courtesy of the lawyers towards each other and the lawyers vice versa towards the court. As my vast experience in lower judiciary and district judiciary and high court, I have my personal opinion is that we have developed a system for recording of the evidence in civil cases by way of commissioners. If law permits, such system can prevail in criminal cases also. It will help us to, it will help us for speedy trial of the case. Now, I am very much grateful to provide this opportunity to discuss my thoughts on this issue. Thank you very much.
Thank you, my lord. I now invite our first speaker, Shri Arun Kumar Verma, Principal District Judge, Ali Rajpur, to share his views on the topic, Delay in Conduct of Trial, Problem and Solutions. I request all the speakers to please be brief as possible, as we are running short of time. So please.
परम सम्मानीय मुख्य न्यायाधिपति महोदय, समसम्मानीय मंच एवं माननीय मध्य प्रदेश उच्च न्यायालय के समस्त न्यायाधीशगण, उपस्थित साथियों, न्यायालय में प्रस्तुत प्रकरणों के विचारण में विलंब न केवल पक्षकारगण बल्कि स्वयं न्यायालयों के लिए भी एक दुखती रग है। जब भी कोई व्यक्ति न्यायालय में कोई प्रकरण प्रस्तुत करता है तो उसे आशंकित रहता है वह कि उसके प्रकरण का निराकरण आखिर कब होगा, और जब निराकरण में समय लगता है तो उसमें कई प्रकार की शंकाएं कुशंकाएं जन्मने लगती है। और क्योंकि न्याय प्रदान करने वाली एजेंसी न्यायालय या न्यायाधीश ही होते हैं, इसलिए सारी आंखें उन्हीं पर लगी रहती है। समय की सीमा को देखते हुए मैं विचारण न्यायालयों के समक्ष मुख्यतः आने वाली समस्याओं और उनके समाधान के ऊपर कुछ अपने विचार शेयर करूंगा और अपने अनुभव शेयर करूंगा। सबसे पहली चुनौती जो होती है वो विपरीत पक्ष की उपस्थिति की होती है या फिर साक्षियों की हुई उपस्थिति की होती है। कई बार कार्रवाई आरंभ करने वाला पक्ष ही संबंधितों के पूरे पते आदि नहीं दे पाता है या प्रोसेस नहीं दे पाता है, जिसमें विलंब होता है। यही बात साक्षियों के समक्ष भी होती है। तो जब यदि विचारण न्यायालय आरंभ में ही यह सुनिश्चित कर लें कि आरंभिक अवस्था में ही इस प्रकार की त्रुटियां दूर कर ली जाएं, तो फिर ये स्थितियां नहीं बनेगी। एक विशेष परिस्थिति हम सीमावर्ती ज़िलों की है, जैसे कि झाबुआ, अलीराजपुर या धार कह लें, जहाँ पर पक्षकार विपरीत पक्ष इस बात की प्रतीक्षा करते हैं कि समझौता हो जाए या नहीं होना है ये तय हो जाए, उसके बाद न्यायालय में उपस्थित होंगे। तो ये भी एक स्थिति ऐसी है जो विचारण को थोड़ा विलंबित करती है। अधिवक्ताओं की अनुपस्थितता, डेट्स के बारे में सामंजस्य न मिल पाना, डिलेइंग टैक्टिस, कई बार अचानक अवकाश घोषित हो जाना, ये भी हमारी समस्याओं को दम देती है। कई बार तो जो मेडिएशन के बारे में, मेडिएशन के सहायता से या लोकायत की सहायता से प्रकरणों के निराकरण की बात की जाती है, उसे भी बहाने के रूप में लिया जाता है। तो उसमें भी न्यायाधीश को थोड़ा सजग रहना पड़ेगा देखने के लिए कि अनावश्यक रूप से समय इस बहाने से तो नहीं लिया जा रहा है। विचारण में, खासकर आपराधिक विचारण में, जहाँ पर एक्सपर्ट के ओपिनियन आने हैं, हैंड राइटिंग एक्सपर्ट है, फिंगरप्रिंट एक्सपर्ट है, उनकी उपस्थिति के प्रयास पहले से ही कर लिए जाएं, तो विचारण के अंतिम अवस्था पर ये अनावश्यक व्यवधान नहीं आता है। साक्षियों की ही बात फिर से की जाए तो विचारण न्यायालय के समक्ष रोज ये थोड़ा सा सस्पेंस रहता है कि कितने साक्षी आ रहे हैं, कितने नहीं आ रहे हैं। इसलिए कई बार ये होता है कि एक दो साक्षी आए और पूरा समय लग गया, कई बार ये होता है कि बाकी बैठे रह गए, या कई दिन न्यायालय जो है वो खाली चला गया, कहीं एक भी साक्षी नहीं आया। इसके लिए भी थोड़ी सी कुछ व्यवस्था हम कर सकते हैं मॉनिटरिंग सेल की मीटिंग में या कभी भी, इस प्रकार से सामंजस्य बिठा के कि साक्षीगण उपस्थित हों और विचारण जाती रहे। कई बार उपस्थिति के बारे में बात कर रहे थे, तो उसकी हम ये कर सकते हैं कि जो प्रक्रियात्मक विधि है उसमें न्यायालयों को अधिकार दिए गए हैं कि वो एक साथ कई प्रकार से उपस्थिति की प्रयास कर सकते हैं। तो पहले ही बार में तामीली के हर प्रयास कर लिए जाएं, सामान्य रीति से, रजिस्टर्ड डाक से। तो इलेक्ट्रॉनिक माध्यम का जो प्रिंसिपल उपयोग है वो भी किया जाए, तो वो भी उपयोगी रहेगा। वीडियो कॉन्फ्रेंसिंग और कमीशन पर बयान लेना तो आरंभ कर ही दिया है, इसमें और भी अधिक गति लाए तो और ज़्यादा निराकरण में गति हो सकती है। माननीय सर्वोच्च न्यायालय और माननीय उच्च न्यायालयों द्वारा विभिन्न स्कीमें लागू की ही गई हैं, जिसमें 25 डेथ केसेस की स्कीम सर्वोपरि थी। उसमें न केवल उन 25 केसेस का बल्कि दूसरे भी कई केसेस का निराकरण हो गया, जो कि अपने आप में अभूतपूर्व सफलता रही। 5 साल पुराने केसेस या उससे भी पुराने केसेस, उसके निराकरण के लिए निगरानी रखी जाती है और समय समय पर इस बारे में निर्देश मिलते रहते हैं, तो उसमें प्रयास जारी है। हम लोग बिल्कुल विचारण न्यायालय कटिबद्ध हैं कि जो विजन था जीरो पेंडेंसी या नो पेंडेंसी का, वो लक्ष्य वास्तव में 2047 के पहले पूरा कर सकें। धन्यवाद।
Thank you, sir. I now invite our second speaker, Kumari Suman Srivastav, Principal Judge, Family Court, Sihor, to share her views on this topic.
Honorable Dais, August Assembly, good evening all of you. दिल्ली से भोपाल आते समय ट्रेन 15 घंटे लेट थी। इतनी पीड़ा हुई, आप सबकी भी होती होगी। सोचिए, जिनके केस 15 महीने में निपटने चाहिए, उनके 15 साल में निपटते हैं, तो हम सिंपैथी और एम्पैथी दोनों से अनुमान लगा सकते हैं। The people of a nation may lose confidence in executive or the legislature, but it will be an evil day if they lose their confidence in its judiciary. हर व्यक्ति जो चारों तरफ से निराश हो जाता है, वो न्यायालय की ओर देखता है, और अगर हम भी समय पर निर्णय नहीं करें तो कहाँ जाए। उसकी आशा को छीनने का हमें अधिकार नहीं है। सामान्यतः प्रकरणों में निराकरण के विलंब के लिए कोर्ट और जज को रिस्पॉन्सिबल माना जाता है, लेकिन हम जानते हैं कि प्रोसिक्यूशन, डिफेंस, कोर्ट इंफ्रास्ट्रक्चर, इन्वेस्टिगेशन एजेंसी, पुलिस, एक्सपर्ट, पार्टीज, एडवोकेट्स सब इसके महत्वपूर्ण पार्ट हैं। अगर कोई भी एक अंग कमज़ोर हुआ तो हमारा ट्रायल पे उसका असर पड़ता है, और क्रिमिनल केसेस में तो ये डिले और भी ज़्यादा त्रासद हो जाता है जब पता चलता है कि अपराध से ज़्यादा सज़ा उसमें काट चुका है। बिहार में ही देखिए आप, 28 साल जेल में रहने के बाद उसको एक्विटल किया गया था, वो भी साक्ष्य के अभाव में। नीति आयोग की 2018 की जो रिपोर्ट थी कि जिस गति से हम चल रहे थे, उस गति से अगर हम चलते तो 324 वर्ष लगेंगे हमें बैकलॉग को पूरा करने में। लेकिन हमारे यहाँ मध्य प्रदेश का ये सौभाग्य है कि बैकलॉग और पेंडेंसी को पूरा करने के लिए एक नई स्ट्रेटेजी बनाई है, और उससे फ़र्क भी पड़ा है। हुसैना खातून वर्सेस स्टेट ऑफ बिहार, शेर सिंह वर्सेस स्टेट ऑफ पंजाब केस में जो डायरेक्शन दिए थे कि स्पीडी ट्रायल वॉज ए फंडामेंटल कॉन्स्टिट्यूशन राइट, वो हम आज तक रियल सेंस में लागू नहीं कर पाए हैं। और ऐसा नहीं है कि अनावश्यक प्रकरण केवल क्रिमिनल केसेस में फैटल होता है, इससे देश की इकोनॉमी भी कमज़ोर होती है, इन्वेस्टमेंट डिस्करेज होते हैं, बड़े बड़े कमर्शियल प्रोजेक्ट फेल हो जाते हैं, और फैमिली मैटर्स में तो व्यक्ति पूरी तरह टूट जाता है, जीत कर भी हार जाता है और हार कर भी जीत जाता है। अमेरिका 1974 में स्पीडी ट्रायल एक्ट लाया, फिलीपींस और लेसोथो में भी एक्ट हैं स्पीडी ट्रायल एक्ट। हमारे यहाँ एक्ट नहीं है, पर माननीय उच्चतम न्यायालय ने 2021 में डायरेक्शन देकर इस कमी को पूरा कर दिया, और मध्य प्रदेश में तो हम लोगों को सारे डायरेक्शन है, तो एक तरह से स्पीडी ट्रायल एक्ट ही बन गया है। अभी वर्तमान में ट्रायल कोर्ट में लगभग 3,83,00,000 प्रकरण पेंडिंग हैं, लेकिन हमें पेंडेंसी और डिले के बीच में थोड़ा सा फ़र्क करना पड़ेगा, क्योंकि देयर इज़ नो सिंगल और क्लियर अंडरस्टैंडिंग ऑफ व्हेन ए केस शुड बी काउंटेड इज डिलेड। ऑफन टर्म्स लाइक डिले, पेंडेंसी, एरियर्स एंड बैकलॉग आर यूज्ड इंटरचेंजेबली। यदि कोई केस हाल में ही फाइल हुआ है और अपनी गति से ठीक चल रहा है, तो ये डिले नहीं है, ये पेंडेंसी है, और इसके लिए हमें टाइम स्टैंडर्ड सेट करने होंगे। अलग अलग केस के लिए अलग अलग टाइम निश्चित करने होंगे। भारत में 66 सिविल केसेस पेंडिंग हैं जो लैंड और प्रॉपर्टी के संबंध में, और हमारे यहाँ मुख्य रूप से प्रिवेंशन ऑफ करप्शन एक्ट, NDPS एक्ट, सिविल प्रकरण में डिले होता है। एक लॉ NGO ने एक स्टडी कराई है, उसने बताया कि 91% प्रकरणों में एडजर्नमेंट दिया जाता है, लेकिन 80% एडजर्नमेंट जो लिया है वो एडवोकेट्स ने लिया है, और 20% एडजर्नमेंट हुआ है वो जज के कारण हुआ है। और जज के कारण में वो सिचुएशन भी शामिल थी कि जब बहुत सारी फाइलें लगी हों तो जब उसका प्रकरण में काम नहीं कर पाया। इट मीन्स उसके लिए जज रिस्पॉन्सिबल नहीं है, वो इनएडिक्वेट ऑफ जजेस की संख्या है वो माना जाए, तो इसे डायरेक्टली हम जज को रिस्पॉन्सिबल नहीं माना जाते। लेकिन हमें भी एक मेटाकॉग्निशन करने की ज़रूरत है, क्योंकि हमारी कोर्स में 60% केसेज हम और आप बहुत अच्छी तरह से जानते हैं कि वो ऐसे होते हैं कि जो आउट ऑफ सेटलमेंट हो जाता है, या विड्रॉन हो जाते हैं, या डिस्पोज्ड ऑफ एज विड्रॉन की कैटेगरी में आते हैं, या इन्फेक्शियस हो जाते हैं, या नॉट प्रेस कर लिए जाते हैं। उनमें हमें बहुत ज़्यादा श्रम करने की ज़रूरत नहीं करनी पड़ती। सिर्फ 40% केसेज ऐसे होते हैं जिनमें हमें काम करने की आवश्यकता होती है, और अगर हमने उन्हीं 40% केसेज में काम नहीं किया, उनको टाला, तो ये बैकलॉग बढ़ता जाएगा। और सिर्फ 60% के आधार पे यदि हम अपना डिस्पोजल बताते हैं तो वो एक सांख्यिकी संतोष मात्र है। तो हमें 40% प्रकरणों में काम करने की ज़रूरत है, जो मुख्य रूप से डिले बचाव का हथियार बन गया है। क्यों बन गया है? क्योंकि डिले से आपके विटनेसेस की मेमोरी फेड हो जाती है, और उनको विन ओवर करना आसान हो जाता है, वो उपलब्ध नहीं हो पाते। इसका प्रेशर किस पे आता है? प्रोसिक्यूशन पे। प्रोसिक्यूशन प्रेशर फील करता है क्योंकि बियॉन्ड रीजनेबल वो डाउट केस को प्रूव नहीं कर पाता। लेकिन ऐसा भी नहीं है कि हमेशा डिफेंस द्वारा ही डिले किया जाता है। कभी कभी प्रोसिक्यूशन द्वारा भी डिले किया जाता है, किसी को फंसाने के लिए या किसी के पर्सनल इंटरेस्ट होते हैं। और कभी कभी ऐसा लगता है कि प्रोसिक्यूशन एक्सप्लॉइटेशन बन गया है। प्रोसिक्यूशन एक्सप्लॉइटेशन ना बन सके, इसके लिए हमें काम करना होगा। बहुत सारे डिले के रीजन बताएं, उनको मैं रिपीट नहीं कर रही हूँ। कुछ ऐसे हैं जो उनसे डिफरेंट हैं, जैसे कॉम्प्लेक्स इन्वेस्टिगेशन। आपके प्रिवेंशन ऑफ करप्शन एक्ट में, NDPS में बहुत कॉम्प्लेक्स इन्वेस्टिगेशन करते हैं, अननेसेसरी एविडेंस कलेक्ट करते हैं जिसको कलेक्ट करने की ज़रूरत नहीं है, उसको डिस्करेज करना चाहिए, उनकी ट्रेनिंग होना चाहिए। पॉक्सो में एज डिटर्मिनेशन के पॉइंट्स बताए गए हैं, लेकिन अभी भी ऑसिफिकेशन टेस्ट होता है। नो कोड ऑफ कंडक्ट फॉर लायर्स। हमारे लिए तो कोड ऑफ कंडक्ट है, लेकिन उनके लिए कोई कोड ऑफ कंडक्ट नहीं है। गवर्नमेंट इज़ नॉट विलिंग टू कम्प्रोमाइज। देयर इज़ टू मच लिटिगेशन फ्रॉम गवर्नमेंट साइड। हम सबसे मीडिएशन कर लेते हैं, लेकिन सिर्फ गवर्नमेंट से मीडिएशन नहीं कर पाते, जबकि उनके लैंड एक्विजिशन के केसेज में सब में मीडिएशन होना चाहिए, पर कहीं से कोई प्रेशर नहीं होता कि वो मीडिएशन के द्वारा वो केस निपट सकें। अभी भी 20-20, 25-25 साल पुराने लैंड एक्विजिशन के केस हमारी कोर्ट में पेंडिंग हैं। ट्रांसफ़र ऑफ जजेस, एब्सेंस ऑफ वर्क कल्चर। ऐसा नहीं है, एब्सेंस ऑफ वर्क कल्चर दोनों तरफ से है। कभी कभी एडवोकेट्स का तैयारी के साथ ना आना, और आपका कुछ कारण ऐसे होते हैं कि जब मैं तो यह कहना गलत है, हमें समझाने में ही पक्षकारों को आधा समय निकल जाता है। कुछ पक्षकार ऐसे आ जाते हैं कि कुछ ऐसे कारण होते हैं, जैसे मान लीजिए दिल्ली रीजन का अगर मालवी, हमारे यहाँ मालवी है, बुंदेलखंडी है, आपकी बघेली है, अगर दिल्ली रीजन के आदमी की मालवी और बघेलखंडी में पोस्टिंग हो जाए तो उसको एविडेंस समझ के लिखाने में जस्ट डबल समय लगता है। तो ये ऐसे रीज़न हैं जो सिर्फ हम समझ सकते हैं। और कभी कभी जो एडवोकेट्स की तरफ से एडजर्नमेंट होता है वो ये होता है कि जो सीनियर एडवोकेट्स हैं वो अपने काम को डिसेंट्रलाइज नहीं करते, वो उनके जूनियर सिर्फ डेट लेने के लिए आते हैं, वो अनुकूल फैसले के लिए सारे प्रयास करते हैं, वो अपने पक्षकार को इम्प्रेस करने के लिए लंबे लंबे आर्ग्यूमेंट करते हैं, वो जोर से बोलकर वर्क एटमॉस्फेयर खराब करते हैं, हम पे प्रेशर जमाना चाहते हैं। लेकिन जहाँ समस्या है वहाँ समाधान है। प्रोसीजरल अमेंडमेंट के अलावा हमें ही काम करना होगा। हमें ऑर्डर 17 रूल 1 और सेक्शन 309 में जब एडजर्नमेंट देते हैं तो हमें ये सोचना होगा कि वो हमारा पर्सनल समय नहीं है, वो कोर्ट का टाइम है। हमें एडजर्नमेंट देने में बिल्कुल लिबरल नहीं होना है। अगर किसी को एडजर्नमेंट चाहिए तो कॉस्ट पे करे। और जजेज की क्वालिटी एफिशिएंसी में भी सुधार होना चाहिए। जुडिशियल एकेडमी और रजिस्ट्री के बीच में कोऑर्डिनेशन होना चाहिए, क्योंकि जैसे मछली है वो पानी में तैर सकती है, लेकिन उससे कहिए कि जंगल में दौड़ लगा दे, नहीं लगा सकती। शेर है, जंगल में दौड़ लगा सकता है लेकिन पानी में नहीं तैर सकता। इसी तरह कुछ जज सिविल बहुत अच्छा कर सकते हैं, कुछ जज क्रिमिनल बहुत अच्छा कर सकते हैं, कुछ जज आईटी के केसेस बहुत अच्छे कर सकते हैं, कुछ प्रिवेंशन ऑफ करप्शन एक्ट बहुत अच्छा कर सकते हैं। तो जो जिसकी चॉइस हो, जो जिसमें एक्सपर्ट हो, उससे वो काम कराना चाहिए। तब निश्चित रूप से पेंडेंसी में फ़र्क पड़ेगा। टेक्नोलॉजी का यूज़ होना चाहिए पूरी तरह से। जब हम टेक्नोलॉजी में आगे बढ़ रहे हैं तो हमें फ़ोन के लिए भी रूल्स बनाना चाहिए कि अगर कोई सिर्फ 2 मिनट के लिए बात करना चाहता है तो उस समय में रूल्स हों, वीसी रूल्स हों। उनके बारे में काफ़ी डिस्कस हो चुका है। नेक्स्ट बहुत इंपॉर्टेंट, कोर्ट्स ऑफ ब्रिटिश कोलंबिया की तरह जो छोटे छोटे तथा समरी विचारण के प्रकरण रहते हैं उनको डॉकेट बना के छोटी कोर्ट्स को देना चाहिए, ताकि बड़ी कोर्ट्स का टाइम इनमें वेस्ट ना हो। और आपका सिंगापुर की तरह आपके आपराधिक प्रकरणों में नियम बनाकर फर्स्ट हियरिंग में ही अपने एक्यूज्ड को और डिफेंडेंट को अपना डिफेंस डिस्क्लोज करना चाहिए। आपकी जो प्री लिटिगेशन नोटिस इशू होना चाहिए और उसी को रूल्स में अमेंडमेंट होना चाहिए कि उनको हम ड्यूली सर्व्ड माने, ताकि जो डॉक्यूमेंट्स देने में और कॉपी देने में हमारा समय लगता है वो हमारा समय ना लगे। फाइलों का ई इंस्पेक्शन पक्षकार कर सकें, इसके लिए वेबसाइट बनानी चाहिए। एट प्रेजेंट में CIS में मोबाइल नंबर भरना बहुत ज़रूरी है, लेकिन हम आज भी देख रहे हैं कि पक्षकार के मोबाइल नंबर नहीं भरते वकील साहब, वो अपना खुद का मोबाइल नंबर भर देते हैं। और इससे क्या होता है कि पक्षकारों का कोर्ट के चक्कर लगाना ज़रूरी हो जाता है। और अंत में मैं यही कहना चाहूँगी कि जिस तरह सिंगापुर में वकीलों को स्वतंत्रता है, कि कोर्ट को स्वतंत्रता है कि वो ऑब्जेक्शन के बिना आगे बढ़ जाएँ, उसी तरह हमारे यहाँ भी स्वतंत्रता होना चाहिए। क्योंकि हमारे यहाँ तो ये है कि सप्तपदी की तरह हमें सारी औपचारिकताओं का पालन करना पड़ता है, हर ऑब्जेक्शन को डिसाइड करना पड़ता है। अगर सिंगापुर की तरह हम ऑब्जेक्शन को डिसाइड ना करें और हम कहेंगे नहीं हम ये नहीं पूछने देंगे और हम आगे बढ़ जाएं, तो हमारा ट्रायल बहुत जल्दी होगा और हमें और आपको स्पीडी ट्रायल करना है। वरना लोग कहेंगे सूरज से बचे तो जुगनू से जल गए थे, सूरज से बचे तो जुगनू से जल गए थे, जिन पर भरोसा किए वही छल गए थे, जिन पर भरोसा किया वही छल गए। थैंक यू।
Thank you, ma'am. I now invite our third speaker, Shri Ashish Kumar Mishra, Principal Judge, Family Court, Narsingpur, to share his views.
Honorable the Chief Justice, Honorable Judges, High Court of Madhya Pradesh, on the dais, respected seniors, brothers and sisters. Almost various issues have been taken up by the earlier speakers. Due to paucity of time, I am directly coming to certain issues and their solutions. First problem being very commonly faced by the trial courts is non-availability of a party, of counsel of a party on the date on which the matter is fixed. We can overcome from this problem if we stop fixing the matter for the next date in a casual manner or through our clerical staff. The Honorable Apex Courts very recently in the month of October 2023 itself, in the matter of Yashpal Jain versus Sushila Devi, has issued certain directions, which include that fixing the date of trial should be in the consultation with the learned advocates appearing for the parties to enable them to adjust their calendar. So while fixing the date of trial, if such kind of process is adopted, the problem of non-availability of the counsel can be minimized. As far as the ground of adjournment by a counsel that he is not prepared with the brief is concerned, this problem can also be curtailed by mentioning the proposed proceedings of the next date in the order sheet and bringing the same into the notice of the concerned parties and their respective counsels. A specific mentioning of names of the witnesses being called for the next date in the order sheet and bringing the same to the notice of the concerned counsels
would eliminate the possibility of adjournment on the ground of non-preparation of a council. Unnecessary adjournment is also has been discussed by speakers in this regard. We should conduct the trial by following the provisions of Section 309 CRPC and Order 17 of CPC. While considering the request of adjournment by any party, we should keep in our mind that every adjournment not only costs adversely on the resources of our country, but also costs one-day livelihood of sole breadwinner of the family who has been made to return without any substantial proceedings just because of an adjournment. If we would deal the prayer of adjournment by keeping aforesaid statutory provisions and factors, certainly we would be in a position to reduce the problem of unnecessary adjournments. Delay in conduct of trial can also be controlled by using certain provisions of procedure law. In CRPC, Section 294 of CRPC and Order 10 of CPC contemplates the provisions of admission denial. If we use these provisions in conduct of trial and any party admits any fact or document or a signature on a document produced by the other party to the list, the same would save the time which would have been spent for proving the said admitted fact or document or signature on a document as the case may be. Adding further, we all are very much aware that Order 10 of CPC provides for examination of parties after completion of pleadings, but usually the said provision is not being used. Rather, after completion of pleadings, generally we proceed to frame issues. If we call the parties to appear in person after completion of pleadings, then we would not only come to know about the actual disputed facts between the parties, enabling us to frame issues properly, but the appearance of parties at this juncture would also make the meaningful use of Section 89, providing the way for alternative dispute resolution. Certainly, many other problems do exist which cause delay in conduct of trial, but being time-restricted discussion, we could only discuss limited issues. In the end, as concluding note, we should keep in our mind that speedy trial is need of hour. A step further, taking note of the dictum of Hon'ble Supreme Court in the matter of Husainara Khatun, when we conduct the trial of an accused who is lodged in jail, being under trial prisoner, we should always keep in our mind that the delay in conduct of trial of under trial prisoner itself causes infringement of his fundamental right of life and liberty enshrined in Article 21 of the Constitution. Speedy trial is necessary not only to fulfill the promise contemplated in the preamble of the Constitution to secure social, economic, and political justice, but also to keep the trust of public at large intact in the dispensation of justice by the courts of law. Thank you very much.
Thank you, sir. I now request Honorable Co-Chair, Honorable Shri Justice Shri Anil Kumar Verma, to give the closing remarks.
सभी वक्ताओं ने अपने विचार बड़े उन्मुक्त रूप से व्यक्त किए और जिसमें से कुछ विचार बहुत उपयोगी हैं। भारतीय न्यायालयों की जो छवि बनी है कि तारीख पे तारीख मिली पर न्याय नहीं मिला, इस छवि को हमें खंडन करना है। बहुत सारे न्यायिक सुधार हो चुके हैं, कुछ और होने बाकी हैं और पिछले एक दशक में तो स्पीडी ट्रायल के मामले में क्रांतिकारी परिवर्तन आए हैं भारतीय न्याय व्यवस्था में और ये परिवर्तन आगे और भी अधिक स्पीड में होंगे और जारी रहेंगे। इसके लिए जैसा हमारे ऑनरेबल चीफ जस्टिस साहब ने कहा कि हमारे भीतर एक जुनून होना चाहिए, जज्बा होना चाहिए कि हमें स्पीडी ट्रायल करना है, वो सबसे ज़रूरी है। व्यवस्थाएं, सिस्टम, ये सब तो आपका साथ हमेशा देगा ही। आप सबके विचारों के लिए धन्यवाद। नमस्कार।
I now request Honorable Chair, Honorable Shri Justice Sanjay Devedi, to give concluding remarks in this session.
स्पीकर्स के विचार सुन के इस बात का बड़ा दुख हुआ कि ऐसा लगा कि हमारी जुडिशरी इतनी कमजोर है। मैडम आई, उन्होंने धारा प्रवाह बोला, आप लोगों ने खूब तालियां बजाई। अधिवक्ता ये करता है, अधिवक्ता वो करता है, एडजमेंट मांगता है। एडजमेंट देता कौन है? एडजमेंट मांगने का प्रोविजन प्रोसीजरल है, देने का कोई प्रोविजन नहीं। आप देते हैं। चीफ जस्टिस साहब ने एक स्कीम लाई कि 25 केसेस डिसाइड करना, ओल्ड केसेस डिसाइड करना। आपने कभी सोचा कि कुछ लोगों ने 25 केस डिसाइड किए, कुछ लोगों ने 23 केस डिसाइड किए, कुछ लोगों ने 6 केस डिसाइड क्यों किए? सभी ने 25 क्यों नहीं किए? सब जजेस बराबर हैं, सबके पास बराबर पावर हैं, तो कोई 5 ही क्यों कर पाया और किसी ने 25 क्यों किए? जज मास्टर ऑफ द कोर्ट है। हम वकील के हिसाब से नहीं चलेंगे, हम अपने हिसाब से चलेंगे, हम प्रोसीजर के हिसाब से चलेंगे। अगर हम सोचेंगे कि ट्रायल जल्दी होगी, हम सोचेंगे कि हम अननेसेसरली किसी को समय नहीं देंगे, तो अपने आप अधिवक्ता आपके हिसाब से कार्य करेगा। ये हर कोर्ट में होता है, हाई कोर्ट में भी होता है। कुछ जजेस एडजमेंट नहीं देते तो वकील उसी हिसाब से आता है। कुछ जजेस लिबरल होते हैं तो एडवोकेट को लगता है कि ठीक है, हम जज साहब के यहाँ जाएंगे, रिक्वेस्ट करेंगे एंड मैटर विल बी एडजर्न। बट इन अ कोर्ट वेयर एडजर्नमेंट इज नॉट ग्रांटेड, counsel has no option but to prepare the case and argue the matter. Go and sit before the court of Chief Justice. Then you will analyze कि counsel has no option but to argue the matter, otherwise case will be dismissed. आप भी लिबरल होना ठीक है, जरूरत है, अननेसेसरली एडजर्नमेंट मत दीजिए। मैं पोर्टफोलियो डिस्ट्रिक्ट में जाता हूं, ऑब्जर्व करता हूं, वहां पे लोग बताते हैं कि साहब हमारे यहाँ 12:30 बजे एडवोकेट्स आते हैं और लगभग कोर्ट का काम 12:30 बजे चालू होता है। क्यों? इसलिए कि हम उस आदत में ढल चुके हैं। जजेस ये देख रहे हैं, सबसे मेन डिले जो होता है, आप ये देखिए कि हर डिस्ट्रिक्ट कोर्ट में लगभग डिस्ट्रिक्ट में 11 बजे काम चालू नहीं होता। एडवोकेट्स आते हैं, लेट आते हैं, अपना टेबल पे आके 10 मिनट 15 मिनट चाय पिएंगे, तम्बाकू खाएंगे, पान खाएंगे, उसके बाद आपके यहाँ से जमादार जाएगा, संबंधित एडवोकेट को बुलाने जाएगा, आते आते 12:30-1 बज जाता है। सरकारी वकील जो होते हैं वो कोर्ट में नहीं आते। अगर एक्यूज का अधिवक्ता नहीं आता है, गवाह आता है, तो आप सरकारी वकील को बुला के गवाही चालू करिए। आपको किसने रोका है? आप देखिए कि जैसे ही आप गवाही चालू करवाना चालू करेंगे, अपने आप ये मैसेज पूरे कोर्ट में जाएगा और एक्यूज जो है वो अपने अधिवक्ता के सर पे नाचेगा और उसके बाद अधिवक्ता को मजबूरी कोर्ट में 11:15 11:30 बजे अपना गवाह को हाजिर करके गवाह कराना पड़ेगा, क्रॉस एग्जामिनेशन करना पड़ेगा। तो हम इतने असहाय क्यों हैं? हम कोर्ट के मास्टर हैं, वी आर बॉस ऑफ द कोर्ट। हम कोर्ट चलाएंगे, हमारे हिसाब से कोर्ट चलेगी। तो इसलिए प्लीज ये दिमाग से निकाल दीजिए, जब एक जज 25 केस डिसाइड कर सकता है तो बाकी क्यों नहीं कर सकते? सब कर सकते हैं, सब सक्षम है, बस जील होनी चाहिए। कोई मैकेनिज्म, कोई सिस्टम, कोई गाइडलाइन काम नहीं करेगी जब तक जज नहीं सोचेगा और जज नहीं काम करेगा। इसलिए आपसे एक रिक्वेस्ट है कि आप अपने आप को इतना असहाय महसूस नहीं करिए। सभी को बराबर के पावर्स हैं, आप अपने पावर एक्सरसाइज करिए और अगर आप तैयार हैं तो लिटिगेंट अपने आप तैयार है, एडवोकेट अपने आप तैयार है, किसी के पास कोई ऑप्शन नहीं। तो मैं आप लोगों से एक बार फिर बोलता हूं, विचार सबके अच्छे। हमारे को ये समस्या है हमारे सामने, हमें समस्या नहीं देखना है, हमें उसका निदान ढूंढना है, हमें उसका सॉल्यूशन चाहिए। तो इसीलिए मैं आप लोगों को पुनः एक बार बोलता हूं कि आप अपने पावर एक्सरसाइज करिए, एडवोकेट के हिसाब से मत चलिए, आप अपने हिसाब से चलिए, और आप देखिए थोड़े दिन बाद एडवोकेट आपके हिसाब से चलने लगेगा। तो इसलिए इस बात को दिमाग से निकाल दीजिए कि कोई क्या बोल रहा है, एडवोकेट आता है लिटिगेट, आप अपना काम करिए। आपको लगता है कि एडजमेंट का रीजन जेन्युइन है तो ही एडजमेंट दीजिए, नहीं तो मत दीजिए। आप प्रोसीड करना चालू करिए मैटर, अपने आप अधिवक्ता एडजमेंट मांगना बंद कर देगा। तो प्लीज ये दिमाग से निकाल दें आप लोग। बार बार आप लोगों को इस बात के, हम लोग हर जगह पोर्टफोलियो में ये नोटिस करते हैं कि ये प्रॉब्लम हर जगह होती है कि देर से काम चालू होता है, एडवोकेट नहीं आते। अरे आप काम करना चालू करेंगे, एडवोकेट अपने आप आने लगे। जबलपुर में हम लोगों ने डिस्ट्रिक्ट कोर्ट में प्रैक्टिस की है, पहले जबलपुर डिस्ट्रिक्ट कोर्ट में भी यही होता था। उस डिस्ट्रिक्ट जजेस आए जिन्होंने 10:30 बजे बैठ के काम करना चालू किया, सिस्टम बदल गया, आज 11 बजे से वहाँ काम चालू हो जाता है। तो हर जगह आप अपने हिसाब से चलाइए। डिस्ट्रिक्ट जजेस टाइम से बैठेंगे तो सब जजेस टाइम से बैठेंगे, सब जजेस टाइम से बैठ के काम चालू करेंगे। आप देखिए आपका काम करने का वर्किंग आवर्स बढ़ेगा, अपने आप एक्सपेडाइट होंगी ट्रायल्स, अपने आप एक्सपेडाइट होंगे केसेस, डिस्पोजल जल्दी होगा। थैंक यू।
Thank you, my lord. With the kind permission of the dais, may I give the vote of thanks? Thank you, my lord. I would like to express my heartfelt gratitude to Honorable Shri Justice Sanjay Dwivedi, Judge, High Court of Madhya Pradesh, who has been kind enough to grace this session and share his insights on the problems in the conduct of trial and discussed various innovative solutions for expediting the trial. Your Lordship's views have deeply enriched our knowledge and will guide us for conducting a speedy trial. Thank you, my lord. I would also like to express my sincere gratitude to Honorable Shri Justice Anil Verma, Judge, High Court of Madhya Pradesh, for gracing this session and for giving various tips to reduce the delay in the conduct of trial. I also express my deepest gratitude to all the panel speakers who have shared their invaluable experience and given various solutions for overcoming the delay in the conduct of trial. With the kind permission of the Honorable Dais, may I declare this session as concluded. Thank you, my lord. This session stands concluded. Moving on to the third technical session. I request Honorable Shri Justice Vishal Dhagat and Honorable Shri Justice Vishal Mishra, Judge, High Court of Madhya Pradesh, to kindly grace the dais. I request Civil Judge Aparna Soni and Civil Judge Sangshikha to kindly escort the honorable dignitaries to the dais. With the kind permission of the dais, may I commence with the session? Thank you, my lord. I request everyone to please maintain silence. Honorable Shri Justice Vishal Dhagat, Honorable Shri Justice Vishal Mishra, Judge, High Court of Madhya Pradesh, respected panel speakers and participant judges, a very good evening to all of you. In this session, I request everyone to please maintain silence. In this session, we have distinguished privilege of having the presence of Honorable Shri Justice Vishal Dhagat, Judge, High Court of Madhya Pradesh, for chairing the session, and the session will be co-chaired by Honorable Shri Justice Vishal Mishra. I welcome my lords in this session. To welcome our dignitaries, I request Shri Bhagwati Prasad Sharma, Principal District Judge, Indore, and Shri Abhilash Kathal, Civil Judge, Junior Division, Indore, to felicitate and welcome Honorable Shri Justice Vishal Dhagat with a bouquet of flowers. Now I request Shri Ramanand Chand, Principal District Judge, Singrauli, and Shri Harshvardhan Rathore, Civil Judge, Junior Division, Singrauli, to kindly felicitate and welcome Honorable Shri Justice Vishal Mishra, Judge, High Court of Madhya Pradesh, with a bouquet. Our panel speakers for the session are Shri Dharmender Singh, Principal District Judge, Katni, Srimati Tripti Sharma, Principal District Judge, Harda, and Shri Dinesh Prasad Mishra, Special Judge, Devas. I welcome all the panel speakers in this session. I request the Honorable Chair to kindly give the opening remarks for this session. My Lord.
Honorable Chief Justice, esteemed brother and sister judges, and all the judges present here today. It is a great challenge today to speak at this hour when most of the thoughts are exhausted and all of the listeners and audience is also exhausted. I have to sum up my topic in 2 or 3 minutes. So I will try to sum up my topic in one word, and court management and your board management is only one thing, and that is timeliness. How you complete your work in a given time, in a given time frame. If you are able to complete your given work in a time frame, then you are successful in your court management and board management. Briefly speaking, court management is being looked after by Apex Court, by Chief Justices, by Principal District Judges, and arrangement is made for infrastructure, for appointment of judges, and you all know that our Chief Justices is bringing 3 new buildings in the High Court, that is court management for future. So one of the participants asked that there must be 5-year plan in courts also. So I will say 5-year plan has already begun in courts. New court buildings are coming. Their new infrastructure is also coming. Finance is also being brought in from the state government. Appointments of judges are being made. We are having High Court judges, and new judges in district judiciary are also being appointed. I will request Chief Justice to also appoint Class 4 and Class 3 employees. We lack in it. There are less stenos. There is paucity of drivers and peons also. So I'll make a request to do it also. And court management and board management is like driving your car with a fast speed, but not to have an accident and reach your target or goal safely. So that is your board management. So while conducting your court, you are required to see that there are no unnecessary adjournments. You can impose cost. If any advocate is filing frivolous application, you have to be strict on limitation, and there are many other things to speak. So I will only speak briefly today, and I will give some time to panelists also to speak, and whatever is left I will cover up in concluding remarks. Thank you. Thank you all.
Thank you, my Lord. I now request the Honorable Co-Chair to give his remarks regarding the session.
Honorable the Chief Justice, esteemed brother and sister judges, judicial officers present in the auditorium, ladies and gentlemen, a very good evening to you all. As already said, that we are over time now. Everyone here in the auditorium is exhausted. Since from morning itself, we are talking about the very topic looking ahead and Vision 2047. lot of thoughts are being shared, problems are being discussed, and even to certain extent solutions have also been discussed. So virtually there is nothing left more to discuss today. But as far as the topic is concerned, that court and board management, as said in the session 2 by Justice Sanjiv, that judges are the masters of their courts. They should be aware of this fact that how to deal with a particular case in a particular manner. They should look into it that how much time will be required for disposal of the particular case itself. Every judge is competent enough to give proper disposal. Working of judiciary has been seen during the COVID pandemic-19, when the whole country was at silent. The judiciary was still functioning, although through alternative modes. Even the scheme of 25 old cases is concerned. Every one of you has given their optimum and has tried to dispose of the maximum cases. As pointed out today, that 56 judicial officers have achieved the target of 100%. Some more than 90%, 95, 85. This shows your competence to do it. There cannot be a roadmap, fixed roadmap, that you have to function in a particular way to achieve the target. Every judge is having a different set of cases before him. Therefore, it is only he who has to decide that how to deal with those cases. He is required to identify those cases, the priorities to be given to which kind of cases, which cases can be disposed of in a very short time, what kind of cases will be requiring more time, and accordingly he should decide how to deal with those cases. Nobody can say that you have to finish these cases in a particular time itself. Even that 25 debt scheme talked about, there was a breathing space given to all the judges also. There were 4 phases. 100 cases were to be decided in a year itself. Therefore, it was for you to identify which cases you have to decide in which phase itself. Some left behind in first phase can be carried to the second phase itself. So it cannot be said that you have to decide this particular case in 3 months, 4 months, 5 months. We are looking ahead for 2047. We are on a way to celebrate 100 years of independence. And as already said, that in 2047, if somebody asks that what the judiciary has done in this 100 years after independence, at least we should be in a position to give a positive answer. The earlier speaker in technical session 2 said that there can be one mode for quick disposal of cases, that is to identify the judges in which topic they are expertise and to give them that particular work itself. As far as I am concerned, I am not agreeable with that proposal or that statement made by the concerning judicial officer. Once you have chosen a profession to be that of a judge, you have gone through thorough examinations, you are being selected as a judge, you cannot say that you are expertise in a particular subject and you should be assigned a particular kind of work itself. Nobody can say this. So you should not think that you cannot do a particular kind of work. That cannot be a thought process. Rather, whatever work is assigned to you, you should be determined to do that work. you should find ways to finish up the matter in the shortest time. We cannot plan a scheme and give the scheme to you for implementation, saying that this is the roadmap for 2047. No. It is you who are the masters of your court has to decide the same. As said, that a plaintiff or a petitioner knows about the fate of the case. The respondent or the defendant is aware of the fate of the case. It is a judge who is always on trial. Therefore, he who has to decide it. Nobody else can decide it. Lot of us talked about the unnecessary delays being caused, adjournments be granted, causing delay in dispensation of justice. I don't say that adjournment should not be granted, but only in genuine cases where genuine reasons are there. I have paucity of time, but I would like to give an example to it. When I was transferred to Jabalpur, I found that huge number of bail applications were piled up and pending. The Honorable Chief Justice assigned a particular roster of bail applications to 3 or 4 judges. I was one of them among them. When I looked into the order sheets, I found that bail application is pending since almost 1.5 years back. What is the reason for that? Half of the adjournments were because the case diaries were not there. Half of the adjournments were there when the lawyer was not agreed to argue. He sought an adjournment and it was granted. Why it is so? If you are able to manage your board, both these problems can be solved very easily. I made an attempt to it, and as on date, I can say that on the first day when this bail application is before me, 95% of case diaries are available before my board itself. Because I don't grant any adjournments in bail applications. File it, argue it, and take a decision on it, this way or that way. So a judge has to learn how to say no to a lawyer also. You have to develop a reputation of your court itself in a way that if a matter is listed before me, for whatever reason it is, for admission itself, or grant of stay, it has to be argued on that day for a particular admission or stay. Unnecessary adjournments should be avoided. That can be one of the key features which you can start implementing from today itself. Does not require any roadmap even to start preparations for 2047 itself. So I sum up by saying that start doing it from today itself. I conclude by saying I am thankful to the Honorable Chief Justice, to the President of the Association for giving an opportunity to me to address this August gathering. Thank you.
Thank you, my lord. As we are running short of time, I request all the panel speakers to please share their views as briefly as possible within 2 to 3 minutes. I now invite our first speaker, Shri Dharmender Singh, Principal District Judge, Katni, to share his views on the topic, Court and Board Management.
Honorable the Chief Justice, Shri Ravi Malimath, Honorable Shri Vishal Dhagat, Judge, High Court of Madhya Pradesh, Honorable Shri Vishal Mishra, Judge, High Court of Madhya Pradesh, and Honorable Judges of the dais and all judicial officers present here. It's a great privilege for me to be here among you all. I would like to say that already sufficient has been said. We must be foremost, and for first duty is that we must be very, very punctual, and our integrity of the dais, on the dais, and after working hour must be of a extraordinary. We should not be judge of 5 10 to 5, or that we say that if after 5 o'clock we are this is private life. We must be very ethical. Once you are ethical on the dais, you can say that you can perform your duties in a very well manner and in integrity is beyond doubt, then certainly your confidence would be extraordinary. And you will able to manage your, that's why I'm saying that unless you are not performing, your lawyers would come to you and they will say that please dispose of my case, and they will surrender you. And Mr. Bhadoria is also there. He may say that, but ultimately it is there. Once you are punctual to your duties and you are coming before the time and you dispose of the administrative work as well as you can do the judicial work at 11 o'clock you start, then certainly your work, half work would be done. My request is that further, so far as Honorable Chief Justice has launched so many softwares, every case is on your list that what is you have to do, what not to do, or aapke paas everything is there just to see that how many cases are on the old cases. I can say that once you are doing your duties in such a manner, I can say when I remain posted in Delhi, also in DRT deputation, I have disposed of 4,600 cases, and I would like to say that 58 lakhs have been got deposited in the repository as a cost on the lawyers, and 80 lakh has been given to the Kerala when there was a disaster there. 80 lakh have been given to that. I started imposing cost. Once you are strict to your principles, then certainly the lawyers would come to you and they will say that we have no objection and your pleadings would be completed. And next I would like to say that whenever file comes to you, you please frame the charges and issue on the same date. Don't urgent. And I am watching that applications are pending, miscellaneous applications are pending which can be disposed of in a single day. You start disposing of all these cases, all these applications, your pleadings must complete in civil cases and criminal, so far criminal cases are concerned. Then if you frame the charges, your trial would start and you would be able to dispose of the cases. And I would also like, because there is a paucity of the time, I would also like to say that the software, CIS software is such a manner it has been crafted that your old cases generally comes on the front side. Do you please watch all these cases and say that you started disposing of these cases on day-to-day basis. Don't urgent the cases. Main function is that we should not urgent the cases and we should be punctual to the duties. And next I would like to say that patience, so far patience is concerned, we must not engage with the consuls. Once we started hot talking with the consuls, then certainly you will start wasting your times. So please don't do this. And another is that you should have a control your own staff. Your staff generally used to wander here and there, and once you are not coming on time, you are not able to dictate your judgments. Once you start coming in the morning, in the early hours, you can dictate the judgment. You give a judgment to his clerk to write it, and you will say that you save the time, and he will not wander here and there. Next, we must be, there are virtual courts are functioning. Virtual courts, we are not giving a message to the public that virtual courts are functioning, and we should come forward to so far secretaries are concerned, legal services authorities are concerned, they should disseminate the information to the remotest area that virtual courts are functioning in each and every district. So far the challans are concerned, these minor cases can be disposed of at the earliest. And so far already I said miscellaneous plea bargaining, we can go for plea bargaining also. And so far as mediation, Honorable Shri Sanjiv Khanna Honorable Judge, Supreme Court of India has already stated during this meeting in session that we should go for mediation and plea bargaining. We should also adopt it. So far as the mediation concerned, half of the cases we were able to dispose of in such a manner. So far as I would also request that petty matters are pending, so far as the compoundable offences are pending before the courts. We should segregate these cases and we can dispose of in such a manner that we should have a Lok Adalat. I can assure from the side of the Katni that we have disposed of 700 claim cases in the this year. 200 cases on each Lok Adalat we have did this, and so far as the litigants have been benefited from that. We can concentrate on the claim cases also. Claim cases, certainly I have also seen that long pendency, as they 3 or 4 years cases are pending before the courts. And we can dispose of by mediation, by Lok Adalats. We can pursue the insurance companies, then we can pursue it like anything, and we can dispose of these cases so that burden of Honorable High Court would also be decreased in this manner. So far e-filing is concerned, we should, this software has been launched by the Honorable Chief Justice, so we can also guide the advocates to have a e-filing system, and e-filing, they should go for e-filing in the district courts also. So far as these 3-4, this virtual justice clock system has also been launched there, and virtual justice clock, we are in real time before the public, so that we can also be very, very visible to all the litigants, and this virtual clock system has made a transparency and accountability to everyone. So I would like, the shortage of time, already message has come. So just I will say that we should have a determined mind. Already said, only Lordship Justice Vishal Mishra has already said that we should be determined, we should have a punctuality, we should have a aim that we have to dispose of the cases in earlier, and we have not to grant adjournments. Honorable Justice has already said this about it. Thank you, so nice of you. Thank you.
Thank you, sir. I now invite our second speaker, Srimati Tripti Sharma, Principal District Judge Harda, to share her views.
My greetings of the day to the honorable dignitaries on and off the dais and all the esteemed fellow judges. I am grateful and indeed very happy to have privilege to share experience on the topic court and board management with my fellow judges. Courts exist to serve the public by delivering timely justice. They are means to an end, and that end is service to the public. But the greatest drawback of the administration of justice in India today is delay. Therefore, to ensure that the court's administration is run effectively and efficiently, essence of requirement is the adoption of systematic managerial approach in dealing with the cases. Going back to the earlier working conditions of the district and taluka courts, we all know earlier all work was done in physical mode and statistical data was being maintained in files and registers. That certainly posed difficulty to we judicial officers in determining the goals and achieving the same. But scenario has now changed due to technological advancement in judicial system in India. Case information system and justice app is the largest digital court management tool gifted by the E-Committee of Honorable Supreme Court of India, empowering the judicial officers of the district and taluka courts for efficient court board management and for speedy administration of justice. With the aid of all law and procedures, tools, techniques, and facilities provided, still the effective control over the system lies within the competency of we, the judges, who are the master of their own court. To carry out the duty of dispensation of justice as wider aspect, board in the courts has to be managed, and in narrow aspect, each case has to be managed according to its own nature. Thus, case management is the integral part of the board management. In the aforesaid backdrop, perhaps the most significant aspect of court craft and court conduct is sound knowledge of law and facts of the cases we are dealing with. To fulfill the prescribed norms and to achieve the goals set for the judicial officers always require effective and efficient court and board management. Judicial officers may adopt the following material techniques for their own court for effective and efficient court and board management. First is punctuality, which has been spoken by all the speakers and the Honorable the Chair. Prior preparation of the cases fixed for the date, preparing one schedule for listing the case, which will help us to exhaust the cause list. One should give priority for deciding the case as per the seriousness, to list as much cases as can be taken on board effectively, strict control in granting adjournments and rescheduling of its own cause list, maximum use of video conferencing, the motivation of parties to resolve their disputes by ADR mechanism, and one has to be vigilant in process of updating data in CIS so that the accuracy of data is maintained. Last but not the least is time management. For that purpose, working hours of the day may also be suitably divided in different types of work. Proper implementation of procedural law is an attack on the causes on reasons for delays. Pronouncement of the Apex Court in common cause case, Salem Advocate Bar Association and Kailash versus Nanku has clearly sent a judicial message that provisions of law are not to be applied in their letter but in their spirit. Further, technical defects like unsigned pleadings, illegible documents, incorrect court fees, etc. can be detected at the very beginning of the trial. We can be very strict without being rude. A message should go to the members of the bar that while reasonable accommodation shall be provided to them, but they would not be allowed to linger on the cases and adjournment shall not be granted for mere asking. It hardly needs any emphasis to say that one should be aware of latest statutes and their provisions and also be aware of the standard textbooks. That will certainly be helpful in deciding the objections and boosting our own confidence to control the court. It may also be added that the conduct of a judge in the court should be pleasant and cheerful, but one should be reticent in making observations. Any loose, casual, and out-of-context observation may lead to unnecessary embarrassment, which is not complimentary of the dignity of the judge. With the paucity of the time, I would like to conclude by saying that I have shared some few thoughts I have gathered from the experiences and guidances received from my seniors. I hope our junior members of the fraternity will be guided, benefited. I again thank Honorable the Chief Justice and all dignitaries adorning the dais and the chair for giving me this opportunity. Thank you all for giving me this patient hearing.
Thank you, ma'am. I now invite our third speaker, Shri Dinesh Prasad Mishra, Special Judge Devas, to share his views.
Honorable the Chief Justice, Honorable the Judges of High Court, on the dais, off the dais, sister and brother judges. कोर्ट एंड बोर्ड मैनेजमेंट की जब मैं बात करता हूँ, सबसे पहले तो मैं ये कहूँगा कि चूँकि समय सीमा में बांधा गया है तो मैं केवल टू द पॉइंट बात करूँगा। न्यायालय में लंबित प्रकरणों की संख्या को कम करने के लिए सबसे पहले ये ज़रूरी है कि न्यायालयीन कार्य को इस तरीके से नियत किया जाए कि हमारे न्यायाधीश, हमारे न्यायिक अधिकारीगण जितनी मेहनत कर रहे हैं उतनी मेहनत में अधिक से अधिक अच्छे रिजल्ट्स प्राप्त हो सके। प्रश्न यह है कि न्यायिक प्रबंधन या कोर्ट मैनेजमेंट और बोर्ड मैनेजमेंट है क्या? तो कोर्ट मैनेजमेंट को जब मैं मोटे तौर पे देखता हूँ तो उसका अर्थ साधारण शब्दों में केवल यह है कि प्रतिदिन के लिए न्यायालयीन और प्रशासकीय कार्य इस प्रकार से नियत किया जावे कि नियत किया गया कार्य उसी दिन अपवादिक परिस्थितियों को छोड़ के पक्षकारों से कराया जावे, कर्मचारियों से कराया जावे और न्यायाधीश द्वारा स्वयं संपादित किया जावे। Means court management is inclusive of entire set of action that a court takes to monitor and control the process of cases from initiation of a case to trial. It is the tool to pursue the institutional mission of resolving dispute with due process and in due time. महत्वपूर्ण यह है कि यह न्यायाधीश का दायित्व है कि उसके न्यायालय का कार्य सुचारू रूप से संचालित हो, इसलिए न्यायालयीन प्रबंधन की संपूर्ण जिम्मेदारी न्यायाधीश की होती है। और जब हम न्यायाधीश की बात कोर्ट मैनेजमेंट की बात करते हैं तो इसके अंतर्गत केस मैनेजमेंट भी आता है, और मेरे व्यक्तिगत मत में केस मैनेजमेंट एक तरीके से बोर्ड मैनेजमेंट ही है। मैं उन चीज़ों को नहीं दोहराऊंगा। न्यायालय में कार्य करते हुए मेरा अपना अनुभव ये रहा है कि यदि हम 5 चीज़ों को अपना लें तो हमारा कोर्ट मैनेजमेंट और बोर्ड मैनेजमेंट बहुत प्रॉपर होगा। पहला, सबसे पहले तो हमें जुडिशियल एथिक्स को प्रैक्टिस में लाना पड़ेगा। जुडिशियल एथिक्स को प्रैक्टिस में लाना इसलिए ज़रूरी है क्योंकि एथिकल वैल्यूज आर एक्सट्रीमली वाइटल फॉर ऑल जुडिशियल ऑफिसर्स। हमें बोर्ड में बैठते समय कोर्ट में अपना टेम्पर लूज नहीं करना है। पंक्चुअलिटी की बहुत सारी बात कही गई, मैं केवल इतना जोड़ूंगा कि जब हमारा न्यायाधीश समय पर न्यायालय में उपस्थित होता है, समय पर अपना कार्य करता है, तो उससे जुड़े हुए जितने भी लोग होते हैं, चाहे वो कोर्ट के कर्मचारी हों, पक्षकार हों, वो सब समय पर उपस्थित होते हैं। और जैसा कि ऑनरेबल जस्टिस संजय द्विवेदी साहब ने कहा कि यदि हम पंक्चुअल हैं तो कोर्ट हमसे चलती है, कोर्ट किसी दूसरे से नहीं चलती। तीसरी बात, इसमें और बहुत सारी बातें हैं। कंटिन्यूअस लर्निंग होना चाहिए। हमारे जजमेंट, आवर जजमेंट मस्ट बी क्लियर एंड डिसाइसिव एंड फ्री फ्रॉम एम्बिग्यूटी एंड शुड नॉट जनरेट फर्दर लिटिगेशन एंड डिमांड ऑफ क्लैरिफिकेशन। इसके बाद बिहेवियर की बात आती है। बिहेवियर ऑफ द जज इन द कोर्ट इज द मोस्ट इंपॉर्टेंट आस्पेक्ट इन द कोर्ट मैनेजमेंट। वी हैव 5 सेगमेंट ऑफ पीपुल इन द कोर्ट एंड बिहेव विथ। इसके बाद हमको इसके मानवीय पहलू को भी ध्यान में देना पड़ेगा। मानवीय पहलू के साथ ई कोर्स प्रोजेक्ट्स जो हैं, CIS की बात कही गई, NJDG की बात कही गई, हम वहाँ नहीं जा रहे हैं। एक चीज़ छूट गई है। वन ऑफ द मेन काज ऑफ डिले इन द disposing of cases in subordinate court is bottlenecks that occur in different stages of trial such as issuance and delivery of court process। इसके लिए हमको N स्टेप का यूज़ करने के लिए अपने कर्मचारियों को इनकरेज करना होगा। लास्ट में मैं केवल ये कहूँगा, संस्कृत के एक सूत्र वाक्य से मैं अपनी बात समाप्त करूँगा कि अप्राप्यम नाम नेहस्ति, अप्राप्यम नाम नेहस्ति धीरस्य व्यवसायिन। There is nothing unattainable to the one who has courage and who works hard। जिसमें धीरज है, जो मेहनत करता है, उसके लिए कोई चीज़ अप्राप्य नहीं है। जय हिंद, थैंक्स।
Sir, I request the Honorable Chair to kindly give the concluding remarks.
I'll just quickly give the bullet points which has been said by most of the speakers. One is punctuality, integrity, hearing of cases on priority. You must decide your priority, किस केस को पहले सुनना है और कितना टाइम देना है. Adjournment in exceptional circumstances. Minor cases is to be decided quickly. There are virtual cases also, challans are also being filed, they are to be decided quickly. Use of plea of bargaining and alternate dispute resolution is to be resorted to. Curb delay, every judge should try to curb the delays. Judges is master of the court, they should decide how they have to proceed. Prior preparations, this is must. Two more points I will like to add up. Whenever a case is fixed up for charge, you must ask advocates to give synopsis, so that advocate is also ready with the case and government advocate is also ready, and court is also aware what is the case before him and what is the evidence to be given, so that there can be fast disposal of cases. Friendly court, this is also very important. You must be friendly with the lawyers, with the litigants, and there should not be unnecessary arguments or losing of temper in court. This is necessary for your board management. Fixing time schedule is again very important. You should fix time schedule of each case. Ethics to be kept in mind. Whenever you sit on board, you must keep ethics on the back of your mind. Judge should be up to date with law and with recent judgments. And one more important point which has been said by last speaker is N step. There are major delays in cases due to delay in service of processes. we see that 4 months, 6 months is taken for service of notices. So we must utilize this N step, utilize all resources which are available to you, including computers, IT, your staff, police forces for your doing your cases. And conference is arranged to give you an idea, to give a kick of an idea into your mind so that you can work according to it. And what I gained today from the conference is idea of 1 plus free. We should make our state 1 plus free. There should be no case pending in any courts for more than 1 year. That should be our vision for 2047. And 2 more points I want to say. Judges are not using order 10 of CPC. They must use order 10 of CPC frequently. And 2 more ideas which I have gained. Justice Sanjiv Khanna, I had a chance to talk with him in the morning, and he was telling me that in Delhi High Courts, whenever charge sheet is being filed, then government prosecutors and APPs were asked to give their comments on the charge sheet. And after writing their comments on the charge sheet, they asked the IOs, investigating officers, to answer it. And once investigation officer answers it, he knows what are the defects in the charge sheet, and that lacunas can be filled up either before filing of final charge sheet or by filing of supplementary charge sheet, so that case will proceed quickly and all evidence will be adduced. One more idea I got while going through an internet, that is an idea that there must be 2 intermediate conferences after plaint and defense is filed, and in that intermediate conference the judge should decide that what is the time frame in which the case is to be decided, and number 2, each month he should review it, that whether he is in the timeline or not. That's all. Thank you. Thank you to all.
Thank you, my lord. With the kind permission of the dais, may I give the vote of thanks? Thank you, my lord. At the outset, I would like to extend my heartfelt gratitude to Honorable Shri Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh, under whose guidance this conference has been organized. In the entire day, there has been a lot of sharing of knowledge, and I'm sure all the participants have benefited from this conference to a great extent. I would also like to express my heartfelt gratitude to Honorable Shri Justice Vishal Dhagat, Judge, High Court of Madhya Pradesh, Honorable Shri Justice Vishal Mishra, Judge, High Court of Madhya Pradesh, who has been kind enough to grace this session and share their insights on court and board management. Your wisdom and expertise has deeply enriched us and will be a guiding source for all the participants in a better board management. I express my deepest gratitude to all the panel speakers whose invaluable deliberations have given different dimensions for a proper and better board management. Last but not the least, I would like to express my heartfelt gratitude to all the organizers of this event for their unstinting support, and to all of you for for your patience. With the kind permission of the Honorable Dais, may I declare this session as concluded? Thank you, my lord. This session stands concluded. There's an announcement by respected Registrar General, sir. So I request everyone to remain seated. I now invite Shri Manoj Srivastav, Registrar General, High Court of Madhya Pradesh, on the dais.
My Lord Honorable the Chief Justice, Honorable Judges of this Honorable Court, respected dignitaries, judicial officers, I would like to mention that earlier culture program was scheduled for 8 p.m. but it has been changed, and now it will start from 8:30 p.m. Honorable Supreme Court judges also attending the program, so all judicial officers are requested to be present here at 8:25 p.m. Since 1 hour is left, therefore may I also request them to stay here, have their tea and coffee and snacks, and be seated in their seats at 8:25. One more thing. Please ensure that no seats are lying vacant. So please be seated in that way only. Thank you, all of you.